possession was not taken andre idagide anta nenne ನಾನು ಮೂವ್ ಮಾಡಿದ್ದೀನಿ ಮೂವ್ ಮಾಡಿದ್ದೀನಿ possession was taken much prior to passing of order by this
it's taken much prior.
That's what I told and I moved. Yesterday I have moved my land. Monday is the day.
Come. Monday date koಟ್ಟಿರುವ Monday.
My lord, the date given matter for today, my lord. In a tender matter, your lordship had granted an interim order that was obtained by the petitions through suppression of facts. If you're finding it difficult to comply with the lordship's order, we'd like to point out why they have obtained that interim order for your lordship. I'm seeking for today at 2:30.
Give the memo.
At 2:30, my lord.
Not at all at 2:30. Please ಕೊಡಿ. ಮೆಮೋ ಕೊಡ್ತೀರಾ ಬೇಡವಾ ಕೊಡಿ ಬರುತ್ತೆ not tomorrow is CMP day.
Consider directed me to vacate the property.
Come. ಏನ್ ಮೆಡಿಕಲ್ ಎಮರ್ಜೆನ್ಸಿ ನಾಳೆ ತಗೊಳ್ಳಿ tomorrow. Serve a copy on the learned AG.
That's one submission. Its appointment of administrator to conduct the election was called in question before this court. And this court has not granted me interim order. However, court has directed the state where I made a submission that we are going to conduct the election. For that reason, my lords has directed the state to secure inspection. Last week, my lords was this day, but it didn't reach. Next date is on 26/11, my lords. Can I request for preponement?
That's the shortest date available. You're lucky to have got 26/11.
Wait.
Third. Adjournments. List number 1, page number 7, serial number 40 to 44.
My lords, if I may, my lords, serial number 7.
Wait, please.
Page number 8, serial number 45 to 49.
Serial number 49, my lord. Appearing for respondent number 1 and 2.
I appear for respondent number 3, my lord.
Mainly pray for
I
2
informed the
weeks
other
time.
side also, my lordship.
Respondent
Number 3, my lordship. I informed the other side.
Petitioner has no objection.
No objection, my lordship. Here, inform, my lord.
Shri P.D. Surana has entered appearance for respondent number 1 and 2. Delete H.R. Renuka as that appearing for respondent number 1 and 2. The counsels for respondent number 1 to 3 seeks for and are granted 2 weeks time to file their respective statement of objection. Objections, if any, by 5th December, relist on 11th December.
My lord, serial number 46, my lord.
46.
Yes. There is some inconvenience, my lord. Kindly have it after. I am for the petition.
Have you informed the respondent?
Yes, my lord.
At the request of counsel for the petitioner, relist on 9th December.
Page number 9, serial number 50 to 56. Page number 10, serial number 57 to 59. Page number 11, serial number 60 to 62. Page number 12, serial number 63 to 67. Page number 13, serial number 68 to
My
74.
lords, for serial number 68, I'm for the petitioner, my lord, seeking for an adjournment. of 2
68.
weeks. Yes, my lord.
Have you
Other
informed
side
the
have
respondent?
informed, my lord. Yes, my lord.
68 at the request of counsel for the petitioner, relist on 9th December.
List number 1,
My lord, submission, my lord. Serial number 94, my lord. I have filed memo for withdrawal.
Present, it is
Process fee ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಇನ್ನ.
order is already passed.
Process fee ಕೊಟ್ಟಿಲ್ಲಲ್ಲ.
80, my lord.
R3 ಯಾರು process fee ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ. You not paid the process fee.
So it's already order is for clubbing of.
Who are you for?
I am for the KEDB.
ಅದಕ್ಕೆ problem. Petitioner has to pay a process fee. Who is respondent number 3?
I have not.
Then wait till the matter reaches.
My lord, serial number 7. 24, my lord, the lordship stand indulgence with matter 4. The matter, my lord, wherein work order has already been issued, my lord. It's come upon maintainability, my lord. Connected matters have been heard before.
If it reaches, we'll take it up. No exception for anybody.
My lord, serial number 190. We filed the memo for withdrawal.
119 memo for withdrawal, dismissed as withdrawal.
My lord, serial number 7.
You're in such a hurry for 7.
My lords, the counsel for the petitioners, my lords, he's scheduled for an angioplasty. My lord.
Just a moment, wait, let's see what it is. So we'll order notice at least.
list number
What
1,
happened, Prajwal?
serial number
Night,
1.
madam.
Happy for the third respondent, my lords.
It appears that petitioners have gone in the afternoon.
Hmm.
Now they say that as soon as it is ready, they will send it to me. Lordships may kindly.
Yesterday afternoon they have gone.
They have gone yesterday, and my instructions are that, my lord, they have asked me to mention lot of emergency cases are there in hospital. So, as soon as the report is made available, I'll move the matter, my lord.
Today afternoon
Kalstar,
or
11 o'clock anta helidare.
Passover?
Please,
It's called at 2:30, my lord.
2:30.
please.
Fresh matter, serial number 2.
Appearance for
I'm
respondent
appearing
number
for
2 and 3, my lord. Kindly passed over the matter, my lord.
My lord, identical matter is, my lord, is disposed on 27th October 2025. It's only seeking for mandamus.
Mandamus to consider. Not this.
May permit me to place this order, my lord.
My lord, we argue the matter, my lord. Kindly passed over, my lord.
Consider the approval and do it.
It has to argue. this
Madam,
matter.
you can't be, in the morning session, you can't be saying Passover. Your colleague has to be here. ನೀವು ಎಲ್ಲ ಮ್ಯಾಟ್ರಲ್ಲೂ ಬರ್ತೀರಾ Passover ಅಂತೀರಾ. You can't be doing that. Either you get ready
Number 1 ನಲ್ಲಿ
or ask your colleague to be present. These kind of matters, if we keep on passing over, there's no point. At least get instructions. Bari mandamus to consider their representation.
Already
ಅದಕ್ಕೂ
one
Passover
matter is
ಅಂದ್ರೆ.
disposed.
And AGA accepts notice for respond number 1. HL Pradeep Kumar,
Already filed a
who has
wakalat.
filed wakalatnama before notice. Wakalatnama ಹಾಕಿದ್ರ instruction ಇಲ್ಲ. What is
ಕಲತ್
this?
ಬಂದಿರುತ್ತೆ ಸರ್ ನಿಮ್ಮ ಬೋರ್ಡಿಂದ.
Accepts notice for respond, who has filed wakalatnama accepts notice for respond number 2 and 3. AGA for 1, 4 and 5. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that despite the approval of respond number 5, district level single window clearance committee, the respond number 2 and 3 have not allotted a plot, and as such a representation had been submitted on 3/8/2024, and despite long lapse of time, the respondents have not acted on the representation. Whenever the district level single window agency were to approve any project, it is but required for the KIDB to consider the same and allot the plot in the area where it has been recommended, and if plots are not available in that particular area, to allot the same in a nearby area where available. The approval of the single window agency having been passed on 9/2/2024, representation of the petitioner having been submitted on 3/8/2024, the respondents 2 and 3 have not done anything. In that view of the matter, I pass the following order. Writ petition allowed, a mandamus is issued directing respond number 2 and 3 to act on the approval of the state level single window agency dated 9/2/2024 and the representation dated 3/8/2024 of the petitioner within 4 weeks from the date of receipt, a copy of this order. If action is not taken,
2 months, sir. 8 weeks. my lord.
4 weeks.
Much of.
Serial number 3. From SS.
Lords, I appear for petitioner.
Yes.
Annexure B is challenged. Lord, is a complaint filed by respondent 5 before civil rights enforcement. Lord, this complaint is already been stayed. Writ petition number 29970 of 25.
Give us the order copy.
The petitioner was not in the party.
Give us the order copy.
Please, Lord.
That may make.
How do we make out that that matter and this matter are the same?
Lords, it's a dispute between landlord and tenant, my lord. The complainant, my lord, is a landlord. It's an advocate of landlord.
How do we make out that this complaint and what is being stated is the same? There's no proceeding number.
Lord, the present petitioner is, my lord, as an employee of that tenant.
You are asking for quashing the complaint. There's no,
Complaint.
it's not even been registered.
Complaint, Lord.
Lord,
It's a
it's-
premature writ petition.
It's not even been registered.
Lord, it's before Civil Rights Enforcement Department, my lord.
They'll do an inquiry
no
and
note.
see if there is to be registered.
No, what has happened, my lord, there is no notice served on me, my lord, but
They'll
still,
issue
my
a
lord, I have
notice
been-
when required, not
I have been
now.
called to the station, my lord, I have been called to the cell every now and then, and my lord, I have been harassed, my lord.
Mr. Counsel, there's a complaint filed, they'll investigate, they'll decide whether to register it or not. You can't come for quashing the complaint, human rights violation.
It's a counter blast, my lord. I have filed a
And
complaint. my
AG
lord.
accepts notice for respond number 1 to 4. Notice to respond number 5 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. What is essentially being sought for is to quash a complaint filed by respond number 5 with the respond number 3, respond number 4 as regards certain human rights violation. Respond number 3 is still to register any proceedings in pursuance of said complaint, which would be registered only upon a preliminary investigation being made. In that view of the matter, I am of the considered opinion that the petition is premature. The petitioner is reserved liberty to approach this court if any proceedings are registered.
Serial number 4, Chandan Gowda party.
Let's appearing for the petitioner in this matter, my lords. We are seeking mandamus to consider our representation to permit us to allow and operate the bank accounts of the deceased husband, my lords. What has happened is here is, my lords, the petitioner, after the death of the husband, my lords, the petitioner and the mother-in-law of the petitioner approached the trial court, my lords, and subsequently they have secured the succession certificate. After that, my lords, the mother-in-law passes away. And now the bank is insisting upon fresh succession certificate. My lords.
So that was a joint succession certificate.
Please, my lords.
SBI Arama,
SBI Vignesh Shetty,
Vignesh Shetty for respond number 1, Karnataka Bank,
Divya Purandar,
Canara Bank
HS Rukoji Rao.
also.
My lords.
Counsel for the petition furnished 2 sets of the petition along with annexes on the said counsels relist on 26th November.
Grateful.
Serial number 5, Prashant P.
For the petitioner, my lord.
Yes.
Lord, I'm seeking implementation of the execution orders passed by the respondent number 1, directing
P1.
under RERA, my lord. Directing respondent
And
number
AG
2.
accepts notice for respond number 1 and 2. Notice to respond number 3 is dispensed with since the reliefs are sought for only against respond number 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the recovery certificate issued by RERA under section 14 of the RERA Act for recovery of the amounts so directed by as arrears of land revenue has not been considered and no orders has been passed by respond number 2. Whenever any recovery certificate is issued, it would be duty of the jurisdictional deputy commissioner and or the tahsildar to act on the same and recover the amounts as arrears of land revenue as expeditiously as possible. There's nothing having been done, I pass the following order. Writ petition allowed, a mandamus is issued directing respond number 2 to act on the what is the annexure?
Annexure G, my lord. Page 66.
66.
The act on the recovery certificate dated 24/5/2024 at annexure G and recover the monies subject matter of the recovery certificate as expeditiously as possible, preferably within a period of 8 weeks from the date of receipt of a copy of this order. Petitioner is at liberty to furnish the details of the properties owned by respond number 3 to respond number 2,
Grateful, my lord.
along with accompanying documents, supporting documents.
Serial number 6, KS Ravi Kumar, party in person.
Permission ಆಗಿದೆಯಾ? IA 1 of 25 has been filed by the petitioner party in person to appear as a party in person. Registry is directed to place the same before the party in person.
No, I have appeared, Form C has been issued.
It's not there before us.
No, it is there in the file, I've seen that.
In which matters?
ಇದೆಯಾ? C not issued.
ಅಲ್ಲ ನಾನು objections comply ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾನು ನೋಡಿದ್ದೀನಿ, it was there.
ನೋಡಿ ಇವಾಗ.
ಬೇರೆ
ನೋಡಿ ಇಲ್ಲ ಅಂತ ಇದ್ರೆ ನೀವು ಕೇಳಲ್ಲ ಅಂತಿರಲ್ಲ.
ಸೋಮವಾರ ನಾನು I will get it confirmed.
Yes, place it before so and so. ಅದಕ್ಕೆ IA 1 put up ಆಗಿದೆ. Form C
I have
they would
received the
mentioned.
email last week to appear before the party in person committee. I have appeared.
Still not been issued, Mr. Ravi
No,
Kumar.
it has not been put into the file, probably. I will get it confirmed on Monday kindly.
If you are going to be arguing on this, you are not going to be a fit enough person to represent yourself. If you don't know the procedure, that IA is still put up for reference by this court. There is no certificate which has been issued. Place it before the party in person committee for doing the needful. Next.
It has been, I have the email wherein I have appeared.
We'll get a report from the committee.
Seven.
7.
I'm a proxy counsel appearing on behalf of the petitioner counsel. My lords. The counsel on record has undergone an angioplasty. So if my lords can kindly adjourn the matter, please, my lords.
And AGA accepts notice for respondent number 1 to 4. She seeks for and is granted 2 weeks time to obtain instruction and make a submission. Department inquiry.
My lords, it's convenient on 2nd of December, please, my lords. If it's convenient.
2nd of
Grateful,
December.
Grateful, my lords.
Serial number 8. Vishwas.
Appearing for the petitioner, Your Lordship.
I am for the proxy counsel for the respondent number 2 and 3, my lordship. Kindly pass out, my lordship.
Huh?
For respondent number 3, I am proxy counsel for.
Yaudrellappa?
For serial number 8, my lordship. For passport.
Reshma Keti.
Yes, my lordship.
You are appearing for Reshma.
Yes, my lordship. Kindly pass out, my lordship.
Pass out.
Serial number 9. SV Jogara.
Your Lordship, appearing for the petitioners in this case.
Yes, Mr.
Petitioner's son was suffering from congenital scoliosis. That is a hump on the backside of the and
Just in the spine.
Yes. Accordingly, he underwent operation in a particular hospital. Respondents 2 to 6. And during the operation, he suffered paralysis, and accordingly the implanted rods and other things have been removed next day. And as a result of paralysis, down abdomen under, there was no bowel control and other. As a consequence, they filed a case before State Commission. It went before the National Commission. It is pending now. Again, a filed application, complaint before the KMC. KMC, in its impugned order, Your Lordship, page number 30 of the memorandum, there are one paragraph particularly, the operational process and follow-up has been found to be normal. As such, the team of specialist doctors have done their job competently and reasonably good. With that sentence, they have exonerated all the doctors, and that impugned order is being challenged.
Very difficult operation. It's a congenital thoracolumbar scoliosis.
Scoliosis. Yes.
Involving the spine.
Yes.
They have seen that the operation which has been conducted is as per the usual practice, and they have got advice and opinion from the other doctors.
Your Lordship, in the proceedings, what we have witnessed is, we have introduced medical literature in terms of the failure as to diagnosis and the failure of not implementing the gadgets. For example, neuro monitor is required to be followed during the surgery, so that if any complication, they get to know and immediately they act upon it. But they realize the complication next day, morning 9 o'clock. As a result, the medical literature very clearly brings out the negligence on the part of the doctors.
You have placed everything here?
Yes, Your Lord.
Where is that?
Medical literature part you are asking.
As regards that particular device not being used?
Your Lordship. In the memorandum, page 15.
50.
No, 15.
The petition.
Petition.
Yes.
Paragraph 28. No evidence by the respondent numbers 2 to 6 of usage of neuro gadgets and monitors. The petitioner submitted the respondents 2 to 6 failed to utilize any neuro gadget or monitor while conducting the surgery. It is significant to note that had the neuro gadget or monitor had been used, the said respondents could have very well detected the complication of paraplegia at the right time and initiated the requisite measures. In other words, the usage of the neuro gadget monitor could have preempted the delayed detection of complication of the next day morning at 9 a.m.
Neuro gadgets were available. KMC Arama,
Ratna Shivayogimat.
Ratna Shiogimat for respond number 1. Issue notice to respond number 2 to 5. Returnable by 15th December. Kim sir,
GB Sharat Gowda.
GB Sharat Gowda for respond number 6. Great. Counsel for the petitioner to furnish 2 sets of the petition along with annexures to the said counsels.
Serial number 10.
My lords, I appear for the petitioner in the instant writ petition.
Yes.
It is filed by the home buyer being aggrieved by the failure of the bank to act in terms of the trust.
Yesterday there was a very strong submission which was made that you are obtaining orders here and going before the RERA after that.
No, my lords, I am categorically submitting on record that the petitioner in this case has not approached RERA till date.
Yeah, and you will not approach RERA after this.
My lords, yes, my lords, we will not approach RERA. My lords, because my relief is against the respondent number 6.
The other question, Adarsh, yesterday he made a categorical submission and he is going to give us a list.
Please,
if
my
we
lords,
find that list,
yes,
and
my
if
lords.
those matters are there, we'll be taking serious action on that.
Please, my lords, please.
So also accept notice for respond number 1 and 2. Pradeep Saukar for respond number 3. Sukanya Baliga for respond number 4. TransUnion error.
So Velanki Ravi.
Velanki Ravi for respond number 5. Central Bank of India.
MS Venugopal.
MS Venugopal. Ozone projects.
Vandana PL.
Vandana PL for respond number 7. The submission of learned counsel for the petitioner is that the petitioners have not approached RERA and do not intend to approach RERA. In that view of the matter, the respondents are restrained from recovering any EMI amount from the petitioner till the next date of hearing. Connect with so and so and relist on
26/11.
26/11.
11. Srinivasa Gowda.
Yesterday,
So,
mandamus malad. Yesterday matter was disposed of, same matter.
Yavudu yesterday, yavudu? Same matter.
Today, yes,
Same.
my lord.
Empowered committee. And AGA accepts notice for respond number 1 and 2. Shri Shanti Bhushan, DSGA is directed to accept notice for respond number 3. Then a number another? Number, same order.
12. PS Jagdish.
Limitation.
Please, madam, limitation.
Issue notice to respondents returnable by 8 December. Though the proceeding in MVC number so and so shall go on, the so and so court is restrained from passing final award till the next date of hearing.
13. Sharat Jayam.
I am for petition, my lord. Seeking the parole, my lord.
Parole.
Yes, my lord.
And AGA accepts notice for response. She seeks
On
for
request, my lord. This matter may be taken up on 8th, my lord.
8th.
Yes.
4th alla ila.
4th day, I have some personal inconvenience.
Baratta illa ನೀವು 4th. 4th alla 8th ಗೆ ಹೋಗ್ಬೇಕಾ?
Yes.
A list ಕೊಡಿ so that we.
I'll give the list. I'll give the numbers.
8th is what?
Monday, my lord.
Monday.
Any other date, my lord?
One ನಿಮಿಷ.
4th, 5th, inconvenient.
Correct, no? Can we have all of them on 1st December?
Please, my lord.
So list ಕೊಟ್ಬಿಡಿ. We'll have it on 1st December.
Yes, my lord.
For released on 1st December. ಅದು ಹೇಳ್ಬಿಡಿ ಅದೆಲ್ಲ 1st December at 2:30.
14.
Lords, this is a matter of GST reimbursement, my lords. Matter of GST reimbursement, petition is before this honorable court to grant a differential GST amount, my lords. Has to be given by the department. In identical matters, my lords, the petition has been allowed.
HNFWDEW ಅಂದ್ರೆ ಏನಪ್ಪ?
Please, my lords.
HNFWDEW. Which department?
Health and family welfare. Health and family welfare department.
Family welfare.
Please, my lords. In identical matters, they are disposed of, my lords, allowed.
And AGA accepts notice for respond number 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that when the work order had been issued, he did not contemplate payment of GST. However, with the onset of the GST regime, the petitioner was required to make payment of the GST. And as such, the same being recoverable from the employer, the respond number 2 is required to make payment of the reimburse the GST amount which has been paid by the petitioner. There cannot be any dispute as regards the contention of the petitioner inasmuch as GST having been paid. If the petitioner were to furnish all the relevant documents regarding payment of the GST amounts, it would be required for respond number 2 to reimburse the same. In that view of the matter, I pass the following. Writ petition is allowed, a mandamus is issued, permitting the petitioner to submit all documents.
We already submitted. It's at Annexure B. Annexure B, my lords, page number 18. The representation is already submitted.
It's not the representation. You'll have to give the payment challenge.
Please, my lords, we'll give.
We saw that. That's why we are saying.
Please, my lords.
Permitting the petitioner to furnish the payment challenge of the GST amount to the respond number 2 within 15 days from today. Respond number 2 is directed to consider the same and pass necessary orders within 30 days of the receipt of the said payment challenge.
Regarding necessary orders, my lords, in the similar case, my lords, the orders are passed like this. My lords. This point is directed to reimburse GST amount as indicated in the representation dated as per annexure.
And sir, consider and pass necessary orders on the basis of the payment challenge produced by the petitioners. You have to give them the challenge.
What has happened in similar cases, my lords? I'll just produce the.
We know that, but if you don't give them the challenge, they can't account for it.
But they'll pass necessary orders saying that we'll not give the GST.
They'll give as per the challenge. You give them the challenge of payment.
Please.
Your statement, once you give the challenge with the number.
Please, my lords.
That number they'll have to account for in their records. Then the Accountant General will not raise the objection. If you give this representation like this, they can't correlate the amounts because they can claim credit for the GST amount.
Please, my lords. But my lords, they may pass necessary orders saying that the petition is not eligible because, my lords, in the identical case, my lords, what has happened is it is orders are passed like this, my lords, just for your consideration. My lords. The respondent are directed to reimburse GST amount as indicated in the representation dated so and so as per annexure so and so, my lords. The respondent department shall reimburse the said amount within a period of 6 weeks. In the similar case, my lords, the same department. The same case, my lords, I'll just produce the.
That is why we are saying give the challan.
Please, we'll produce the channel, my lords.
15. Prakash MS.
Yes.
Petition is for the writ of mandamus to dispose of the annexure A.
Representation. What is your representation?
Representation to give protection to the petitioner in respect of the life threat given by the respondents number 5 to 7. Therefore, representation has been given to the.
Threat perception report bandiya.
No, I'll get the.
And AGA accepts notice for respond number 1 to 4. Issue notice to respond number 5 to 7. Emergent notice written by 9th December. And AGA to secure a threat perception report of the petitioner in respect of the petitioner.
16.
This is the case where Aushadhi Kendra geo mandating closure has been challenged. Interim orders of protection have been granted at annexure 48, annexure L.
What have you challenged?
We've challenged a geo directing closure of Aushadhi Kendras in government hospitals.
Aushadhi.
Please. Page 48.
AGA accepts notice for respond number 1 to 5, 6. Who is for 6?
DSGA.
Shri Shanti Bhushan and DSGA for respond number 6. So order connect, and when have we listed all of them?
112th.
12, 11, 12, 12.
I'm giving a list of connected.
Yes,
please. Grateful.
17.
Matter I am requesting to note extension of parole. But sir, while granting the parole, this honorable court observed that the mother of the petitioner is seriously ill, and the 30 days parole has been granted, which has been complied, and liberty is given to seeking extension of trial. The petitioner requested them for the extension since his mother He seriously is suffering from lot of
Suffering from?
rectal bleeding and lot of the peripheral neuropathy and etc. That is the serious.
4L5 peripheral neuropathy. Yes, madam.
My lord, the earlier parole, my lord, expired on 8/10/2025 itself, my lord.
On time, lot
No complaint.
no complaint.
And AGA accepts notice for respond number 1 to 7. Petitioner is before this court seeking for, who is the petitioner?
Not the himself, not the.
How can he himself fight?
Not he from jail, not he brought the affidavit.
Mr. Tungi, some of you are going to get into serious trouble on this.
But in jail, not they permit me to, they identify them, not this person and signature and all, not.
As notary is sworn to before me.
But he went there, not notary. Notary also went to the jail to swear there.
Someday you are going to get into serious trouble if you keep on doing these kind of things.
Then next time, not will file
File an affidavit of a family member. We have advocates filing affidavits without knowing what it is. And you have you're not identified by anybody. This one is done. And you're saying notary went to the prison. Impossible to believe that.
But jail authorities countersigned them, not the affidavit as well as wakalat also.
Adaitu, notary enge. They don't even allow family members to meet antare. Notary work band.
Next time, I will change.
If they file that objections.
Next date, I will definitely I will ask somebody.
You will be in trouble. Before this court, petitioner is before this court seeking for the following leaves. The petitioner had been convicted for offences under section 376 of the IPC, read with section 5(1) and 6 of POCSO Act, in a special CC number 190 of 2017 by the 53rd Additional City Civil and Session Judge Bengaluru, and on 4/9/2018 was sentenced to imprisonment for life. The petitioner, as on 12/3/2025, had served a period of 7 years, 11 months, 23 days, and had been granted court parole on 2 earlier occasions for 2 months cumulatively. Subsequently, the petitioner was granted one more court parole by order dated 29th August 2025 in WP number 24377 of 2025, taking into consideration the medical certificate which had been produced relating to his mother, indicating that she suffered from peripheral neuropathy, rectal bleeding with chronic fatigue, with the doctor advising that she must undergo surgical treatment. Surgical treatment, aita?
Yeah, in no matter. Get to come. For that only, she has to come out. Nobody is there to take care of that. That is the last date of hearing also.
You have been given parole for that purpose. You did not avail of it, and you are coming again.
It requires some time, also money and all. He is a poor man.
That you knew when you took parole the last time. The parole was given for that particular purpose. So you did not avail of it.
No, I requested 60 days. In fact, lot of the 30 days has granted again liberty to sick.
If you don't avail of it this time, then you will not be able to avail parole ever. If you don't produce the medical certificate of surgery, we'll observe that you will never be able to avail parole. Are you trying to mislead the court?
No. Whatever is the fact is there, I have put it before the court.
ಅಷ್ಟೇ ಮಾಡ್ತಾ ಇರೋದು. ಸರ್ಜರಿ ಬೇಕು ಅಂದ್ರು ಸರ್ಜರಿ ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಪರೋಲ್ ಬೇಕು ಅಂತೀರ.
ಸರ್ಜರಿ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಹಾಗಾದ್ರೆ ಇಲ್ಲ ತಾನೆ.
The certificate also, my lord, it is
If my
file
lord
number
see,
20.
observe this medical certificate, my lord, in all the petitions, the same doctor has given the medical certificate.
Same doctor.
Yes, my lord. In most of the petitions, my lord, it is
Take
the
action
same
against
doctor
him.
who gives the.
Are you sure it's the same doctor?
Yes, my lord. I have seen many medical certificates, my lord.
We'll record your statement and direct inquiry.
I just wanted to.
Direct inquiry if the same doctor is giving this kind of.
Yes, my lord. It is the same doctor, my lord. I have
We
seen
have
many
also
medical
directed you
certificates.
to constitute a board. ಏನಾಯ್ತದು?
My lord, I have spoken to AG sir, my lord. We are in the
It's
process.
supposed to be listed this week, answer.
No, my lord. It is with respect of that club matters, my lord. That
Not
direction
club
is-
matters. The medical board and the e-enabling the parole applications.
No,
So that
there
they
is
can
no-
approach that board and they can get the certificate, which nobody can dispute.
I'll ascertain, my lord. I am not aware of.
We have these kind of doctors giving these kind of
Yes, my lord.
certificates, and which we will believe because doctor has given certificate. ಏನ್ ಮಿಸ್ ತುಮ್ಗೆ
Yes, my lord, sir. Next.
ಡಾಕ್ಟ್ರು ಬಹಳ ಕ್ಲೋಸ್ ನಿಮ್ಗೆ
ಇಲ್ಲ sir. You are government doctors, we don't know.
It's very close to everyone.
ಸ್ವಲ್ಪ ದೂರ ಕಳ್ಸೋಣ, so he can also get parole later.
Next time. I will also, my lord,
So it's the
instruct.
same doctor.
It is.
For surgery. On inquiry with the learned counsel for the petitioner, I submit that surgery could not be carried out since the funds could not be arranged. His submission is that if a further parole of 30 days is granted, funds should be arranged and the surgery carried out. In the interest of justice, though the submission made last time has not been adhered to, I am of the considered opinion that taking into account of there being no particular complaint against the petitioner during his release on earlier parole, I deem it fit to grant parole subject to the condition that the petitioner places on record the details of the surgery conducted on his return to jail. In the event of no such document being placed on record, adverse inference would have to be drawn, probably requiring the petitioner not to be granted parole again. And AGA submits, insofar as the medical certificate is concerned, that the very same doctor has been issuing certificates. If that be so, it would be for respond number
Go ahead.
ಇವ್ರು ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬರ್ತಾರೆ?
Doctor.
For the who will be the supervising authority?
I'll ascertain, my lord.
Give us that, this one.
I'll-
For so and so, to conduct an inquiry and ascertain the nature of certificates being issued by Dr. Shankar KN, MBBS, MS, DPH, KMC-50798, CMO, Senior Medical Officer, rank of District Surgeon, Victoria Hospital, BMCRI, Bengaluru 02, and submit a report in that regard, which report shall be submitted on or before 15th December. Though the above petition, I pass the following orders. So and so, though the above petition is disposed, released on 15th December, to consider the report submitted by the so and so. Here the designation of the officer.
Yes, my lord. I'll give.
Discord.
18.
30 days.
One request, my lord, with respect to
Ms. Tumgi, ಈ ಸತಿ ಕೊಡ್ಲಿಲ್ಲ ಸರ್ಜರಿ ಇದು ಅಂದ್ರೆ
This time, Lord, I will also suggest them that, Lord, if they bring them, Lord, certificate from the same doctor and all. So I will inform that, Lord.
if that is not given,
Yes.
My lord, one request with respect to serial number 16. Notice issue agide interim order agilla, my lord.
I oppose for that, my lord, because
Interim order already granted in 19292 and connected.
tri-party agreement, my lord, all these Aushadhi
We'll consider all of
Kendras.
them on 12. There's a batch of 50 matters or something.
Please.
Where coordinate benches have granted stay. ಒಬ್ಬರಿಗೆ ಹೆಂಗೆ ಇದು ಮಾಡೋದು? You file your objection, we'll consider
Please,
all
please.
of them on that.
Please.
Interim order as granted in 19292.
Interim order as per that.
Please.
You're given the paper, no?
Please.
Your order.
Grateful.
18.
Recreation. And AG accepts notice for the respondent. She seeks for and is granted 2 weeks time to obtain instruction as to ascertain if the petitioner is conducting its affairs in the location indicated and if all the compliances have been made. Relist on
2nd December.
2nd December.
2nd December.
19.
Mr. Parshuram.
Petitioner in this case, the writ of mandamus directing the R2 to consider the complaint filed by the petitioner, my lord.
ನೀವೇನನ್ನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ?
ಅಲ್ಲ, ಅಲ್ಲಿ ಫ್ರಾಡ್ ಆಗಿದೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ. So the government has withdrawn the consent clause. Kindly turn to page annexure B, my lord, page number 29. Para 3, my lord.
29.
It is further intimated
and others.
that the government of Karnataka has withdrawn the general consent given to CBI under section 6 of DSP Act 1946 wide government order HD 139 COD or 2024 or 27 and 2024 in the absence of general consent under section 6 of DSP Act 1946. CBI is unable to register a regular case and take to inquiry investigation without prior approval of the state government. We have given representation to the government on 17/7/2025. There is no response, my lord. Annexure F is the
specific case-to-case basis.
Yes, ma'am.
Yes, madam. On case-to-case basis, they wanted to be taken. CBI
Not served, my lord. Copy is not served.
Served, my lord.
19, serial number 19.
19 serve ಆಗಿಲ್ಲ.
State government serve ಮಾಡಿದ್ವಿ. CBI have to serve.
No seal.
My lord.
ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಂಡ್ರೆ?
ಅಲ್ಲ, you have taken
ಒಂದು ಕಾಪಿ ಕೊಡಿ. And AG accepts notice for respond number 1, Shri Prasanna Kumar accepts notice, is directed to accept notice for respond number 2. Counsel for the petition furnished 2 sets of petition along with annexures on the said counsel relist on 26th November.
Serial number 20.
Parole.
Premature releasement. Board recommendation.
Board recommended.
First time is seeking.
As a time, my lord, I am not.
And AG accepts notice for respondent. She seeks for and is granted 2 weeks time to obtain instruction, make a submission. Relist on 1st December.
Obliged.
21. Srinivas here.
Counsel for the petitioners, please.
Yes.
Petitioners are the senior citizens who had filed petition before the assistant commissioner seeking restoration of possession, please, my lords. However, the petitioners were driven out of their house by respondent number 5, who is the daughter-in-law of the petitioners, please, my lords. The property stands in the name of petitioner number 1, please, my lords. And since there is a matrimonial dispute among respondent number 6 and 5, cases have been filed against the petitioner, and as such, the petitioners have been driven out of the house. Thereafter, the order of AC was challenged before the deputy commissioner. A deputy commissioner holds that and directs the petitioners to approach the civil court for the possession of the property, please.
Where does it show that the property is in the name of the petitioners?
My lords, annexure C, please, my lords.
Page?
Page number 26, please, my lords.
ಇದರಲ್ಲಿ the father-in-law and mother-in-law have been thrown out. Daughter-in-law is happily sitting there. 2 years, I think.
A lot of cases like this are coming.
Yes, Very unfortunate. ಆಮೇಲೆ she comes out to the street and scolds him.
Anyway, you're not sought for any interim prayer and we can't
No,
give
ಇಲ್ಲ,
it.
notice ಹೋಗ್ಲೇಬೇಕು.
And AG accepts notice for respond number 1 to 4. 5 and 6 ಯಾರಾದ್ರೂ counsel ಇದ್ದಾರಾ? Any other proceedings? Any other proceedings are there?
Earlier proceedings, they had a local advocate in Tumkur, please.
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ.
ಇಲ್ಲಿ ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾರು ಇದ್ದಾರಾ?
ಇಲ್ಲ,
ಇಲ್ಲ, ಇಲ್ಲ.
Issue emergent notice to respond number 5 and 6 returnable by 9th December.
ಆಯ್ತು. I'm hang summons ಅಂತ ತಗೊಂಡ್ಬಿಡಿ.
Counsel for the petitioner is also permitted to hand summons, please, in respect of respond number 5 and 6.
Apply.
22, S.A. Sudhindra.
Petitioner, Lord.
Yes.
But the petitioner is, has entered into contract with security contract agreement with the respondent bank. There is a clause 17, page number 24, ink pastem. Any dispute or difference or claim arising out of or in relation to this agreement, including the construction, performance or breach thereof, which the parties cannot settle by reaching mutual understanding, shall be settled by arbitration.
Yes.
Without adhering to this clause, they issued the terminating notice.
How is the writ petition maintainable against the
Lord,
respondent?
the bank,
Like
Cooperative bank.
It's a commercial service.
Lord,
Writ petition is not maintainable.
right, they have issued the tenders, Lord.
Tender. ಎಲ್ಲರೂ ಕೊಡ್ತಾರೆ tender. You can also take out a tender.
By violating the contract.
So there's an arbitration clause. If they have terminated, you can take it up in the arbitration proceedings. Writ petition is not
They,
maintainable.
instead of adhering to the arbitration,
Writ petition is not made. They can terminate. You can raise arbitration dispute. They need not raise arbitration.
right? Lord,
Petitioner is before this court seeking for the following reliefs. Notice to respondent is dispensed with in view of the order proposed to be passed. The petitioner is before this court aggrieved by the respondent terminating the work order issued by respondent in pursuance of a
issuing the
tender.
tender notification.
If at all the petitioner is aggrieved by any such action, it is for the petitioner to take such action as may be permissible under the security contract agreement produced at Annexure D, which also contains an arbitration clause. Reserving such liberty, petition stands disposed.
23.
Mr. Nagaraj,
Petition.
ಏನಿದು?
It is a writ of mandamus, my lord. It is a directive, the second respondent, the release of the vehicle, my lord. Appeal has filed before the second respondent. The identical matter, my lord, it's Annexure D, my lord, Annexure J.
Page?
Page Annexure J, page 34, my lord. The FIR is, my lord, it FIR.
Annexure J.
J, my lord. Identical.
ಇಲ್ಲಪ್ಪ.
Last paragraph.
Annexure J ಬೇರೆ ಎಲ್ಲೋ ಇದೆ.
In the case of nature, in the ends, the second respondent.
ಇಲ್ವೇ ಇಲ್ಲ. H is the last annexure.
Which also is the same, it's same identical matter. Either. FIR is, my lord, it is FIR is the challenge before this honorable court, my lord, FIR is stayed. Thereafter, my lord, appeal has filed under the EC Act, my lord. 451 and 457. Now, my lord, his appeal is not heard the matter.
Is not heard the matter.
Yes, my lord. 17/10/2025 the appeal is filed.
AGA accepts notice for respond number 1 to 4. Petitioner is before this court seeking for the following reliefs. The petitioner's vehicle, namely a lorry bearing KA number KA01 AB0798, having been seized by the respondents. The petitioner, in furtherance of which crime number 170 of 2025 was registered. The petitioner made an application for release of the vehicle to the second respondent deputy commissioner. The grievance of the petitioner is that the said application has not been considered by deputy commissioner till date, despite the application having been filed on
17/10/2025, my lord.
17,
10.
10,
Next year.
25.
Yes, next year G, my lord.
ಬಹಳ ಅರ್ಜೆಂಟ್
So one thing like some vehicle ಅಲ್ಲಿ
ಒಂದು ತಿಂಗಳು ಅಷ್ಟು ಅರ್ಜೆಂಟು.
ಅಕಸ್ಮಾತ್
17, 10, 25. Since an application had been filed for release of the vehicle, it is but required for the response to consider, for respondent number 2 to consider the said application and pass necessary orders in accordance with law. Hence, I pass the following order. Writ petition is allowed. A mandamus is issued directing second respondent to consider the petition filed by the petitioner under section 6C of the Essential Commodities Act 1955 and pass necessary orders in accordance with law within a period of 3 weeks from the date of receipt or copy of this order. It is made clear that this court has not expressed any opinion on the entitlement of the petitioner in the matter.
24, Arvind Patil.
Mr. Anshuda?
There is a grant by the land tribunal
Hmm.
in favor of the occupant on 18 to 1993.
On?
18 to 1993, Annexure A.
Mic on ಮಾಡ್ಕೊಳ್ಳಿ.
Annexure A. That order attains finality. There is no challenge to that order either by the government or by anybody else.
ವೆಂಕಟೇಶ್, ಲಾವಣ್ಯ, ಮನೋಜ್, ಭರತ್. ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? They are not parties to this.
Please, your lordship kindly take Narasimhaya.
ಎಲ್ಲಿದೆ? Narasimha is not a petitioner.
No, Narasimhaya sold the land to the petitioners under the sale deed dated 22/5/2006. Pursuant to the sale deed, mutation was accepted, Khata was transferred in our name. Land was converted for non-agriculture purpose.
Yes.
An application was moved before the Magadi Town Planning Authority for approval of the layout. Layout has been approved. Now Annexure J came to be issued saying that no sale deed cannot be registered in respect of the
Your
property.
interim order cannot be granted. And AG accepts notice for respondent number.
My lord, in this, my lord, may I speak? My lord, in this originally, my lord, this is not the land of Inam, my lord. Order was passed. There are 3,000 acres are there, my lord. Either Inam land alvante ಆದೇಶ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ ಹೇಳಿ. There was a trust.
So what have you done about it?
I have to take instructions and submit, my lord.
That's what we are giving you notice.
Yes, my lord.
Find out what you have done.
Yes, my lord.
The government
Further
has to take
proceedings
its
have been taken place in respect of 9 villages. They said there is a donation by the gift by the Radhabai is concerned. It was treated as Inam lands. An application was filed.
It was a trust
And
was
in favor of
created,
the
my lord, for the benefit of temple, my lord.
There are a lot of kinds of frauds which are coming, which once we see only we know that these kind of frauds can also happen.
93 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿಬಿಟ್ಟು ಡೋಂಟ್
Executive Officer, Bengaluru South Taluk Yarama, Panchayat. MS AGA for 1 to 4, MS Devraj for respondent number 5. Counsel for the petitioner furnished 2 sets of the petition along with annexures on said counsels. Then AGA seeks for and is granted 2 weeks time to obtain instruction, make a submission. Relist on 2nd now December.
Five, Ashoka T.
My lords, in this
I'm the
matter.
QA respondent, my lord.
Senior
Yeah, copy
counsel.
has not been served, my lord.
My lords, email ಕಳ್ಸಿದ್ದೀವಿ. We have sent the copies through email, my lords. I'll serve one more set, my lords.
Copies have not been served, my lord.
Serve ಮಾಡ್ತೀನಿ, my lords.
Land Council undertakes to furnish a set of the petition along with annexures on the Cavita Council by end of day today.
Please, my.
Land AGA accepts notice for respondent number 1 to 8. ನಿಮಗೆ ಬಂದಿದೆಯಾ copy? Both the councils seek, both the respondent councils seek for and are granted 10 days time to obtain instruction, make their submission. Relist on 26th November.
27th, my lord.
26th.
27th, or 25th. 25th or 27th, my lord.
27th, okay, 27th. I 1 of 25 is allowed.
Much.
26.
Lordship, I appeal on behalf of the petitioner. Lordship, this is a matter wherein the passport authorities say that there is police verifications not very clear. This arises out of the fact that the petitioner is the sister of the wife between, there's a dispute between husband and wife, and she's the sister of the wife. And there are cases pending on respect with the trespass only, Your Lordship. And in the connected matters, Honorable Supreme Court has approved,
Ms. Reshma Kamaya is directed to accept notice for respond number 1 and AGA accepts notice for respond number 2. Counsel for the petitioner served 2 sets of the petition along with annexes on the said counsel. Released on 26th November. IA 1 of 25 is allowed.
Obliged.
27. Saurabh GK.
Yes.
Towards the petitioners are the partners of a firm. Towards page number 64, can I request your lordships may kindly take notes. Lords, without making the partners as a parties, a writ petition is filed seeking registration of.
Page number?
Page number 64. Lord, this is the state of affairs which stood as of 1999.
4 is Form C.
Form C. Lords, your lordships will find that the petitioners are the partners. Lords, then one of the petitioners who is the managing partner executes a power of attorney at page 65.
Janet, Preeti, Florence, Anuradha. James Richard, Ratna Richard.
Janet, Preeti. Next one is that.
Florence.
Florence.
Yes.
Round up. Page 65, your lordships may kindly take notes. There is a power of attorney executed by the managing partner.
Yes.
Lords, this is appointing one K.R. Satish and H. Rakesh Bhatt. Lords, the third unnumbered paragraph. This is the object of executing this power of attorney. Manage the affairs of the quarry work, attend to the sale of granites, appear before the authority, department officers. I deem it absolutely essential to appoint the attorney. Lords, the powers as are described are generally in nature only to appear before the revenue authorities, applying for any application, grant of further orders, so on and so forth, etc. This is all the powers.
Yes.
Lords, what this two persons would do is, Lord, this is a power of attorney which has been cancelled at page number 68 in the month of July 2024 itself. Now he files an application at page 70. He reconstitutes the firm. Lordships will find incoming partners K.R. Satish and Rajesh. Then right hand side column is Janet, Preeti and Florence Anuradha. He signs as the power of attorney holder on the right hand side.
But he is not their power of attorney.
He is not the power of attorney.
Yes.
He claims to as the power of attorney holder of the entire firm. But then page 71.
Only for the firm, not for individual partners.
Yes. But he is a partner for an individual partner, J.M. Richard, not for the firm. That's the reason why I took your lordship's willingness to that power of attorney.
At the most, he could be a partner for
the managing partner.
J.M. Richard.
J.M. Richard only.
Or for the firm.
Even if it is
not the power of attorney for Janet, Preeti and Florence.
Yes. This form is submitted. Page number 70. Lords, now page 71, my lords.
Yes.
Lords, the registrar of firms gives an endorsement saying that the signatures of the outgoing partners are not there because what was forthcoming there was the power of attorney holder signatures. But now he does not disclose these facts and comes before this honorable court and says, lords, may kindly take notes, page number 30. He claims himself to be the power of attorney holder of the firm, whereas the power of attorney is actually only by G.M. Richard. And this honorable court is made to believe that it is not mandatory to affix the signatures of the outgoing partners. And on this count, my lords, it was directed that you consider it in accordance with law under section 63. This order would not have been harmful. But again, it is moved for being spoken to at page 33. Lords, a positive direction is obtained, my lord, saying that it should be registered. Lords, now excluding us from all the purview of everything, this entire exercise has been undertaken. We are seeking a review in view of Shivdev Singh's case and Pola Singh's case. Now, lords, the difficulty for us is, lords, can I just pursue your lordships, my lords? There is a Karnataka partnership registration firm, register of firms rules of 1954. Lords, there is a right which is vested. Lords, whenever such things happens, this is an endorsement which was issued because whenever such an entry is requested or requested to be made, there is a protest which can be made against such proposals in terms of Rule 7. Then under Rule 8, there is a power to conduct an inquiry by the registrar.
Has not
moment-
been done.
So the moment this exercise can be undertaken, then my lords, the registrar can go into as to whether the registrar's power is very limited, whether the requisites under the act and the rules is meted
Normally,
out.
we would have said go to civil court, but since this is based on an order passed by this court, we'll have to intervene.
That's the reason, my lords.
And AGA accepts notice for respond number 1 and 2. Who are the counsel who appeared for them?
There's one, Mr. Shubham has appeared, my lords. I'll
Mr.
find out and
Shubham
then serve a
NM,
copy on him.
who had earlier appeared for respond number 3 and 4 in WP number 31119 of 2024. He is directed to accept notice for respond number 3 and 4. Additionally, issue emergent notice to respond number 3 and 4, returnable by 9th December. Counsel for the petitioner is also permitted to take out hand summons on respond number 3 and 4, returnable by same date. The operation and implementation of Form D at Annexure A is stayed till the next date of hearing.
Is great.
IA 1 of 25 is allowed, IA 2 of 25 is allowed. Process fee and copies to be furnished by end of day 14th, failing which the interim order will stand
Please,
automatically.
Give it them
That
up.
Gaurav knows, he will do.
Serial number 28.
For the petition, my lords, it's a writ of mandamus, seeking a direction to discharge the difference of GST. Responding.
ಯಾವ್ದು ಆವಾಗಲೇ GST ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದ
28.
GST 28 ಎಲ್ಲ ಇದು 28 ಆಗಲೇ ಒಂದು GST ಕೊಟ್ಟಲ್ಲ that when the work order was issued no GST was there. Dictate ಮಾಡಲ. And AGA accepts notice for respondent. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that when the work order had been issued to the petitioner, payment of GST was not contemplated, and it is only after the Goods and Service Tax Act 2017 came into being that GST was required to be paid on the works contract. The petitioner, having made payment of the due GST, had sought for refund of the GST amounts to the respondent by submitting a representation to the respondents, which not having been considered, the petitioner is before this court seeking for the aforesaid relief. Whenever, since the payment of GST was on account of the act coming into force, and it was required for the petitioner to make payment of the GST amount, it is but required for the respondents to reimburse the differential GST amount on the petitioner submitting necessary proof of such payment by way of the challenge for such payment. In that view of the matter, I pass the following. A writ petition is allowed, a mandamus is issued, directing, permitting the petitioner to submit the challenge and supporting documents as regard the payment of GST amount to the respondent within 15 days from date of receipt of this order, and directing respondent to consider the same and pass necessary orders within 30 days of such receipt.
29. Karnataka.
29. Marriage certificate. ಏನಕ್ಕೆ ಡಿವೋರ್ಸ್ ಆಗಿದೆಯಾ? Fasu?
Serial number 30. Vijay Kumar T.
Petition. Yeah, for respondent 8 to 9. 5 to 9.
Hello. Petitioner.
What is the report of RJ?
Hello.
ಒಂದು ನಿಮಿಷ ಇದೆ.
Please.
So it is kept in 10602.
It's kept below answer there. What is this report? Q, Excel Q. Ilwa. Yes, what is this?
That, the Brahmashri Narayan Guru Billavara Sangha is registered under the Cooperative Society Act, my lad.
Cooperative society. Society na cooperative society?
Cooperative
Society. Nammunde baralalapa.
Now administrator has been appointed, that
Yes,
is.
but this is not our roster. And counsel for the petition submit that the first petitioner has been registered as a cooperative society. If that be so, it would have to be placed before the appropriate roster. Registry is directed to do the needful.
First petitioner is trust. What has happened in this, my lord? Cooperative society has merged with trust. Thereafter, registrar of cooperative societies has appointed administrator merging the said.
The matter relates to a cooperative society. Matter relates to an order passed by registrar of cooperative society. Registry is directed to place the matter before the appropriate bench.
Any date may be.
Now date ಆ bench fix ಮಾಡಕಲ್ಲ ಬರುತ್ತೆ.
Thanks.
ಈ cooperative society ಬಹಳ confusion ಇದೆ.
Archer report.
ಅಂತ ಎಲ್ಲೋದ್ರಿ ಇವರು? Registrar Judicial is saying it is KSR because it is a society. What is petition? Now, this matter has gone from service to KSR to CS to now KSR. So again, we are sending back to CS. No, but registration under cooperative societies ಇದೆ. ಪಾಸ್ವರ್ಡ್ ಕರೀರಿ ಅವ್ರನ್ನ. ಪಾಪ ಓಡಾಡ್ತಾ ಇರ್ಬೇಕು.
31.
ಗಣೇಶ್ ಕುಮಾರ್. ಪಾಸ್ವರ್ಡ್. Ganesh Kumar.
Appearing for the petition, my lord.
Yes.
My lord, short accommodation, my lord, kindly.
What are you seeking for? You made an application for marriage to be registered?
Yes, my lord.
I seek instructions from my client.
If they submit, you will consider that. Submit those documents.
Yes, my lord.
That AG accepts notice for Agile. Petitioner is before this court seeking for the following leaves. Notice having been issued, learned AG on instructions submit that the supporting documents have not been furnished by the petitioners, and it is for that reason that the marriage could not be registered. If the supporting documents like address proof, Aadhaar card,
Rental agreements.
address proof ಕೊಟ್ಟ ಮೇಲೆ ಆಯ್ತಲ್ಲ ಇನ್ನೇನೇನ್ ಬೇಕು
Affidavits ಕೊಡ್ಬೇಕು. ಅದೊಂದು format ಇದೆ.
affidavits etc are furnished, the same would be considered and necessary orders passed within 30 days of such submission. Reserving liberty to the petitioner to furnish such documents, petition stands disposed.
32.
Should like to appear for the petitioner in this matter, my lord. I'm seeking
Please, okay.
a writ of mandamus before this honorable court for police protection, my lord.
There's a KLR and there's a police matter.
Please, my lord, 32.1 is the KLR matter, my lord. What happens is that there is an interim order of status quo as regards the possession of the petitioner over the suit, over the scheduled property, my lord. In brief, my lord, the matter revolves around a narrow compass, my lord. I am the owner of a survey number 22/1 in Lingnalli village, my lord. I've given up 5 guntas of land towards the Pradhan Mantri Sadak Yojana.
Just 1 minute. What is annexure A in the next petition? 3822?
3822, my lord, that is the order of the Tahsildar, my lord, at running page number 17 of that petition, my lord.
Yes.
So this annexure A, my lord, only states that if at all any obstruction has been found on a tar road, then the revenue inspector has been directed to remove the same, my lord.
Yes.
The very same Tahsildar at annexure B, my lord, he passes another order to remove any such obstruction if found. And at annexure C is the actual survey sketch that has been furnished by the said revenue surveyor, my lord.
Indicating the existence of the road.
Yes. Now what happens is this, my lord, 5 guntas of land I have already given up towards the tar road, my lord. What the revenue officials do is that, my lord, they are trying to form a new road only for the benefit of the vested interest persons who are below my property. So then this order at annexure B comes to be passed, my lord. I challenge the same before this honorable court in the coordinate bench, my lord, and I secure an interim order, my lord. Subsequent to this, my lord, if your lordship would take the other companion writ petition, that is 15973, my lord. I have produced the actual photographs of what they have done, my lord, along with police protection. Despite the order of status quo, my lord, that is at running page number 48, it is annexure F series. So with the help of the jurisdictional police, despite the order of status quo, my lord, a new road has now altogether been formed. Already 2 roads are there. And this is not as per the village map. This is not as per the earlier tar road.
Without
What they do is.
And no acquisition.
Acquisition is.
Memo in? Yes.
Copy could without any authority.
As per village map, this is the road. Which was page number
Your survey number 22.
22/1, please. Now, this is in the southern portion of my property, my lord, even as per their own survey sketch. The road that they're now harping upon, my lord, goes through the property, my lord. Now, this road has only been formed for the benefit of the vested interest persons, my lord.
It will be formed throughout. It's shown as a road in the village map.
My lord, this is the survey sketch, my lord.
Yes.
Now, the road which they're showing in the village map is this road.
Correct.
Now, they have formed a road here at this portion. This is the southern portion. Even the map depicts north is on top, my lord, below is south. So here they form this road, my lord, along with the police protection. So what I write to the juris,
What basis do you say it is on the southern portion?
based even on this revenue sketch, I'll be able to show that, my lord. And if need be, my lord, I'm ready for another survey also.
The village map for 22 shows the brown color in the end ಮಾಡಿದ್ದೀರಾ ನೀವು. That is not the village map. It's additional yellow portion. ನಿಮ್ಮ ಹತ್ರ color ಇದೆಯಾ?
That document I have not received, my lord.
Yellow color road. ಇದು brown color ಏನೋ ಮಾಡಿದ್ದೀರಾ? The objection is as regard the brown color.
ಅಲ್ಲಿ ಕೆಳಗಡೆ ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವುದು ಡಾಂಬರೀಕರಣದ ರಸ್ತೆ ಇದ್ದು ದಾಖಲೆಗಳಲ್ಲಿ ಇರುವುದಿಲ್ಲ.
ಅದನ್ನ ತೆಗ್ದಿದ್ದೀರಾ ಇವಾಗ? ಅದನ್ನ ತೆಗ್ದಿದ್ದೀರಾ ಇವಾಗ?
ನಾವು ಈ ವಿಲೇಜ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದೇ ರೋಡ್ ಮಾಡಿದ್ದೀವಿ.
ಸೊ ಬ್ರೌನ್ ತೆಗ್ದಿದ್ದೀರಾ? ಬ್ಲೂ. You haven't received this memo?
I have not got a copy of the memo.
Copy on put. What they are saying is that the blue portion, they are brown in the village map and in the other survey map, they marked it as blue. That blue they have removed and yellow continues.
I bow down, my lord, but however, even if going by whatever they're saying now across the bar, if there is a tar road, my lord, there's a fresh piece of land now which they have dug up and made a road. So there could not have been a tar road here.
Please see the survey map that they made at page 8.
A copy of it.
And AGA submitted survey has been carried out. A copy of the memo enclosing this along with the survey map would be furnished to the petitioner by end of day tomorrow. Counsel for the petitioner seeks for a week's time to go through same and make a submission. Released on 26th.
Grateful.
33.
This matter may be taken upon first, my lord.
Your lordship.
Parole.
Yes, my lord.
Since 3 months it's pending.
And AGA accepts notice for respondent. She seeks for a grant 2 weeks time to obtain instruction, make a submission. Released on first.
Your lordship, second.
All
He won't be there.
I haven't Harvard matters.
You can come on VC.
Represent the state in the matter. On the last occasion, my lords had directed us to conduct a survey with regarding to the premise where the firecrackers were stayed. May I just pass across this report, my lords?
Yes, now they have handed over the copy of the report, my lords. I'll just look into it and make my submissions.
Yes, Mr. Ravi Shankar.
Lords, it's the essential ground which we have raised, my lords, in the matter is
Now
this.
Deepavali is over.
No, not about that. my
Be
lords.
another issue
My
next
lords,
year.
No, this is not a Deepavali store, my lords. This is a permanent store. We have the licenses from the past for 15-20 years in the same premises. Now, in respect of the same premises, same plan, the license is being renewed from time to time. Lords, under Rule 84 of the explosive rules.
You ready na?
ಇಲ್ಲ ಅದಕ್ಕೆ ಇದನ್ನ ನೋಡಕ್ ಅವಕಾಶ ಆಗ್ಲಿಲ್ಲ. ಇದನ್ನ ನೋಡ್ಬಿಟ್ಟು ನಾ
General has
ಮಾಡ್ತೀನಿ.
filed a memo enclosing the survey report and certain documents. Same is taken on record. Copy and been furnished to the counsel for the petitioner. Seeks for and is granted 10 days
1
time
week,
to obtain
sir.
instruction, make a submission. Released on 2nd December.
Please, minutes.
35.
Writ of mandamus, my lords. Lord, for the enforcement.
58, my lord, that RERA comply.
41 na? ಇದು ಯಾಕಪ್ಪ ಇಷ್ಟೊಂದು ಬರ್ತಾ ಇದಾವೆ?
28 is the revenue recovery.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಕು, ಆಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಟು ಸರ್ಚ್ ದಿ
Any particular problem? Why they are not
But they
initiated?
are doing, they are not doing. There is a special DC is constituted for this purpose only. ಅವ್ರು ಬರೀ ಇದು senior citizenship matter ಮಾತ್ರ ತಗೋತಾರೆ. So it will be forwarded to the concerned tahsildar. They will find out the premises and they will look into and ಅದಕ್ಕೆ ಒಂದು ಮಹಜರ್ ಕಂಡಕ್ಟ್ ಮಾಡಿಬಿಟ್ಟು then they will start the process. ಸ್ವಲ್ಪ late ಆಗುತ್ತೆ.
Third matter today. The same. And AG accepts notice for respond number 1 and 2. Notice to respond number 3 is dispensed with since no relief has been sought for. Since respond number 3 would have nothing to say as regards the reliefs which have been sought for. Shri Gautam Des Ullan accepts notice for respond number 4. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respond number 2 has not taken any action to enforce the order dated 13/2/2025 passed by respond number 4 under section 40 of the Real Estate Regulatory Authority Act, so and so. The submission of learned counsel for the petitioner is that respond number 2 was but required to initiate proceedings for recovery of the amounts mentioned in the recovery certificate, the arrears of land revenue, as expeditiously as possible and make available the said amounts recovered to the petitioner. The order having been passed on 13/2/2025, it was but, having gone through the documents, the order having been passed on 13/2/25, it was but required for respond number 2 to have taken action as expeditiously as possible. Same not having been done, I pass the following order. Writ petition allowed, a mandamus is issued directing respond number 2 to take necessary action to enforce the order dated 13/2/2025 passed under section 40 of the Real Estate Regulatory Authority Act and recover the amounts mentioned therein as arrears of land revenue from the third respondent as expeditiously as possible, preferably within a period of 60 days on date of receipt of a copy of this order. Counsel for the petitioner is also permitted to furnish the list of
the
properties owned by respond number 3 along with supporting documents to respond number 2.
One more request ಮಾಡ್ತಾ R2 ಅಂತ ಹೇಳಿದ್ರಿ, ಅಲ್ಲಿ ಸ್ಪೆಷಲ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಂತ.
Special deputy commissioner. The submission of mail ಬರ್ಕೊಳ್ಳಿ. The submission of learned AGA is that a post of special deputy commissioner has been
He's allotted
created
that one.
for the purpose of implementing the orders under section 40 of the RERA Act. Midrally, second respond ಬದಲು the special deputy commissioner.
36.
Lord, in 36, my lord.
That on 1610, notice is ordered and directed the state to file a statement of objection on or before 5th to serve the copy.
Yeah, idarda.
No, this is matter
Internal-
relating
internal
to
reservation.
Internal
Internal
reservation.
reservation.
Yes.
That's 32. Lots in 32, my lords,
36 ಇದು.
36.
36, I'm sorry.
3, 4 other matters ಅಲ್ವಾ?
Other two matters are not listed, my lord.
ಅಲ್ಲ, ಒಂದ್ ಬಂದಿದೆ ನೋಡಿ.
ಎರಡು ಬಂದಿದೆ. 72 one, it is connected to this.
72 and 36. In 36 into 2, 72.
That's, insofar as the objections in the first case is concerned, my lords, it's almost ready. We'll be filing it in a day or two, my lords. Insofar as because the cognate petitions have taken up slightly different contentions because it is by a different groups. So
When
we
will
had
you
to,
file objection, all the matters?
all the matters we want to file objections. We require around 10 days time, my lords.
36 connect to 72. How many other matters are there?
இன்னும் better matters.
Other two matters are there.
Which is your matter, Mr. Shankar Narayan?
32137.
Connect with WP 32127 of 25.
32137 of.
Birth ಕೊಟ್ಬಿಡಿ. Any other matters?
No, there is one more matter I will.
Number ಕೊಟ್ಬಿಡಿ. Connect with so on.
There's one or two matters, my lords, we'll just stand it.
Give us all the numbers.
Please, my lords. Mr. Arun, sir.
Kind indulgence in making an observation for good and sufficient reasons that the interim order passed in the earlier main matter would inure to the benefit of these petitioners.
It's an order.
It serves a purpose, it serves a purpose.
The main matter, the interim order will serve everybody.
Everybody's purpose.
No, it serves a purpose.
Everybody belonging to all the communities, it serve as long as they're contained in the
I
report.
was only trying to impress upon.
You want the interim order in your matter also.
What is
For good
happening?
and sufficient reasons, my lord may observe that.
Good and sufficient ಅರ್ಥ ಆಯ್ತು.
My lord may observe that it will inure to the benefit.
What is happening? This is He wants
Our
to-
very good and sufficient reason.
So this reservation pertaining to the education and employment, so far as appointment is stayed, but admission to the educational institutions is not stayed. State is going on with the making admission in the educational institutions.
You again admission.
In accordance with the, no, MD.
What admissions are?
So MD, ಅದಕ್ಕೆಲ್ಲ ಇದನ್ನ ಮಾಡಿದಾಗ, through the Karnataka Education Authority, they are doing the admissions.
This is not education season.
No, caste certificates are issuing on the basis of this, on the basis of category A, B and C.
3672 connect with so and so. That additional advocate general submits that objections are more or less ready, given 10 days time. The objections would be filed after serving copies thereof on the respective counsels for the petitioners.
Interim order may be.
Relist on 3rd December at 2:30 PM.
Interim.
In the meanwhile, the respective counsels for the petitioner and respondent shall exchange their respective synopsis of dates and events, list of authorities along with authorities, and get ready to address their arguments on the next date of hearing. Interim order earlier granted is extended till next date of hearing.
My lord, serial number 36, my lord. We have already impleted, my lord. Kindly take it on record, my lord. Appearing for the petitioner.
No one
11
is
and 12.
impleted.
Already impleted.
No one is impleted.
Without us, how can you implead? You filed an application for impleading. Who are you?
Petitioner 11 and 12, my lord.
Yaru ನೀವು?
She filed an application to come on record as petitioners 11 and 12.
As petitioners?
11 and, that is
He
strange.
doesn't want you to come.
That is strange.
IA 2 of 25.
There are two impleading applications.
We have only one listed today.
ಇವ್ರದ್ದು ಆದಂಗಿಲ್ಲ. ಇಲ್ಲ, ಒಂದೇ ಬಂದಿರೋದು.
Maybe at best they could be heard as interveners.
Are they opposing or favoring? ಗೊತ್ತಿಲ್ಲ.
I don't, notes, I think the first application that was filed, IA 1 of 25, they were favoring us. I think the other people are opposing us.
This is, no, this is, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರು ಅಂತ ಅದಕ್ಕೆ just to decide which side to go.
ಒಂದು ಕೇಸ್ ಬಿಟ್ಟಿನಿ ಅಂದ್ರೆ ಆರ್ಡರ್ ಆಗಿದೆ. Just connect.
IA 2 of 25 has been filed by one society and a individual to come on record as party respondents. I have the considered opinion that a challenge to the constitutionality having been made by the petitioners, such an application to come on record as party respondent would not be permissible. They could, however, assist the additional advocate general in the arguments to be advanced, as also this court as interveners. Hence, IA 2 of 25 is allowed to that extent. We list on 3rd.
Please, grateful.
Including our matter.
3672 ನಿಮ್ದು ಎಲ್ಲ.
Grateful.
37. M.
My lord,
Raghunathan.
my lord, seeking for a short adjournment, madam. Short. Senior.
37. Report. And AG ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ? And AGS 6 fund is granted 10 days time to file report. Relist on 3rd December.
38, serial number 38.
Lord, may kindly recollect, Lord, the no confidence motion is progress. Now the
In
Enquiry is
administrator to be
initiated.
appointed, inquiry and administrator will be appointed.
there's a
Negating the,
threat is, my lord, the appointment of an administrator to frustrate the no confidence motion. Meeting is scheduled on 15/7/15/11. my lord. On that day, our lordship
are
said,
you going to be appointing an administrator before 15/11?
My lords,
Or
now
will
we
you
have
permit
on
that meeting to go on?
ಅಲ್ಲ ಮೀಟಿಂಗ್ ನಮ್ಗೇನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. 11 we have appointed an enquiry officer.
That's
Per
correct.
section 25. I'll place that on record.
ಅದು ಗೊತ್ತಾಯ್ತು.
ಹಾ.
Will you appoint an administrator before 15th?
Plus, I have no instructions. That was not the prayer, so I don't have that instruction.
That is the question that we asked.
I'll just.
Only
I'll just-
argument is that
27th motion was placed.
My instruction is, as of now, we have initiated only section 25 inquiry. Administrator, we have not made any progress.
so don't take any action on the enquiry report without permission of the court. Let the meeting go on.
Place it on.
Let the meeting go on.
Grateful.
We don't want that meeting to be frustrated.
Frustrated.
And additional advocate general submits that enquiry officer is still conducting.
Yes, he
the
started
inquiry.
the proceedings.
He has started the inquiry
11 we
proceedings.
appointed, my lords. Today is.
And it will
12.
take some time for the inquiry to be completed. The respondent number 1 to 3 are restrained from taking any action on the inquiry report without due permission from this court till the next date of hearing. Relist on 25th November. Your purpose will be achieved.
Great.
ಆಮೇಲೆ withdraw ಮಾಡ್ತೀರಾ?
ಆಮೇಲೆ
25th withdraw ಮಾಡ್ತೀರಾ?
ಹೌದಾ? 39 minute yesterday's matter. I want till Monday minute.
ಎರಡು yesterday's
something
matter.
be undertaken. It's an appointment of administrator.
That's
I have argued that matter yesterday.
Huh.
I wanted to cite the orders passed by this court in Balad Sanghas matters, my lord, I referred to.
ಅದೇ ನಿನ್ನೆ you
Correct,
took time
correct,
for that.
correct. Some tinkering is required, my lord, they kindly discuss on Monday.
Notice ಆಗ್ಲಿಲ್ವಾ?
I will,
ಇಲ್ಲ ಆಗಿಲ್ಲ ನಿನ್ನೆ.
including.
And AGA accepts notice for respond number 1, 2, 3, 4.
ಏನೇನ್ ನಡೀತಿದೆ ಅಂತ.
ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಎರಡಿದೆ.
ಅದ್ರಲ್ಲಿ
39
ನೋಟಿಸ್ ಆಗಿದೆ. 1, 2, 3, 4. Relist on
Monday, my lord, in the same category.
Monday 20th possible.
ಆಗ್ಬೋದು.
Earliest day.
20th means, my lord, 17th.
Thursday.
Tuesday at least, my lord, some urgency.
More than 125 matters on each of those days.
It may be
It won't reach.
My lord, the problem would be this, my lord, the after appointment of administrator, calendar of events have been issued. Process is commencing from.
Gopal, there are 125 matters already listed apart from fresh matters. Fresh matters on 40-50 ಇರುತ್ತೆ. So yours will go down to 175.
Be on Tuesday, I can take a chance in the preliminary hearing. Same
Tuesday,
Already started 17th is the last date for withdrawal of the nomination.
Thursday 20th.
Please.
May I make one submission? The government advocate, which is, I are directed to get the records on that day at least.
ಏನ್ records?
Original records relating appointment of an administrator is concerned.
Why would that be
The
required?
factual aspect we wanted to brought to a lot.
Why would that
We have
be
gazetted
required?
I will
already.
show it, my lord, I will show it.
No, no, no,
You
there's
show
nothing
it,
over there.
what happened,
Challenge the appointment of
why
the
all these
administrator.
things, it was held on 3/11, my lord.
Have you challenged the appointment of
Yes, appointment of administrator only challenged.
The proceedings is part of the paper book at page 42.
Now, they can get the records, there must be a record.
It's part of
A
the
report
records.
is also.
If there's anything extra.
So the only thing is,
The AGA is
let
right,
there not be
secure
an
the-
attempt to frustrate the ongoing process.
Only on that day. Today we are not taking and
Please.
keeping it with us. That won't happen.
Yes, my lord.
One more submission. If you file a nomination pursuant to calendar of events, it would not come in the way of prosecuting the writ petition.
Obviously.
They may not say that tomorrow. That kindly be absurd. Our submission may kindly be.
If you win, they will always, you'll withdraw the
Everything will be put
petition.
back.
ಅದಾದ್ಮೇಲೆ
Yeah.
the nomination-
If you lose, you will continue.
No, no, they cannot say that the nomination they have filed pursuant to our calendar of events, they esto put to content ಅಂತ ಬರೋದ್ ಬೇಡ.
ಅದೇನ್ ಬರಲ್ಲ. You are always free to do so.
That's an observation may kindly be recorded. My submission may kindly. be.
Last day of nomination ಯಾವತ್ತಿದೆ?
Last day of
Tomorrow-
nomination,
Tomorrow is-
tomorrow, my lord. Scrutiny is happening on 15th, 17th is the last day of withdrawal.
Lord AGA is right, secure the records relating to the appointment of administrator by next date.
ಮಾಡಿಲ್ಲ,
Counsel for
scrutiny
the,
ಆಗದ
Lord senior
ನಾಳೆಗೆ
counsel for the
15ಗೆ.
petitioner seeks liberty to participate in the elections without prejudice to the present proceedings. No such liberty is required to be made available any member of the society would always be free to participate in the election either by contesting or voting.
Please, grateful.
Records pertaining to government and also second respondent.
Registrar.
He has conducted inquiry, my lord, by issuing notice. Before him, we appeared. He has recorded some proceedings, my lord. That is also required.
Administrator.
Annexure, they have made that as a part of the paper book.
I have produced that document.
They say they have produced it.
What is there, let they can place it on record, my lord. We are not.
We can't do a roving inquiry into all these.
No, it is only inquiry report is not there. It is not given to us also. And the note sheet is there. In the note sheet, my lord, they made a request for us.
Mr. Rajgopal, only issue is 3 years from when to be calculated.
That I have got a.
We are
full
not
bench
going to
judgment.
be doing this kind of a roving inquiry.
Well, yesterday I rendered my exercise. I have got a full
As a
bench
body.
judgment. I will cite it. In addition to that certain additional fact, I advise to pleading, part of the pleading. For that, we require that information. That's the reason, my lord. Otherwise, I won't.
If you want any information, file under RTI. We are not going to do a roving
But in my
inquiry.
experience, I know what the file contains. But I am eager to see the file for my satisfaction.
RTI Act, not through this court. We are concerned with only one issue in this matter. 3 years, whether it expires on 11 or 12,
That I can
or
answer.
financial year, or calendar year.
That I have an answer based on the full court judgment of our court.
Courty.
I have got a judgment. I will cite it on that.
We'll consider it when you place it before us.
Grateful.
It is fully, that full court judgment is fully answered my questions and cleared the doubts of your lordships also.
Thankfully, ಭಾನುಪ್ರಕಾಶ್ ಏನ್ ಹೇಳ್ತಾ ಇಲ್ಲ. It doesn't ಅಂತ ಹೇಳಿ ಅವ್ರು ಶುರು ಮಾಡ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಾ ಇರತ್ತೆ. Do that on 20th.
D group matters, serial number.
Kindly pass over the matter.
Pass over. Ready?
Yes, your lordship.
41. TC Mallikarjuna.
Dispensation of annexure D and impleading applicant of respondent number.
Who is the impleading applicant? Who do
Respondent
you?
number 2.
Yes, to come preliminary.
Respondent number 2 is the present fair shop license owner.
What is this impleading application? ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡಬೇಕು?
The present fair shop license owner, ಯಾರು run ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Last date it was asked by the honorable court of Andhra Pradesh.
So notice has to go on this.
Yes, ma'am.
Issue notice on IA2 of 24, return number 24.
24 matter, date may be.
IA2 of 24, inna notice ಹೋಗಿಲ್ವಾ? Returnable by 16 December.
42.
IA1 of 24 is allowed. 42.
I appear for the respondent slumbered in this matter. My lord, I'm sorry, my lord, the objection is ready. I could not file it, my lord. Today, I'll file it, my lord.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
Illa, he is not available, my lord. He's online.
I
I tried to communicate it.
Bhagat, you are not available.
Allah, I tried to communicate it with his colleague, my lord. Her phone is not reachable, my lord.
I talked to his colleague. I told send by WhatsApp also. I told inform.
Coordinate ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು. What is this respond number 3? Who is respond number 3?
There's a board, my lord. Respond number 3.
Some board, my lord.
You can take notice for respond number 3 also. alva?
Yes,
No,
sir,
my
last
lord, yes.
time my lordship directed, my lord.
No, third respondent, MCT quarters, I'm not.
Yes,
my
sir,
lord.
there is a
Only for
run
his
by
second
them only, my lord. Last time order is passed, my lord.
Learned counsel for respond number 1 and 2 submits. That statement of objection will be filed during the course of the day.
Please,
After service, copy thereof on the counsel for the petitioner who in turn seeks for 2 weeks time to go through the same and make his submission. Relist on 2nd December.
Please, my lord.
Blessed, my lord.
43. Umesh BS.
Wish.
Petitioner, my lords, mandamus for consideration the representation, annexure A, suspension of fair price shop,
In what is the representation?
annexure A, my lord.
What have you asked for?
To revoke the suspension. Page number 13. my lord.
Revoke.
In 2018, our fair price shop has been suspended for some irregularity.
Well, if that is so, then they would have allotted. Who appears? 43. PDS. Suspension in 2018,
Yes, my lord.
representation in 21. No instructions.
No, my lord.
And AGA seeks fund is granted 10 days time to obtain instruction. If as regards action, if any, taken by a respondent pursuant to suspension of the license of the petitioner in the year 2018 and on the representation of the petition submitted in the year 2021, released on 1st December.
44, Manjula D.
My lord, in this case, it's a mandamus malone to direct the respondent to consider the representation. The facts of the case is that, my lord, the petition has released the amount of rupees 3 crore 95 lakhs for the purpose of construction of Hanganawadi, for the scheme of CSR, my lord. But as per the third party inspections report, as per Annexure J, my lord, that has not completed until direct to the respondent to consider the representation.
So what is your representation?
Please, represent.
What do you want?
Annexure K, my lord. In a report on submit ಮಾಡಿ work ಎಷ್ಟಾಗಿದೆ ಅಂತ ಹೇಳಿ. We have released the amount on, please, my lord, on 2019, my lord. As per Annexure E, my lord.
This is between a government organization and a government organization.
BBMP, my lord. For the purpose of construction of 7 Hanganwadi schools, my lord.
It will have to go before the committee constituted by a chief secretary. You should not be coming to court between government organization and government organization. I'll committee cuts.
It's only directions, directions and refer the matter.
So that that committee is
Already
sensitized to it.
5 years is completed as per
You have to
CSR.
inform all the government departments, madam, about the constitution of the committee. Ms. Kulkarni, you have to inform all of them. It's not proper for one government department to fight against the other before us. The petitioner is before this court seeking for the following reliefs. The dispute essentially is between one government department and the other and another. In terms of the Karnataka litigation policy, a committee has been constituted by the Chief Secretary, Government of Karnataka, which committee is required to consider any and all dispute between, intersay between government departments. In that view of the matter, the present writ petition is disposed, directing the said committee to consider the dispute between the petitioner and respondent number 2. Petitioner is permitted to place the dispute before the committee for consideration. The Chief Secretary, Government of Karnataka, is requested to sensitize all the government departments about the litigation policy so as to avoid these kind of litigations being placed before this court.
Within specific period, a committee has to dispose it of on.
Everything is there in that litigation policy. Chapter 5, full chapter is there.
Serial number 45,
This is for premature release, your lordship.
My lord, the board has rejected the premature release.
Board has.
Board is rejected.
Board has rejected.
Recommend, jail authorities have recommended, your lordship.
Jail has
No, my
recommended,
lord, it
board,
is not. Board
jail-
itself has rejected.
board, LCRC, then government,
It is not recommended. My lord.
give them a copy of the order.
Yes, my lord, that order may be passed.
Prayer is for parole, your lordship.
This premature release
Interim is for parole, your lordship.
and extend the general parole. Now that is, this one has been rejected, we can't extend the general parole.
They
Your
have to
lordship,
file
now
an
he is
another
inside since a
petition.
year. Last he was granted in 2024, your lordship.
Correct.
Now new,
Then file another petition.
Is, parole was granted because of the recommendation.
no, your lordship.
Now that it's not
No,
been.
your lordship, that is different, your lordship.
Huh?
After going to the jail itself, we have filed this premature
Where
release.
is the order?
Order is here, your lordship.
Earlier order?
Your lordship. Here, your lordship. Memo.
Third. Now where is he? Is in jail or is?
Inside the jail, your lordship. September 2024, he was granted parole, your lordship.
Obtain instructions, madam. Learned AGA submit that the application for premature release submitted by the petitioner has been rejected by the advisory board, and that a copy thereof would be furnished to the petitioner or the council within a week from today.
Yes.
Insofar as parole is concerned, she seeks for and is granted 10 days time to obtain instruction maker submission. Released on 1st December
Yes.
at 2:30 p.m.
And there is no ground with respect of the parole, my lord, in the petition.
Your Lordship, I have
There is
given
no
now-
reason mentioned.
Your
in the
Lordship, it
petition.
was for premature release, that's.
It's
File
only for
another
that.
petition.
No, no, Your Lordship, I have given the memo of medical, Your
Let
Lordship.
them file another petition or give a requisition to the jail
Have you
authority.
even applied for parole there?
Yes, my Lords. Please, my Lords, I have applied.
You applied.
I've got a.
With premature release and parole together you applied.
No, Your Lordship.
Undoubt-
Premature release is different, Your Lordship. We have applied for parole, Your Lordship.
If they applied, consider it. Illa andre they'll lose 15 days time.
We have applied, Your Lordship. We have got the endorsement also, I have produced, Your Lordship.
Yes, next.
46 urgent, 47.
The petition of Millard. And for the respondent number one, Your Lordship, but there has been a mistake in the wakalat, Your Lordship. We had R2 ಅಂತ ಹೇಳಿ ವಕಾಲತ್ ಹಾಕಿದಂಗಿದೆ, Your Lordship. ಆದ್ರೆ R1 Your Lordship ನಾವು.
R1 ಯಾರು?
R1 is a KUDFC, Your Lordship, Karnataka.
Urban Infrastructure
Yes, Your Lordship.
KUIDFC.
Yes, Your Lordship.
Commissioner City Corporation Vijaypura.
ಅವರಿಗೆ ನಾವು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ, Your Lordship.
Tata Consultancy. So ನೀವು KUIDFC ಗೆ ಮಾತ್ರ
Yes, Your Lordship.
R2 ಗೆ ಯಾರು?
R2 has not yet appeared, Your Lordship.
So you undertook to file and there is a
No,
mistake.
we didn't take undertake, Your Lordship. R2 ಅಂತ ಆಗಿದೆ ವಕಾಲತ್ Your Lordship ಅದು.
So who
Presentation
appears for
R1.
respond number 2?
Respondent number 2, Subhash has filed a wakalat. We filed a wakalat for R1, Your Lordship.
R1 they have filed.
Yes, Your Lordship. The wakalat Your Lordship, see. On record shows R2 also. R2 ಅಂತ ಒಳಗೆ ಮಿಸ್ಟೇಕ್ R2 ಅಂತ ಬರ್ತಿದೆ. Presentation R1 ಅಂತ ಬರ್ತಿದೆ, Your Lordship.
He is not a standing counsel for R2. How will he file? We'll ask you to file for so many then. Registry, correct the appearance of Shri Santosh Nagrali as that appearing for respond number 1. City Corporation Vijaypura ಯಾರು?
ವಿಜಯಪುರ ಅಂದ್ರೆ ದೇವನಹಳ್ಳಿನ ಇನ್ನೊಂದು
ಯಾರು?
ನಾಗರಾಜ್ ಜೈನ್.
ವಿಜಯಪುರ ಅಂದ್ರೆ
ಸಿಟಿ ಕಾರ್ಪೊರೇಷನ್.
CMC ವಿಜಯಪುರ ಇಲ್ಲ. ಯಾವ ವಿಜಯಪುರ ಇದು? ಬೆಂಗಳೂರು ಹತ್ರ ಇರೋ ವಿಜಯಪುರನ? ಅದಕ್ಕೆ ವಿಜಯಪುರನ ಅದು ವಿಜಯಪುರ ಇದೂನು ವಿಜಯಪುರ. This may not be.
This is not this Millard, Vijaypura Corporation.
Vijapura.
Yes, yes.
Vijapura, now Vijaypura.
Yes, Vijaypura. Notice has been served and
Ratna Shivogi Matta. But then that would, what is this matter about?
Look, make one short submission.
Huh?
Insofar as respondent number 3 is concerned. Not respondent number 3 is neither a proper party nor a necessary party. But I was a project consultant. I have issued a letter. Based on that, the repetition is now filed. Not the contractor was entitled to.
You certified the bills.
I have certified that that letter is there on record. I don't have beyond that letter anything to explain.
You came here because that's.
no relief is claimed, Millard. No relief is claimed.
If this matter goes on.
If they had not made you a party, you would not have come, Mr. Gade. Now let us find who is respond number 2.
ಅಮರೇಶ್ ಎಸ್ ರೋಜಾ.
Amresh Roja, Kalburgi. He is a standing counsel, but he is in Kalburgi. Notice has not gone to respond number 2.
Yes, Millard, notice is heard. If I may make a submission, Lordship, by next date we'll ask Lordship to file wakalat, Lordship.
You are KUDFC, how will you go to Vijaypura? Notice I ಹೋಗಿದ್ಯಾ?
ಚೆಕ್ ಮಾಡಿ.
As per the contract, there is an entitlement for bonus. If the project is completed ahead of time, that is the certification by me.
He is only asking for a mandamus. We can issue it only after service is effected. He is not asking for payment.
He is asking for payment, Lord, look at the player, he is saying direct them to release the payment.
That Consider the bills ಅಷ್ಟೇ. ಏನಾಗಿದೆ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಇಶ್ಯೂ ನೋಟಿಸ್.
15/5/2020.
ಆಮೇಲೆ ಏನು ಗೊತ್ತಿಲ್ವಾ? Issue notice to respond number 2 returnable by 15 December. Sri Amresh Rosa, Standing Counsel of respond number 2 is also directed to accept notice for respond number 2. Counsel for the petitioner to furnish 2 sets of the petition along with copies on Sri Amresh Rosa. Process fee and copies to be furnished by end of day 14th November. You come once more.
Oblige, my lord.
Much obliged.
48.
Well, it's appearing for the respondent bank. We are filing wakalat for respondent bank in serial number 48.
For State Bank or IDBI?
State Bank. We are filing wakalat.
You are?
We are filing wakalat.
Vinay Bhatt?
No, for Nandish Patil. For Nandish Patil.
Nandish Patil. Submit that he is filing wakalat number for respondent 48. Registry is directed to file it in the registry.
Please.
Directed to print his name as such once wakalat number is filed. IDBI MG Kumar. ನೀವು appear ಆಗ್ತೀರಾ?
10570.
Please. 10570.
My lord, in this case, now that IDBI Bank has been made as a respondent. IDBI Bank, this government of India, 2004, formed a trust known as Trust Asset Stabilization Fund. And what about 9,000 crores NPA accounts have been transferred to this as per the direction of the IBA. So from 2004 onwards, then this entire that NPA.
What is this matter? Surface matter?
My lords, what has happened is we had sought for a loan.
Is it a surface matter?
No, it is not surface matter.
No, my lords, I have prayed for a mandamus for considering the representation made in the letter, my lords. I want no objection certificate from the respondent bank to show that
cleared the dues.
Please, I have satisfied the charge that has been reflecting upon the MCA portal.
48.1. 48.1, you have made IDBI a party.
Please.
What's your submission, Mr. Muthana?
My lord, that
Trust Asset Stabilization Fund.
Trust Asset Stabilization Fund has to be made as a party. Because IDBI has nothing to do with that. Because they sanctioned.
Is it a separate entity or under IDBI?
No. Not IDBI. That government has formed the trust and this entire account has been transferred. That is a separate entity. Nothing to do with IDBI. Because now all these details, what now they have mentioned that one in the petition that they have written a letter to the SAFC, that is Stabilization Assets Stabilization Fund. So those people will be able to tell exactly what happened to that.
No, my lord.
700
Any
crores.
particular counsel for the SAS?
No, I only appear.
You only appear?
Yes.
So we'll make you a party, you only appear.
ಅದು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ.
ಮಾಡ್ತೀವಲ್ಲ.
IDBI ಗೆ ಹೋಗ್ಲಿಕ್ಕೆ.
If I make a submission, my lords.
TP Muthana, that council submits that all the stressed assets of IDBI have been transferred to the Stressed Asset Stabilization Fund.
NPA, not
the NPAs
NPAs
of IDBI have been transferred to the Stressed Asset Stabilization Fund.
As per the direction of the government.
As per the government of India. And that the account of the petitioner also being NPA had been transferred to SASF.
Yes, ma'am.
In that view of the matter, the Stressed Asset Stabilization Fund is brought on record as respond number 2. Shri TP Muthana accepts notice for respond number 2. Counsel for the petitioner to carry out necessary amendment and file amended cost item.
Yes, ma'am.
ಇವಾಗ ಏನ್ ಹೇಳಿ ದುಡ್ಡು ಬಂದಿದ್ಯಾ?
ಏನು ಮಾತಾಡ ನಾವು this issue, my lord, this has to be reconciled. That is why, my lord, if Stressed Asset Fund also requires at least 1 month time to reconcile, because that is only the question is they have given the money, but they are unable to trace now because that they given the money to the IDBI bank or this year we do not know because the IDBI bank has sanctioned.
Now we have both IDBI and SASF as parties.
ಅದೊಂದು
Any borrower has paid, you should give the certificate.
time for reconciling the account. That is all I ask.
How long will you take for
1 month?
I pray for 2 weeks time.
You will reconcile in 2 weeks time.
Let's have an instruction that
1 month time.
That's one humble submission, my lords. I've already produced in Annexure D, my lords, a letter by
You have to
SASF.
reconcile their account
Reconcile.
and
That
give
is
you a
what-
certificate.
They themselves have given me a letter saying that there is no more loan remaining for me to repay, and everything has been satisfied.
Mr. Muthana submits that it will take around 4 weeks' time for reconciliation of the accounts. And he would be in a better position to make a submission after such reconciliation. Relist on 15th December.
Grateful. Great. Sir.
Serial number 49 adjourned. Serial number 50. Pradeep ji, party in person.
Pass over, madam. Respond number 2, pass over. Yeah, Kappa.
This honorable court counsel is permit to file a written argument.
May I make one request? Engaged Mr. Manmohan in this matter, IPF for the second respondent. Today, some inconvenience, Lordship, to have it.
Party in person is here. You can't be asking for time.
No, it's only today, my lords. That's one of the reasons.
Madhyana Barli.
Today, some inconvenience.
He's not there in Bangalore?
My lords, he is there, but afternoon he has some inconvenience. Otherwise, I would have agreed for Passover, my lords. That's one of the reasons. Lordship, have it on Tuesday.
By the time, kindly this honorable court permit to file a written argument.
You can file your written. You don't want to argue, you want to file your written.
Nothing, let them first finish.
At the request of counsel for respond number 2, relist on 20th November.
Obliged.
Please.
51. Lakshmi Kante.
For petitioner, parole, Mila. His custody in 2 years, 11 month custody, Mila.
Received instructions, madam?
Wife is a petitioner.
Any objections?
My lord, it was rejected only for the adverse police report, my lord, as he has completed 2 years.
2 years?
2 years and 6 months.
2 years,
my lord.
till today 11 months. Mila.
On that day, my lord, it was
Where
only
is your
2 years, 6
certificate?
months.
Page number 8, Mila.
Other Lafa, where is your
Imprisonment certificate.
prisoner
Hakilla.
certificate?
No.
Prisoner certificate, Ellie.
Annexure. Annexure D, Mila. Annexure D.
It's not there. You have to file your prisoner certificate. That's where we'll get to know what has happened.
Can you have it on Monday, Mila?
First application of Parole. File. Land counsel for the petitioner seeks for and granted a week's time to place on record the prisoner certificate. Relist on 20th November.
52. Sushant Tiwari.
For respondents 1 and 2, please.
My lords, the petitioner, my lords, were all depositors in a bank, my lords, Cooperative Society Bank.
Cooperative?
Yes, my lords. Cooperative Society Bank, my lords. The bank, my lords, was operating, my lords. Now, my lords, because of the mismanagement of the bank, the RBI interfered and imposed, my lords, a condition under section 35A saying that the depositors can only withdraw 5,000 rupees. And my lords, a moratorium was placed on the operation of the bank.
Prayer sought for against Sushruti Sawadra Sahakara Bank, Cooperative Bank.
Yes, my lords.
They'd like to go before the cooperative.
No, my lords, it has nothing to do with the cooperative society. It's to do with the DICGC, my lords. What has happened, my lords? I'll just give a background, my lords. Now, when the restrictions were placed on the operation of the bank, my lords, the depositors were allowed to withdraw 5,000 rupees. That's the annexure A, my lords.
Yes.
Now, my lords, because of this mismanagement in the bank, my lords, the DICGC, my lords, Act was amended in year 2021, which says, my lords, when the bank has been placed under a section 35A moratorium by the RBI, the depositors, my lords, will be entitled for a insurance money that is up to the tune of 5 lakhs. This got amended, my lords, in the year 2021. Now, my lords, this time period that is stipulated, my lords, is 90 days time period. May I just please look at, my lords, annexure A for a minute, my lords.
Yes.
Yes, my lords. On April 7, 2022, the RBI, my lords, places restriction on the operation of the bank. And the depositors, my lords, at item 1, my lords, for the present maximum amount of rupees 5,000, whether from savings bank, current account, recurring deposit, or any other amount, may be allowed to be withdrawn by the depositors. Now, may please turn page, my lords, page 63. Point number 2, my lords, para 2. Para 2, my lords, at page 63. The bank shall, in compliance with the provisions of section 18A of the Deposit Insurance and Credit Guarantee Corporation as amended by DICGC Amendment Act 2021, furnish the Deposit Insurance Credit Guarantee Corporation a list of showing outstanding deposit of each of the depositors and certified to be correct by executive officers within a period of 45 days from the day of this direction. Please look at annexure B, my lords, the time period.
Yes,
This is from DICGC to the administrator, my lords.
To the DI. Who is going to give this in compliance so and so, so and so?
The bank, my lords.
Who is to give this?
The
list?
bank is supposed to give a list of depositors, my lords,
Shall
to the.
a list showing the outstanding deposit of each depositor certified to be correct by CO within 45 days. So when was this? This is from the date on which the act came into force.
Yes, my lords.
Or from the date on
2020.
which the order was
Yes,
passed,
my
whichever is
My lords, the timeline, my lords,
AID.
please look at the timelines, my lords, annexure B for a minute. So may I just finish it? Please, annexure B, so the last sentence. Please note that the effort, page 65, my lords, last sentence. Please note that the effort shall be taken by the bank to obtain the willingness as and KYC on all eligible depositors by submission of claim list to DICGC within 45 days from April 7, 2022. So that is, my lords, 21 May 2022, so that the eligible depositors to get their claim amount within 90 days period mandated in the act, that is 5/7/2022. So 90 periods, my lords, gets over on 5/7/2022. No, my lords, may I just take, my lords, the entire time period, my lords, under the section 18A is 90 days period, my lords. Now, my lords, the contention by the DICGC says, my lords, that the certain claims by the bank were given to them after the 90-day time period, hence they cannot condone the delay, and hence, my lords, the depositors are not eligible for insurance. This is this time
delay by the bank who is already in default.
And my lords, the bank also explains why there's a delay, my lords. May I just please turn, my lords, to page as to the annexure J, my lords, as to what is the state of affairs right now, my lords, by the bank. Page, my lords, that would be 119, my lords. And the bank, my lords, explains the delay also for that matter. Please look at, my lords, annexure J. This is from the bank on 22nd of May 2023, February 2023. With reference to the above subject, we wish to inform you the following claims have been pending and there's tremendous pressure from depositors for the settlement of the amount due. The details of pending claims are as under. Pending out of the first batch out of 199 depositors, claim amount of 8 crores. Completed the audit and the same has been reported on 17/1/2023. Second batch claim of 823 depositors, that is 15 crores, not audited. As per your email dated so and so, we have referred to communicated that claim furnished beyond the statutory time period of 45 days, imposition of AID shall not be considered by the corporation. In this regard, we would request your good self to look at the following. The first batch of claims have been sent on 21st May 2022, which is well within time, my lords. The second batch has been sent as per the balance on 5th July 2020, that is the last date. Further, we have been permitted to furnish the depositor list by end of 21st July 2022, because they, my lords, on 4th July, say, my lords, you can submit your claim after the 5th July 2020, after a period of 90 days, by on or before 21st July 2022. Accordingly, we have submitted the total depositor list on 10 June 2022 via email to the auditor appointed by DICGC. We included all the depositors, including 823 claimants in second batch. Further, we have requested the 8th August 2022 via email to provide a further time to submit the data in required format. So second batch list and all depositor lists in required format has been submitted on 5th November 2022. The delay in submission of a claim in respect to second batch was due to delay in submission of claim from depositors, which was again due to the delay in communication to depositors, that is by the bank, my lords. The bank could not communicate to the individual depositors well within time as there was change in the phone numbers of some of the depositors and the change in the address. In view, we request you to condone the delay and settle the claim of second batch to the tune of 15 crores, and we request to expedite 8 crores, my lords.
So you are part of 823?
Yes, my lords.
Yes. Which has been submitted and there is no
Yes, my
dispute.
lords. Because most of them, my lords, they did the claim submission, my lords, well before 5th of July 2022. It is the bank, my lords, which has failed. But my bank is completely mismanaged. And an administrator is appointed by the government, my lords. He had to go through the accounts, he had to reconcile the accounts, everything had to happen. And my lords, because of this reason, my lords, today the depositors who are in the twilight of their life, my lords, are told to withdraw 5,000 rupees, my lords. All their life savings are in that account.
What has happened to the bank now?
The bank, my lords, is, my lords, the RBI placed the liquidation, my lords, but liquidation subject to challenge in this court. And that liquidation is stayed, my lords. My lords, that is the internal dispute between the bank and, my lords, all those things. But I, my lords, as retail depositors.
We are thinking of your balance money. You will only get 5,000 here.
Yes, my lords. And today, my lords, I have to get, my lords, to the tune of 5 lakhs. It's not that, my lords, whatever amount that I have in the account, that is not, my lord, all I'm getting by insurance corporation. And, my lords, the insurance corporation, my lords, will be able to reclaim this by the SLR that is prevalent in the bank.
Yes, Mr. Commissioner, you are appearing for?
My lords, I appear for the
respondent number
1 and DICGC and the RBI in this matter. Lords, what has happened here, please kindly see that, for only respondent number 1, I'm sorry. Lords, there are 2 provisions in the DICGC Act relating to payment of insurance deposits. If my lords kindly see it. Now what has happened, my lords? There is section 18A, my lords.
That's at annexure D, my lords, page 109. The amended
109.
act. No copy. The full act, my lords, annexure C. Page 109, my lords. Amended act. At page 1110 is the relevant portion, my lords.
10?
110, annexure D.
Section 18A is at page 110, my lords.
18A.
Yes, my lords.
Yes. Insertion of new section 18A.
Yes, my lords. 18A, my lords, provides as follows. Where in respect of an insured bank, any direction is issued or any prohibition or order or scheme is made under the provisions of the Banking Regulations Act 1949. And 2, such directions, prohibition, order or scheme provides for restrictions on depositors of such bank from accessing their account or for their deposits, then without prejudice the provisions of sections 16 to 18, the corporation shall, on the date of which such direction, prohibition, order or scheme takes effect, become liable to pay to every such depositor an amount equivalent to the amount payable by the corporation to the depositor under section 16. List showing the outstanding depositors of each depositor of the insured bank as on the date on which the direction, prohibition, order or scheme referred to in subsection 1 takes effect shall be furnished by such insured bank within 45 days of such date of effect in such form and manner as may be specified by the corporation and certified to be correct by the chief executive officer of the insured bank. So what happens is when the AID, in this case an AID on an all-inclusive direction has been issued by the RBI against this cooperative bank, this took place on 8th of May 2022. Minutes. The statute provides that they should make through the bank an approved list along with consent of the depositors. They are supposed to submit it to the DICGC within 45 days. Minutes. Now, what has subsequently happened is the first stand that the DICGC has taken insofar as some of these depositors are that this information, it is not necessary only submission, my lords. If my lords would recollect the letter that was read out by my learned friend, the bank itself has not been able to communicate with the depositor. But nonetheless, the difficulty today that arises is that a subsequent claim of a batch of depositors has been made beyond this statutory period. And we have indicated. So now the bank has now been directed to be wound up. That order of winding up, the RBI directed winding up of this bank on 4th of July 23. Then subsequently, the Registrar of Societies has passed an order of winding up and a liquidator has been appointed. Now what happens then, please, my lords, is section 16 is triggered of the Act. Where an order for winding up or
Surely you will not
liquidation...
challenge the Act. The mandamus that you are seeking for is contrary to the Act.
Yes, my lords, that is, my lords, but may I please,
Yeah,
my
I'm
lords?
still, my lords, submitting that they still have the opportunity under section 16.
So that they will have in liquidation.
Liquidation.
But this 5,000 is guaranteed.
ಇಲ್ಲ ಇದ್ರಲ್ಲೂ 5 lakhs ಬರುತ್ತೆ 16 ಅಲ್ಲೂ may I read?
Guarantee
ಅದು
ಇದೆಯಾ?
ಹೌದು ಅದಕ್ಕೆ.
We don't have 16.
No, 6, no, I have produced the Act, my lords, annexure.
ನಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
May I just place, my lords?
You have produced only the amended Act.
No, my lords, I have produced the entire Act, my lords, just
Page?
annexure. Annexure C, my lords, is an entire Act.
Annexure
Page
C
69,
is
my
the
lords.
entire Act. Section 16, huh?
Section 16, please.
Yes, liability of corporation in respect of.
Where an order for winding up or liquidation of an insured bank is made, the corporation shall, subject to the other provisions of this Act, be liable to pay every depositor of that bank in accordance with the provisions of section 17, an amount equal to the amount due to him in respect of his deposit in that bank at the time when such order was made, provided that the liability of the corporation in respect of an insured bank referred to in clause A or clause B of subsection 1 of section 13 or clause A or B of section 13C shall be limited to the deposits as on the date of the cancellation of the registration. Provided further that the total amount payable by the corporation to any one depositor in respect of his deposit in that bank in the same capacity and in the same right shall not exceed, now with effect from February 2020 is 5 lakhs of rupees. Now what is now therefore required, my lord, my humble submission would be that the relief that are available under section 18 may not be available after the order of winding up has been passed, and whatever action has to be taken will be under section 16.
Probably both Reliefs would be available under 18 and 16.
That is the time period, my lords. Once the AID is in effect, 18 will immediately kick in, my lords. They are supposed to make the.
That 5,000 they should have got.
No, 5,000 in any case they would have got, but this is an insurance of 5 lakhs. 5,000 is the immediate requirement without any further action from my side, or the bank has to release that.
5,000 will be deducted from 5 lakhs.
Yes, madam.
Yes. So totally
net effect is 5 lakhs.
5 lakhs they will get, my
So
lords.
now if they go under 16, they'll still get.
That 5 lakhs.
Bro, the problem is, my lords.
Now what has happened, my lord? There is the piquant situation here. Subsequently, after the order of winding up that has been passed by the through the RBI and the Cooperative Societies Department, the bank has come before this honorable court in writ petition 5930/24, my lords. In that matter, there is a direction of this honorable court against the liquidator not to take precipitative action. So now what has happened? The liquidator otherwise could have acted under section 16, and I could have considered it. But because of that order, I think there may be some difficulty for the liquidator.
Would that order come?
Liquidator has to submit that, my lords. The liquidator under section 16, he will have to submit that data to say, I am making a claim under
930 GMRS.
Yes, please. How
we'll connect this.
Lords, may I say this, my lords? Please look at my lords.
He's giving you a very good solution.
No, my lords.
Did you understand this solution?
I'm grateful, my lords. The reason is this, my lords. The mandate of 90 days was getting over on the 5th of July 2022, my lords. My lords, they on their own volition, my lords, extend the time period till 21st July 2022. My lords, it is not that the my lords have submitted some of my claims.
So shall you want 5,000 or you want 5 lakhs?
No, I want 5 lakhs, my lords, because my lords.
Then connect the above matter with
the problem is this, my lords.
5930 of 24, my lords.
Of 24 and relist on 26th November.
It's not that my instructions are, it's not that we would like to deprive these depositors.
This provision, Mr. Kamal,
my lord,
it is asking the obligation is on the bank to submit.
It
is the bank is already a defaulter. You want the defaulter to certify what payment is to be made. They're a little far-fetched.
So that is under 18, my lord.
18.
16 is the liquidator can do that.
But that 18, you should permit them to approach you directly.
But we don't have that information. My lords, we don't have the information. My lords, the bank will have to give the list of the depositors, some identity, plus most important is also the consent.
All the offices of the bank have scooted.
I quite understand. Well, that's
most of the time, all the directors would have
unfortunately,
scooted,
our hands are tied by
and
this.
you won't get anybody.
No. Unfortunately, our hands
KPID,
are
that
tied.
is, everything is happening. And to put that responsibility on the bank to give you a certified list may not be a proper way of doing it.
I understand, my lord, but then once the AID is issued, my lord, it becomes public information. The bank will know, the depositors will know. They have it's not that they have, according to them, the bank itself has delayed a little bit, but nonetheless, the corporation's hands in these hands.
Should you also not permit the depositors to approach you directly with their documents?
Then the corporation will be put on the of the responsibility to verify who each of them are. So therefore, that requirement is that the bank, the CEO, and the auditors of the bank will certify all
to
these.
Stop that limitation running.
Please.
Verification is later.
Please.
To stop that, because now you are saying within that 45 days,
It has to
it has not happened, and limitation you say cut off. So at least to stop that, if any depositor is aware of it, they can always approach you. Then you can do your verification.
But today,
if you don't want them to come to you directly, but through the bank, and the bank is missing in action.
But today the statute is such that I can't.
That is why we are so sure. Haven't you challenged it?
My lords, the problem is, my lords, it's a lawyer's paradise to challenge, my lords, but the depositors who are in twilight of the career, lords, they would request medical.
But can a mandamus be issued against the statute?
Lords, may I request this, my lords? Anything submitted prior to 5th July 2022, my lords, let that be cleared, my lords.
Let us connect that and see what we can do there.
Please.
Here's the number I write, 26.
5930 of 24.
Yes.
Date 20?
26th.
Great.
I'm grateful.
53. K. Prasanna Shetty.
For respondent 2, my lord. Seeking time to file objection, my lord.
Counsel for respondent number 2 seeks for and grant 2 weeks time. to file a statement of objection. Objections, if any, by 1st December, relist on 9th December.
Please.
54.
Yes. Forest. ಏನದು ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕಾಯ್ತು. One week ಆಗತ್ತಾ? Now DG submit that survey has been conducted. Seeks for a week's time to obtain instruction, make a submission. Relist on 27th November.
55.
Lord, appearing for the petitioner, my lord.
Yes.
Appearing for the
Lord.
respondents. This petition is filed seeking mandamus from the respondents. The petitioner is a Gabon national who had applied for visa and she was blacklisted. My lords, the child is in India, but the mother is abroad and her visa is blacklisted. She entered the country with a valid visa on in Annexure A, my lords, which is produced in Annexure A. And later on, she overstayed for 10 months, but she got a valid exit permit and then exited the country. Now is a situation where the child is in India, but she is abroad and the visa is not granted to her and blacklisted arbitrarily without any reasons, my lord. And she had set up a company here for medical tourism and it has contributed to the economy of this country too. But without any reasons, she has been blacklisted by the respondents, my lord. Therefore, had issued a representation. I'm just praying for that representation may be considered.
Yes, Your Lordship, if I may. Your Lordship, with regard to the preliminary objection, with regard to the maintainability of the petition itself, Your Lordship may kindly see the power of attorney which he has sent from her country, which is the last document, Your Lordship may see. It is at page number 26 and 27. This has been executed outside India. Your Lordship, the coordinate bench of this honorable court has held that any power of attorney issued by a foreigner from outside India, if it has been sent directly, will not be taken into account to invoke the extraordinary jurisdiction of this honorable court. If I may just pass on the judgment, Your Lordship, in case of a similarly placed foreigner outside India. Para 9 of the judgment, Your Lordship. In fact, the pending matter which was referred to in this, Your Lordship had disposed of that matter as well. So para 9. The other issue is whether a foreign national can execute a SPS sitting elsewhere in the globe. In furtherance, Your Lordship, the law will not leave anybody remediless. So there is the possibility of an apostille. Under the Hague Convention, the person who's residing outside, if he executes any document outside India, has to get it necessarily apostilled from the Indian consulate and then send it. Only then can it be accepted within the country. Your Lordship may kindly see a similar provision from MEA's website. Your Lordship, I've just downloaded it now. I'll share everything.
This has been notarized.
It has been notarized, but it has not been apostilled. There is a need for that. Your Lordship,
Apostillation is for Indian citizens?
No,
or
for foreigners and Indian citizens abroad. So they can either give it to the Indian consulate or any country which is party to the Hague Convention. They can go to their embassies also and get it done. Specifically for power of attorney, Your Lordship, it is quoted there.
Coordinate bench has held it.
My lord, I have not been served with the judgment. I'll just see it and make my submission.
See the judgment, but you'll probably have to comply with that.
My lord, I'll comply with it, my lord.
Small
So there is
formality,
also
comply with it.
alternative remedy. There is a review committee in the Ministry of Home Affairs. They can also approach them with regard to the blacklisting. They are aggrieved by it.
Why have you blacklisted?
Your Lordship, there was an overstay, an unauthorized stay. There was an overstay of 5 months for which we have taken a fee as well, which is there in Annexure C.
Yes.
And thereafter, there was an unauthorized stay. We cannot regularize the stay beyond 1 point. So we can collect a fine till 1 point. Beyond that, we cannot. So for that purpose, because she had paid the fees, the blacklisting has been done for 1 year.
Any particular complaints, any particular issues?
Overstay.
Apart from that,
Your Lordship, there are some visa violations also.
what are the
Which are there? Your Lordship, I've just been given the instructions. I'll just pass on the instructions also.
No copies being
any
served to me.
serious issues?
Wait. Your Lordship, at Para 2, she initially came on student visa, then tourist, and then business visa. The latest entry in India was on a business visa, which was issued for a company called Grace Healthcare for selling medical equipment. And the permitted activities were sale, purchase, and trade. That's it. So there was a violation of that. These are all things which we came to know, Your Lordship, after they gave the birth certificate in the writ petition. Before that, we did not even know about the birth of the child here. They have not even gotten the child registered here, which is mandated. The child is not a citizen of India by virtue of birth. Both parents are foreign nationals. That violation will also be on the head of the
serious
parents.
Issues.
Lord, I've not been even served a copy. I need to see order and seek
File these
instructions.
objections. Counsel for respondent seeks for and is
Your
granted.
Lordship, with regard to the preliminary maintainability itself.
He'll comply with that. That's easy to comply. Pays it so that he can go and file a review. Seeks for and is granted 2 weeks time to file his objection. Counsel for the petitioner also seeks for and is granted 2 weeks time to comply with para 9 of the order dated 24th April 24, WP 11952 of 2024, released on 9th December.
Much of it.
56, Abhishek here.
Respondent number 2.
I appear for the petitioner in this matter.
Yes.
Petitioner, my lord, is a platform, my lord, for online gateway payments and aggregator, which basically facilitates.
Sorry?
The petitioner, my lord, is a platform for online gateway payments. It basically collects all the funds and pulls it into one nodal account and facilitates various merchants' payments, accepts and disperses various payments. So the petitioner, my lord, received various complaints saying that there are certain fraudulent merchants activities that are happening, and there was a crime that was registered. A crime, my lord, was registered, and certain liens were marked, my lord, on petitioner's accounts. Now the total fraudulent amount, my lord, that was these amounts, my lord, were part of the earlier writ petition as well, which your lordships will find at page 45. The total lien amount that was earlier marked. Why I'm bringing this to your lordships' notice is, my lord, these subsequent accounts which I'm before your lordships now, these were by oversight not made part of this earlier writ petition. The earlier lien that was marked, my lord, were about 94 crores. But that was a lien that was marked. But the total fraudulent amount was only 1 crore 61 lakhs, out of which, my lord, the state has admitted that para 4 your lordships may see at page 47. The petitioner submitted an application dated 9/10/23 to the investigation officer stating that no amount is standing in the 5 CID accounts which were ordered to be frozen by the IO. The petitioners have further explained that the amount of INR 1 crore 61 lakhs 80,000 which was deposited in 5 CIDs was transferred to the ED in Bangalore, so and so, on 17/4/2023. The learned SPP does not dispute the amount of 65 lakhs. This amount, my lord, out of 1,61 lakhs, that is the fraudulent amount, 65 lakhs, my lord, was already transferred. It has already been settled. The present prayer in this present petition is about 62 lakhs, my lord. That is an additional lien that is
From
marked.
where did you get those amounts?
My lord,
Who transferred that amount to you?
I'll point out, my lord. If your lordships will see my writ petition, my lord, at page
So you are
9.
only a portal.
Yes.
So your portal is used only for payment. How will you receive any money?
So the amount comes to our account first, the petitioner's account.
Yes.
From that account, my lord, it gets dispersed into
Transferred.
various accounts.
Hmm.
So now that is my case, my lord. The liens that are now marked, I'll just point out at page 71, my lord. I'll just show my lords the flow of chain in which the
Yes.
this is a representation that petitioner, my lord, has written to the CID officers. At page 73, my lord. So starting from lien of 3,87,000. The 62 lakhs that is before your lordships is an amount that is not even with razor pay. That is not even with the petitioner. This is an additional lien that they have now marked. That is my case, my lord. Because this lien of 3,87,000 or a lien of 29 lakhs and lien of 30 lakhs, my lord, all of this has come into various different merchants and left the account of the petitioner. We don't have any of this. And this 62 lakhs that is now additionally marked on me is causing a lot of problem to my business. And this disputed amount is already
They are
settled.
only an aggregator.
It's for state to,
Who are
for the
you?
bank. I will comply with any
You are for
direction
the
that. Bank. Yes, ma'am.
So that this is a aggregator. Their platform is used for people to do transaction. Either use a credit card, debit card, bank account, NEFT, RTGS, or any wallet. That transaction flows through, they'll charge the 2% or whatever 1.75%, they'll charge for it. It's only a platform which is used by people for making payment. For their amounts out, that amount has come from their own Visa card and gone off, or from their bank account and gone off. Iವ್ರ ಹತ್ರ ಏನು ಉಳಿದಿಲ್ವಲ್ಲ? How do you mark a lien on their account? So this 65 lakhs is part of your commission charges, or what is it?
No, this is not part of the commission
Yeah.
charges.
Permitted minutes. Initially, minutes before the CID, I'm the complainant.
Ah.
Stating minutes, many of the merchants has onboarded. Minutes, they have onboarded for some other reason. They have started using for some other reason. I am the complainant in the CID before. Minutes, the lien was marked for the amount which I have given the complaint. The entire amount which was lien minutes has been transferred to ED. That minutes the
So where did that amount come from? What is that amount?
minutes, all merchants minutes who are boarded.
Nah.
Minutes, they have made a transaction now on their account minutes, whatever the amount was there, minutes, it was lien and transferred to ED.
Yes.
That is not in dispute. Minutes. The entire amount what's supposed to be alleged minutes has been transferred to ED now.
Yes.
Minutes, now on the instructions of minutes, the CID now, they have liened such an amount. Minutes, which this honorable court minutes by order dated.
Yes.
28
We saw
November.
that order. That's why we are asking them how they can mark a lien on your account.
I had given
It's
a
only an
complaint.
aggregator.
Since I have given a complaint, minutes, they have marked it. Minutes, now the amount is transferred to ED now. That is not in dispute. Minutes, now they have given an email communication. Minutes, these additional numbers which are there, minutes, 63 lakhs has to be dealing. That's it. It's covered by the order of this
The same
court,
order.
minutes, at,
But you can't be marking for this.
Minutes, it's our mistake, minutes, because before the order itself, this was there.
No,
It's
that is
not been
fine.
communicated.
We are not on that. We're on how, if somebody else has used for transfer, What is the 65 lakhs? Is the commission that you charge or what is it?
My lords, it's a pool account, my lords. All the merchants' money will be there. Whatever I have received from the merchants also, my lords, it will be there. to make
Before the onward transfer?
Yes.
Please.
So
Commission amounts also, my lords,
the interregnum, the interim period.
belongs to the merchants also. Some of the amounts which is being there will be in the nodal account.
It's a nodal account, my lord, where all the three merchants who are now accused transaction, that all their money will be in our account in the name of the petitioner.
For that period?
Yes.
Before the transfer happens?
And my
So-
lord, it's arising out of the same crime number also. So this amount has already been cleared, that 65
The
lakhs.
petitioner is before this court seeking for the following reliefs. A similar matter, the very same matter had been dealt by a coordinate bench of this court while it's ordered dated 28 November 2023 in WP number 17412 of 2023. The submission of learned counsel for the petitioner is that the amounts now, then the amounts as regards which now a lien has been marked, he is also part of the very same transaction. And the coordinate bench of this court, having taken into consideration that an amount of rupees 65 lakhs had already been transferred to the Enforcement Directorate, Bangalore, had lifted the lien, directed the defreezing of the account and permitted the petitioners to operate the account. By inadvertence, the amounts as regards which Annexure F has been issued was not mentioned in the earlier proceedings. But however, the fact remains that the entire amounts having been transferred to the Enforcement Directorate, there are no amounts which are available with the petitioner. In that view of the matter, for the very same reasons as indicated in the order dated 28 November 2023 in WP number 17412 of 2023, I pass the following order. Writ petition is allowed. A certiorari is issued, so and so at Annexure F series are quashed. Respondent number 2 is directed to remove the lien on the petitioner's bank accounts as indicated in the prayer above and permit the petitioner to operate the accounts freely without restriction, which shall be done within a period of
2 weeks.
2 weeks. ಬೇಕಾದ್ರೆ.
1 week.
ಈ ನಾಲ್ಕಕ್ಕೆ ಒಂದಿನ.
1 week.
1 week from date of receipt of.
Let me just submit, in addition to Annexure F, it should also be Annexure E. Subject to what? Annexure E ಅಲ್ಲಿ there's a lien marking of 3.87 lakhs.
That was covered under the earlier order.
ಹೌದು, it's both Annexure E and F, your lordship.
3.87.
Indeed. Annexure F pertains to 29 lakhs and 30 lakhs.
44 lakhs, 1 crore 61. Annexure E also. Annexure E and F. That is the same amount as covered under that 1 crore 61 lakhs. Out of which only 65 was, the amount came in. ಯಾವ ರಿಟ್ ಪಿಟಿಷನ್ ನಿಮ್ಮ ಕಾಪಿಯಲ್ಲಿ ಇಲ್ವಾ? You not serve this petition on that?
Sir, it's the same copy.
Certiorari Annexure F series.
816 as it.
Serve a copy. Counsel for the petitioner to serve one more petition along with annexures on the learned AGA who seeks for and is granted a week's time to obtain instruction, make his submission. Relist on 27th.
Sir, can it come up in fresh matters? Can it come up in fresh matters?
In preliminary hearing.
Please.
57.
Yes, sir. My lords, we have filed, I appear for the respondents, madam.
We
have filed the wakalat. I request for the copy of the petition, madam. Petition copy has to be served, my lord.
Not been served on you?
Sir, the respondent had been staying with the petitioner only until the death of the donee, her own son.
Can you give him one
Same
more?
address is there, that's why I could not send. He has filed the wakalat 3 days back. So this is a copy I am just giving.
Thank you. A copy of the petition along with annexures has been served on the counsel for the respondent who seeks for in 2 weeks' time to obtain instruction, make his submission. Released on 9th December, interim order earlier granted is extended till next date.
Date maybe.
Date
9th December.
9th December. Oh, please.
58, Sachin DS, corrected matter.
Covered by my lord's judgment, that is Device case with regard to the Bane land. My lords, what had happened was that, yes, cutting the trees. Lords, I made an application for cutting the trees existing in the Bane land to the Forest Authority. Forest Authority sought an opinion from DC. DC's order at Annexure A, what the DC says is that ownership vests with you, the owner, but the trees, the ownership in respect of standing trees does not vest with you owner. My lords would find it at page number 15. My lords, second writ petition, sorry. My lords, relying upon Annexure A order, the Forest Authority rejects it. My lords has taken a view that, kindly see, second writ petition, page 15.
Yes.
My lords, page 15, last paragraph. ಆದ್ದರಿಂದ ತಹಶೀಲ್ದಾರ ಪೊನ್ನಂಪೇಟೆ ಮತ್ತು ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಮಡಿಕೇರಿ ಇವರ ವರದಿಯಂತೆ ಭದ್ರಕೋಳ ಗ್ರಾಮದ ಸೋನ್ಸು ಪಹಣಿಯನ್ನು 9ನೇ ಕಲಂನಲ್ಲಿ ದಾಖಲಿಸಿದ ಸದರಿ ಜಾಗವನ್ನು ನಿಬಂಧನೆಗೆ ಪ್ರಸ್ತುತ ಪಹಣಿಯಂತೆ 7656 my lord.
Yes.
ಸಾಗು ಬಾಣೆ ಎಂದು ಇದ್ದು ಜಾಗದ ಮಾಲೀಕರಿಗೆ ಜಾಗದ ಮೇಲೆ ಹಕ್ಕು ಇದ್ದು ಮರಗಳ ಮೇಲೆ ಹಕ್ಕು ಇರುವುದಿಲ್ಲ ಎಂಬ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ಮೂಲ ಕಡತವನ್ನು ಈ ಕೂಡಲೇ ಮುಂದಿನ ಕ್ರಮ ಸಾಗು ಬಾಣೆ.
Sagu Bane is theirs.
Same. My lord's view, I also annexed the judgment.
We dealt with Jama Bane. Jama Bane alli Sagu Bane is obviously the owner. Sagu is alienated land. Only Sagu Bane belongs to the owner. Jama Bane used to belong to the government. But with the amendment that you did, now occupancy rights have been given. The Sagu Bane, you could never have objected.
They filed a counter also. In counter, they have said it's a Sagu Bane, therefore judgment has no application. That is a view taken by the state.
Obviously, judgment is not required to be applied for Sagu Bane. Sagu Bane, they can't have a claim.
Correct.
And AGS 6 fund is granted a week's time. Released on 27th.
Can I request for preliminary hearing, my lords?
Preliminary hearing.
Great.
59. Corrected matters.
59, my lord. I was not served with copy, my lord. It's an appealable order, my lord.
It's 59.2.
I am for 59.
Who are respond number 2 and 3?
Well, the respondent number 2 is the allottees, my lords. In the first writ petition, that is 59. Respondent number 2 is the allottee. Respondent number 1 is the appellate tribunal.
Yes.
Respondent number 3 is the developer. Respondent number 4 is the authority, my lords. That is the RERA authority.
So 2 and 3 have to be served.
My lords, 59 and 59.1, I appear for the second respondent, which is the allottee. I have on the last date received notice for 59.1 also and 59 also.
Well, lords, what happens? These are all similar matters.
But my lords, I have a preliminary objection. I'm sorry.
It's about maintainable order.
Yes, my lords, that a writ is not maintainable in this.
Yes. First, you accept notice, then you can make that submission.
59, I have accepted notice, and
59, you accept notice for respond number 2.
Yes, my lords, and 59.1.
So also accepts notice for respond number 2, 59. 59.1,
My wakalat is already there.
Sanjay Krishna for 2. Who is the developer? Respond number 3.
My lords, he's remained in some of the other writ petitions, my lords. The same coordinate bench has dispensed the notice to him because he's not been appearing.
What is the name of the
Balaji Builders, my lords. His name is sorry, my lords. One name is Srinivas Murthy, my lords. Srinivas Murthy. His name is Srinivas Murthy.
Any lawyer appearing for him?
No, no, no.
Any proceedings?
His advocate is appearing now before the appellate tribunal. my lords. I'll carry a notice.
What's the name?
My lords, I have no. No, he just, my lords, after being absconded for so many days, just.
That's why you should immediately jump at it and tell us the name.
Sorry, my lords, but I will, you can, it will be taken.
Reason for his appearance is, my lord, Allottees Association, a cooperative society filed an application for takeover.
Represented by Mr. Pradeep Kumar.
Represented.
Credit always. 59.2, who is allottee?
I am for the Allotee. 59.2, I am for the Allotee.
Allotee.
That is
Pradeep
respondent
Kumar
number 2.
for respondent number 2, 59.2.
It's already been-
59.3. Who is allottee in 59.3?
Not appearing. Which one?
My lord, I will verify that, my lord. With all the other Allottees are verified. Filed for Allotee.
You'll accept for all.
No, I don't have instructions.
You are the cooperative society.
I will find out whether he is a member of the cooperative. Some of them, my lord, are not.
We can't deal with it until you say that, right?
Well, if the matter 59.3 is coming up for the first time, my lords.
59.3 is Srinivas Murthy TV.
That is respondent number 3, my lords.
3. 2 is Madhusudana
59.3 is one.
Verma. Madhusudana Verma Madi Raju.
Not appearing, but
Is your member?
No, I'll find out.
Yeah, find out. And find out who is the counsel appearing for respondent number for the developer. Counsel for the. By afternoon you will tell us or what?
My lords?
By afternoon you will tell us, we'll pass over.
For which one, my lords? I'm sorry.
Give us the names of the counsels who will appear, so that once the process is completed, then we can take it up.
No, your lordship, because I just need.
I'll take an adjournment, my lords, because I think a lot of cases, so I could make a list 10.
Inna idea.
In either, sorry. There are totally 11 cases
And counsel
pertaining
for
to this
the
allotee.
petitioner has furnished a list of connected cases. Registry is direct connect the above with the said matter with the above matters.
And listed on one.
Relist on 3rd December.
My lords, this
My
interim
lord,
stay extended, my lords.
Interim order.
My lords, if 59.3 is
Counsel for
coming
the
up for the first
petitioner is
time.
also directed to serve the counsel for the RERA in all the matters, a copy of the petition in all the matters.
Yes, my lords. My lords, I think 59.3 is come up for the first time, my lords. So by virtue of the similar facts and circumstances, an interim order may be granted. my
Petitioner
lords,
in
till the next date of
WP
hearing.
24570 of 2025 will also be entitled to the interim order, benefit of the interim order passed in the other matters.
Yes, my lords.
File your wakalatnama, madam, in all. Pradeep, you also file your wakalat.
grateful, my lord.
Serial number 60, Chetan Jadhav.
My lord. If your lordships kind leave, my lord, if I can just mention 56. We've clarified, my lord, it's the same petition that's been served.
I'll get your instructions. Quash ಮಾಡ್ಲೇಬೇಕಲ್ಲ.
Remove.
You can't say, pass a lien order on a transit amount, on a claim on a transit amount as regard their account. We'll have it on that day, 27th, you do that. No coercive steps till then, ಅಂತ ಹೇಳಿ. ಇದರಲ್ಲಿ. 50?
56, my lord.
56, no coercive steps till then. You can order a lien on the transferor or the transferee. It's very transitional.
Milords, what they're seeking, Milords, they don't have problem to allow the petition. They're only saying, Milords, not to quash that annexure F and E. Milords, there will be a direction, Milords, I think it suffice.
You don't want it to be quashed.
No, my lord, the lordship's order just to say that the amount may be released, my lord.
I think
That's
the
all.
respondent bank
Without that quashing, you will be in trouble. Please think about it. That will continue to be there every time. They'll have to explain that. Wait for some time. Let him explain.
Serial number 60, Chetan Jadhav.
Not yet received the instructions, ma'am.
ಏನಿದು?
Not
What
matter
is
is
this?
covered by your lordships. Lord.
Rowdy sheeter matter, my lord.
Rowdy sheeter, but all the cases referred to Lord in the report Lord, are acquitted. Acquitted.
Acquitted.
Acquitted. All the
Acquitted
cases.
ಆದ್ರೆ ಇನ್ನೇನಮ್ಮ?
But since 15 years, Lord, there are no cases.
ಫುಟಲ್ ಆಗಿದೆ ಎಲ್ಲ ಕೇಸಸ್ ಬಟ್
ಮತ್ತೆ ಇನ್ನೇನು?
ಅಲ್ಲ ಮತ್ತೆ ಯಾಕೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತೀನಿ.
ಅವ್ರು ನಮ್ಗೆ ಬೇಕು ಅದಕ್ಕೆ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತಾರೆ ಅಷ್ಟೇ.
No, my lord, they will be involved in Sadhana.
Pass over.
Activities,
It-
pass
Since 15 years, no cases registered.
Pass over, my lord.
Pass
I'll
over.
orally get the instructions.
51. Vasant Kumar.
Covered by judgment, my lord.
For respondent, my lord.
Annexure J to M, all the connected matters are disposed of. This is also similar matter.
Is who appears for the respondent?
The IPF for respondent number 5, my lord, Panchayat.
Covered ಅದು same order.
ನೋಡ್ಬೇಕು ಸುಮ್ಮನೆ. Any short date may be
No,
fixed in
no,
this matter.
sufficient
5
upper
my
class
lords, my
given
lords.
copies will
The
serve
survey
last year
number is
lordship
different.
has-
Mr. Counsel, please don't make wrong submissions. We directed him to accept notice last time. Sufficient opportunity ಎಲ್ಲ ಆಯ್ತು. Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ. Last time ಕೊಟ್ಟಿದ್ದೀವಿ sir.
Counsel for respondent seeks for and is granted 10 days time to
Copy
obtain
judgment
instruction,
ಇದೆ,
make his
ಅವ್ರಿಗೆ-
submission. Released on 9th December. It's made clear that no further adjournment would be granted. ಇನ್ನು ಅವ್ರು ವಕಾಲತ್ತು ಫೈನ್ ಮಾಡಲಿಲ್ಲ, sufficient opportunity ಅಂತೀರಾ.
ಅಲ್ಲ ನಾವು at the time of filing the writ petitions, we served the copy to the all the
Whom?
respondents.
To the panchayat, who is
Oh,
going to be
sir.
affected.
No, earlier the one of the one Devraju, he was appearing also, we talked to him also.
No, my lord.
Subsequently, he has
The
appeared.
earlier council, when Somaji appeared for this
Ah,
matter,
see.
my lord. The Somaji, because after death of the Somaji, we entered to.
ನೀವು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, you should be responsible in making your submissions.
Please, my lord, last time.
Don't make that submissions. They've entered appearance last time, let them get instructions.
Prior to that, when Devraju was appearing, we have served the copy to the Devraju also. That's what I'm submitting that.
Should we observe that you are making wrong submissions? The earlier council has expired, new council has come. Last date he has come on record.
He is also colleague of Devraju.
Devraj has been directed to accept notice last time, Mr. Council.
Not last time, no, prior to last statement. Kindly.
Kodi,
Last-
order
I'm
ಮಾಡೋಣ.
sorry, I'm sorry. ma'am.
Order ಮಾಡೋಣ.
No, I'm sorry, ma'am. Last time I was not
Be
there.
responsible in your submissions.
No, because what I'm.
ಅವ್ರು ಒಂದ್ ವಾರ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೆ sufficient opportunity ಅಂತೆ.
No, this is covered by judgment. That's why I make a submissions already disposed in the similar matters.
Next.
62, G1K.
I appear for the petition. I served the copy to the both the councils. Served the copy.
ಇವಾಗ ಮಾಡಿದ್ರು, ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರು. ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್, ಪವನ್ ಕುಮಾರ್ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್. ಪಾಸು.
53, Sridhar K.
63.
Hearing for respondent. Respondent number 6. This court directed the Tahsildar to visit this spot.
63 nalla.
63.
My lord, last
Copy
again,
not
my lord.
served on me. I am for the respond number 2. Copy of the petition not received by me.
ಏನಪ್ಪ?
Copy not served on.
ಕಾಪಿ ನೋಟ್ಸ್. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ನೀವು ಯಾರಿಗೆ?
R2, my lords.
R2.
I am for respondent number 6, my lord.
6 and R2.
V. Vishnu Shetty, my lord.
What about the others?
Others
1,
also,
2, 3,
notice has
4,
been
5.
argued. AJ accept notice for R1, R3, 4 and 5, my lord.
Yes. Counsel for the petitioner has served a copy of the petition along with annexures on the counsel for respond number 2 today.
Please.
ನಿಮ್ದೇನಂತ?
My order has been challenged before this.
So, you are going to defend your order?
Copy has to.
ಆಯ್ತಷ್ಟೇ. Is the,
Yes,
you are ready?
No, we'll have it next week, my lord, because I have to file objections to this.
You received the copies.
My lord, may I make submission, my lord?
This court directed the Tahsildar to visit the.
Make a report, my lord. In that, my lord, I have given report. Kindly, madam, memo ಕೊಡಿ. ಎರಡು ನಿಮಿಷ ಕೊಟ್ಟೆ. My lord,
You are supposed to file a report.
Yes, ma'am.
My lord,
The power of attorney could be issued by the Archak.
Please.
my lord,
They have visited the spot and to file.
My lord, right now I am dispossessed from my original position, my lord. It's my private property, my lord. They have dispossessed me, my lord.
Request for interim order was rejected by the coordinate bench. They have to file a report. They'll file the report next week.
I have given representation, but they have not considered, my lord. 2 times I have given, my lord. They are deliberately.
And AGS seeks for and is granted 1 week's time fine to file the report as directed, wide order dated 24/9/25. Relist on 20th November, it is made clear that no further adjournment would be granted.
Much obliged.
My lord, I apologize for filing memo, right?
64.
Ian, go before the coordinate bench. There are 4 police notices from various states.
Surface matter.
Not defreezing of the account.
Defreezing outside the state.
Outside state, there are 4 accounts.
64 connect to WP number so and so.
My lords, I have a submission to make.
86, well, it's connected with another matter coming up on 18.
86.
18, madam, along with WP number 30.
86
Still 86.
notice ಎಲ್ಲ ಆಗಿದೆ.
Notice ಎಲ್ಲ ಆಗಿದೆ.
86 connect with so and so.
WP number 3.
ಬರ್ತ್ ಕೊಡಿ ಕರೆಕ್ಟ್ ಆಗಿ. ಇಲ್ಲ ಒಂದ್ ನಂಬರ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಆದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
My lords, I have a submission to make, my lord.
18 November. 18th November.
My lords, I have a submission.
Just a moment, please.
96 melodies.
Huh?
96.1. Has been settled, melodies. I'm filing a memo to withdraw the matter.
Only 96.1?
The remainder matters, that is 96 to 2 to 5, they are infractuous, melodies.
Infractuous. 96.1 petitioner is before this court seeking for the following names. Memo has been filed, dismissed as withdrawn. 96, 96.2, 96.3, 4 and 5. Granted counsel for the petition submit that the relief sought for in the matters have been rendered infractuous. Accepting the said submission, petition is dismissed as infractuous.
My lord, I have a submission to make. I apologize in prior as I couldn't file memo in the morning, my lord.
Yaudappa?
CMP 581 of 2024.
Want to move it for tomorrow?
Yes, ma'am. For all.
Nale told.
Serial number 99, my lords.
CMP.
I have filed the withdrawal
Till
memo.
number?
99.
99. Yes?
My lords, I have filed a memo
Withdrawal.
for withdrawal, my lords.
99 memo for withdrawal, dismissed as withdrawal.
Lord, one request, my lords. Lord, this matter, my lord, where Consumer Forum has passed order in Stamp and Registration Act in the Stamp and Registration Act without jurisdiction, my lord. Contempt case is coming tomorrow before State Consumer Forum, my lord. May be taken tomorrow, my lord.
Nale told. ಯಾವುದು? $96.1 withdrawn. 96 ಬಾಕಿ ಎಲ್ಲ ಏನೇನಿದೆ till 96.5 infractions.
ಬರುತ್ತೆ ಸರ್.
ಮೇಡಮ್ ಅದು
86 ಅಲ್ಲಿ.
ಅದೇ ಇದು ಡಿಫ್ರೀಸ್
Serial 86 ಅಲ್ಲಿ connected with.
ಅದೇ ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ನಾನು ಪ್ರಶ್ನೆ ಕೇಳ್ಬೇಕು ಅಂತ ಅನ್ಕೊಂಡೆ. ನಾಳೆಗೆ ಇದೊಂದು ನಾಳೆಗಂತೆ ನೋಡ್ಪ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು
86 ಅವ್ರದ್ದು 18th ಮೇಡಮ್ 18th ಇದೆ 18th ಡೇಟ್
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಮೇಡಮ್.
ಹಾ ಅಲ್ಲ ಆದ್ರೂ ನಾನು ಅದು ಪ್ರೇಯರ್ ನೋಡ್ತಿದ್ದೆ ಆ ಫೈಲ್ ಅಲ್ಲಿ. 30887 of 24 ನಂಬರ್ ಅದು ಅವ್ರು ನಾಳೆನಾ ಅದು GM ಏನೆ ಸರ್ GM ನಾಳೆಗ್ ಬೇಕಾ ಅದು ನಾಳೆ ಇಲ್ಲ GM ನಾಳೆ ತಗೊಳಲ್ವಲ್ಲ ಮಂಡೇಗೆ. ಅದೇ ಇದು ಆರ್ಡರ್ ಸೈನ್ ಆಗ್ಬೇಕು.
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಮೇಡಮ್.
ಹೇಳಿ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 44 ಏನಾಯ್ತು ಮೇಡಮ್?
44 ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಸರ್ ಅದು.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Hello, Court Officer. Hello, Court Officer. Good afternoon, sir. Good afternoon, sir.
ಹೌದಾ? Okay.
ಹೇಳಿ ಸರ್. ಸರ್ ಹಲೋ.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ಕೊಲಾಟ್ ಆಗತ್ತಾ?
ಫಸ್ಟ್ ಧಾರವಾಡದ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ನಾಳೆಗ್ ಬರಲ್ಲ, ಡೇಟ್ ಸರ್ ಕೊಡ್ತಾರೆ. ಅಲ್ಲೇ ಕೇಳ್ಬೇಕು ನೀವು, ನನ್ನಲ್ಲ. ಅವ್ರು ಕೇಳ್ಬೇಕು, ನಾನ್ ಕೊಡಲ್ಲ, ಸರ್ ಕೊಡ್ತಾರೆ. ನಿಮ್ ಇಷ್ಟ, ಕಾಯೋದು ಬಿಡೋದು ನಿಮ್ ಇಷ್ಟ. ಬೇಕೇ ಮೆನ್ಷನ್. ಡೀಲಿಂಗ್ ಆರ್ಡರ್ ಮಾಡಿ ಮೇನ್ ಫೈಲ್ಗೆ 10-12 ಅಂತಾನೆ ಡೇಟ್ ಕೊಡಿ. ಹೌದು ಹೌದು. ಮೇನ್ ಫೈಲ್ಗೂ ರಿಲೀಸ್ ಅಂತ ಒಂದು ಡೀಲಿಂಗ್ ಅಂಡ್ ರಿಲೀಸ್ ಅದೇ ಆ ಡೀಲಿಂಗ್ ಮಾಡಿ. ನಾನಾದ್ರೆ ಎಲ್ಲ ಬರ್ದಿದ್ದೀನಿ ಪೆನ್ಸಿಲ್. ವಾಪಸ್ ಕಳಿಸಿ ನಾನು ನೋಡ್ತೀನಿ, ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀನಲ್ಲ ಅಷ್ಟೇ. ಸೀರಿಯಲ್ ನಂಬರ್ ಬರ್ದಿಲ್ವಾ ಹಾಗಾದ್ರೆ? ನೆನ್ನೆನ ಮೊನ್ನೆನ ಸಪ್ರೇಟ್ ಆಗಿ ತಂದು ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಇವ್ರು ಕೊಟ್ಟಿದ್ದಲ್ಲ, ಇಲ್ಲಿದ್ದವ್ರು ಕೊಟ್ಟಿದ್ದಲ್ಲ. ಕಳಿಸಿ ನೋಡಿ. ನಾಗರಾಜ್ ಹತ್ರ ಕೊಟ್ಟೆ ಕೊಡೋದಕ್ಕಾಗ ಸೂರಜ್ ಹತ್ರ ನಾನು ಏನೂ ಕೊಡಲ್ಲ, ನಾನೇನು ಕೊಡಲ್ಲ. ಇವ್ರು ಇರ್ಲಿಲ್ಲಲ್ಲ ನಿನ್ನೆ, ಇವ್ರೇನು ಕೊಡಲ್ಲ. ಇವತ್ತು ನನಗೆ ಅದ್ಯಾವ್ದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ನೋಟು ಮಾಡ್ಕೊಂಡಿರಲ್ಲ, ಹೋಗ್ಲಿ ಕೂತ್ಕೊಳ್ಳೋದು. ನಾನು ಬರೆದ್ರೆ ಇರು ಬರಿತೀನಿ, ಸೀರಿಯಲ್ ನಂಬರ್ ಬರಿತೀನಿ, ಇನಿಷಿಯಲ್ ಬರಿತೀನಿ, ಎಲ್ಲ ಬರಿತೀನಿ. ಅಲ್ಲ ಈಗ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾವುದು ಕೊಟ್ಟು. ಕಂಪ್ಯೂಟರ್ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಲ್ಲ?
Lord, may I make a there one matter of PMRCL's tender which was filed by the association. That is
outdoor.
Yes, that is listed today, but 122 may not reach. Lord, can your lordship relist in the fresh matters list, Lord? We want to
Non-compliance of office objection.
You know, annexure A or original.
Annexure A, they're asking for the original, which is an RFA. Original can't be produced.
122, accepting the submission of learned counsel for the petitioner, the production of original of annexure A
Annexure A.
is dispensed with.
There are other small office objection which I'll complain. IA not served on the BBMP council and the ಕೊಟ್ಟಿದ್ದೀನಿ in fact.
Learned counsel for respondent number 4, acknowledged receipt of copy of IA number 1 of 25. Hence office objection on IA 1 of 25 does not survive for consideration.
So for a serving of copy, I'll
maybe listed under the fresh matters.
When will you fresh alla preliminary hearing?
Preliminary. Next week, next Thursday.
20th?
20th or 21st.
At the request of both the councils, released on 20th at 2:30 p.m.
Very well, I'm grateful.
It's interim order.
Interim order earlier granted is extended till next week.
The IM, they have extended the time for submission of tender. Today is the last date for the submission of tender. They issued one more corrigendum on the same day when the interim order was
without knowing that they had extended the date, thinking that matter is pending before the court. But
Same
anyway,
day.
there is a interim order, my lord.
ಅದಕ್ಕೆ ಐ ಹಾಕಿದ್ದೀನಿ corrigendum ಫೈಲ್ ಮಾಡಿ that needs to be stayed ಅಂತ ಹೇಳಿ.
Your lordship stay is stay of the entire tendering process. So
only that particular thing, if you clarify, they'll also.
Yes, we'll clarify. We'll clarify. I'll get it clarified.
So that would
now letter issue.
Yes.
Issue.
There's some office objection, Mr. Gupta, that you have to. No, there's some office objection on the petition. There's some office objection on your petition.
Office objection, prima facie been allowed, kind of, 3 times, 4 times. Now there are technical objections. This is not the order coming on the way of the order.
Office has raised objection, we'll have to deal with it.
Kindly order that may be overruled. I've tried my amendment.
What is the office objection?
Carried out everything you are, so much of.
That's a very. What?
Direction required by.
We understand it's a very nice submission, office objection are there, please overrule it. But we don't know what it is.
4 times you are not, you give my that memo, it is 4 times.
When it reaches Mr. Gupta.
Reach your lordship.
I may seek my lord's indulgence.
Yes.
Serial number 1, my lords,
Hmm.
the MTP matter.
Will reach
Lords.
evening you can.
Yes, madam. Report is come.
Evening. End of.
Third.
Court of.
Yes.
Wait and
Serial number what, madam? 3, yes. Hmm. Hmm. So when will you get it? When will you get it? We'll list it. The learned counsel for the petitioner seeks for and is granted 10 days time to place the settlement deed on record. Released on 27th November. Mr. Prajwal, they are advising against it in the interest of the child.
Lords, in fact, I spoke with the victim also. She was like, if the court doesn't grant permission, I will wait up until term and I will hand over the child to the state is what she wants to do, Lords. According to orders may be passed, Lords.
So you want to voluntarily surrender?
Yes, my lords.
That in this matter, we'll file a separate proceedings for that and go through that.
After the delivery, maybe we'll have to reinitiate proceedings again, my lords.
Fair enough. We'll reserve that liberty here.
Certainly, my lords.
Could you petition? Petitioner is before this court seeking for the following reliefs. Petitioner is aged about 16 years, residing with her parents and younger sister at Chikbadapur. The petitioner is a victim of an offence under Section 5J 2, 5L (6) of the Protection of Children from Sexual Offences Act 2012 and Section 65(1) of the Bharatiya Nyaya Sanhita 2023. On account of the said offence, being a victim of the said offence, due to forcible sexual intercourse she had conceived, and as on the date on which the petition was filed, it was stated that she was 29 weeks pregnant. It is in that background that the petitioner had approached this court seeking for permission for medical termination of pregnancy by exercising the right of body autonomy. The petitioner contending that she does not wish to continue with the pregnancy which was forced upon her. The matter I mean referred to the medical board of respond number
3 minutes.
4.
Respond number 4.
Indicating that since the pregnancy was more than 28 weeks, the state board would have to submit a report. And as such, the petitioner was referred to Vani Vilas Hospital, who is the medical board, which medical board has submitted a report today. In terms of said report, it is indicated that the gestation is of a period in excess of 30 weeks. And in the event of the fetus surviving, the baby will be preterm, resulting in respiratory complications requiring long hospital stay, renal, metabolic, cardiac complications like hypoglycemia, hypocalcemia, respiratory distress syndrome, patent ductus arteriosus, neonatal sepsis, acute kidney failure, etc. And in that background, the board is advised that given the possible complications, the pregnancy can be continued till term. Apart from the said complication submitted by the pediatrician, the obstetrician and the psychiatrist have indicated various other complications. Though it is in view of the said report that I have to consider the request made by the petitioner. The petitioner has categorically indicated that the petitioner does not wish to continue to have the child. And even if the child were to be born alive on account of induced
Labor,
she would wish to surrender the child. That being the case, there being a large possibility of the child being born alive on account of induced delivery, in the event of the child suffering from any of the issues indicated by the pediatrician and the obstetrician, it would be difficult for the child to be surrendered and or given up for adoption or for anybody to adopt the said child. It would also be in the interest of the child would also have to be taken into consideration. And the possibility of the child being born alive with any of the issues pointed out would have to gain precedence over the request made by the petitioner. In that view of the matter, taking into consideration the interest of all concerned, I am of the considered opinion that the request made by the petitioner for medical termination of pregnancy at this stage cannot be considered favorably and is required to be rejected. However, liberty is reserved to the petitioner to approach the appropriate authority. However, the respondents are directed to provide free medical attention to the petitioner till the delivery, and thereafter, as mandated in the standard operating procedure issued by this court in WP number so and so, so and so. In the event of the petitioner after the delivery still wishing to surrender the child, the same to be done in terms of the said SOP and section, the JJ Act, surrender of child, section 40 something.
But I think it's 35 if I'm not wrong.
Yeah, 35.
This is the 2015.
35 of the Juvenile Justice Care and Protection of Children Act 2015 by following due procedure thereafter. Instruct on the hospital, madam, all the expenses, everything. As a
Deep replacement.
That you will have to, as per the SOP and 30 So you will have. They don't need to file. We have directed in the other matter that it will be for the CWC to collect and file it with you because they may not know. They lay down detailed guidelines as regards how it is to happen. So CWC will collect the details and submit an application, which you will have to deal with in 30 days and release the money. How? Initial amount adadmele, then it will go before the KSLS for approval. That procedure is there. ಏನಮ್ಮ ಇದು ಫುಟ್ಬಾಲ್ ಆಗೋಗಿದೆ ಇದು
ಅದನ್ನ ರೀಡ್ ಮಾಡ್ಬೇಕಾ ಒಳಗಡೆ ರೀಡ್ ಮಾಡ್ಬೇಕು ಇದೊಂದು ಕೆಪ್ಪಿಲ್ ಡಿಸ್ಪೋಸಲ್ ತಾನೆ ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲ Dharwad bench matters.
Please. Hello. The matters relating to 1.1, 1.3 and 1.5, my lord. They pertain to where the Nigam is not made party to the LAC proceedings, my lord. That these are to be heard along with that KBJNL batch, my lord. Idu Nigam, my lord. Niravari Nigam ivo. 1.1, 1.4 and 1.5, my lord.
What happened to those other partner matters? They are also to be listed.
Please, my lord. The court is not audible, my lord.
Yes, now we switched on the mic. There are other matters also, Alva. What happened to them? Gangadhar, you are on mute. Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Some more matters pertaining to the KBJNL matter. There is a lot of matters with larger prospectus. These matters have been parted by my lord. But considering that the burden of the interest on the state and all these things, these matters may be connected with those matters. I have it in the next week. Advocate General will assist this court on those aspects.
ಅದು ಯಾವತ್ತಿದೆ ಅದು?
No data is given, my lord, in that.
No, date we had given as 12th. But I believe
next week all these matters may be posted.
Files ಬಂದಿಲ್ಲ ಅಂತ. Thursday ಬರುತ್ತೆ. Relist, connect with so and so and relist on 27th November.
Please.
One submission. But
Yes.
as far as 1.2 and 1.3, there are different matters.
1.1 and 1.3 na?
1.2 and 1.3.
ಅದೇನದು?
One is regarding 28A proceedings. Another one is, my lord, in Lok Adalat, my lord, without the consent, my lord, decree has been passed without the consent
So
of
that
the
is not part of it. So we'll delink and release those two.
Please, the interim order has to be extended, both the matters.
1.2, 1.3. The counsel for the petitioner submits that the these two are not connected with the other matters. As said, they are directed to be delinked and are released from parted.
Interim order has been extended.
Interim order earlier granted is extended till next year.
Please.
Hmm. 1.2. She so and so submit that you would be appearing for respond number 4 to 7. You submit that respond number 3 has expired and you would provide the details of the legal heirs of respond number 3 to the counsel for the petitioner within 10 days from now. Counsel for the petitioner seeks for 2 weeks time thereafter to file an application to bring the legal heirs of respond number 3 on record. 1.3.
1.3 is also different matter.
Released on date kodada. Released on 10 December 1.2 and 1.3. Idunella 27.
Both the matter malo interim order has been extended. Both the
Interim orders are extended.
Please.
Line 27. 27.
List number 2. Serial number 1.
ಎಲ್ಲಪ್ಪ ನಿಮ್ಮ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಮಿಸ್ಸಿಂಗ್ ನಿಮ್ದು and counsel for the petitioner has finally filed his returns, has filed his return submissions. And counsel for respond number 3 seeks for and is granted a week's time to file his return submission. Released on 27th November. ಹೇಳ್ತೀನಿ ಅಂತ ಹೋಗ್ಬಿಡೋದು.
Serial number 2.
You wanted to make your submission only on some judgment.
Allowed. I'm for the petitioner. Matter may be passed over. Senior will come. He's in the other.
You can make your notes until that particular judgment is referred as.
I don't want to reopen any.
Hmm.
There was just a recent judgment that
Yes. So your submissions have been filed. All of them have, both of you have filed.
No, there are no, I will file for submission. Submissions.
Still not filed.
Both of us have not filed comprehensive written submissions.
That is why you said you will file and we reserved it and then both of you are missing. So when will you file it?
A week.
Then that day you can make your submission. What about you? You have filed?
I have not filed, my lord.
When will you file?
Week's time.
Both the councils seek for and are granted 10 days time to file their respective written submissions. Released on 27th.
Interim order to be continued.
Interim order earlier granted is extended till next year.
Serial number 3, Arjun. Serial number 4, Prithvi Wadiyar.
Respondents in this matter.
The losses are directed us to file synopsis. I have served copy. They too have.
You are there, huh?
Yeah.
We've also filed, my lord.
Done?
Submissions have been.
Both the councils have filed their respective written submissions. Reserved. Anything you want to say?
But just 2 points, my lords, because in fact your lordships heard us on the one of the matters. The other matter your lordships have not heard us. But the issue is only this.
Which matter? There are 2 matters.
There are 2 petitions, my lord. 2, 3,
Oh,
4,
no, we
8,
haven't
7.
heard you on this. This is different.
And 2, 2, 8, 5, 0.
We haven't heard you. We thought it was part of the earlier list.
Also, on his way. He's on his way.
Pass over.
Lord, I appear to the respondent number 4 in this matter. The arguing counsel had to undertake emergency travel in Arizona. Can we have it any date next week?
You have for respond number?
4, my lord. So it will be tomorrow, my lord.
Will you be back tomorrow? Tomorrow not possible. No, tomorrow is CMP day, not possible.
Tuesday.
19th or 20th.
Any date, my lord.
You'll be back?
Yes, my lord.
You said emergency travel.
Back tomorrow, my lord.
19th.
The request of counsel for respondent, counsel for the petitioner has filed his written submission. The same is taken on record. At the request of counsel for respondent number 4, released on 19th or 20th, Yavattu, Mr. Patel?
In connected also, Tahir is filing synopsis.
Petitioner in both the matters.
Ultimately, Manoj, it's between the two of us, Manoj. Since Mr. Patil is here, may I request that the matter, it won't take more than 5-10 minutes.
Respondent number 4 is?
Ultimately, Manoj, I don't agree
You don't
about
agree.
the timeline. About 20th.
Respondent number 4, Beka, Bedwa? Because he is requesting for time, Mr. Nair is saying respondent number 4 is not required.
Ultimately, it's a question of the agent of KMF. Manoj, KMF has made its position clear. The agent, Manoj, will have to follow what the principal says.
Let him be there. 19th or 20th, Mr. Patil, Yavattu?
Please, Manoj. 20th would be.
20th. Released on 20th.
Hassan is necessary. They have already put in appearance. There is no difficulty.
No, they have put in their appearance. Some emergency has come. Counsel is not there. That time kedidro. You're bad and unnecessary.
Then could it be the 25th, Manoj, is also convenient to Mr. Patil?
25th.
It's convenient.
Wherever it reaches, we'll take it. Every day is convenient. 25th.
Interim order may be extended.
Interim order extended.
Serial number 5, Nityananda V. Nayak.
My apology. I'm appearing for the petitioner, my lord.
Yes.
Not the filed in interim order was granted.
Respondent ikkada.
Respondent number 2 to 6, your lordship.
2 to
6, your lordship.
6. AGF person. Ready?
Please.
Ready?
I'm appearing for the.
Yedi Nityan.
My lord, they have filed an application seeking vacating the interim order granted by this honorable
Argue
court.
on the merits, please.
Please. My lord, the petitioner is also a senior citizen, a retired doctor, my lord, from BMS College. And the petitioner's father has filed an application before the Assistant Commissioner, invoking the provisions of.
Second respondent is the father.
Please, my lord.
Everybody has become senior citizens.
Please.
Yes.
Now he is 90 years old.
My lord. And he filed an application before the Assistant Commissioner, and the order passed by the Assistant Commissioner is Annexure A, my lord, page 29.
Yes.
May I read, my lord, that the prayer sought for by the petition, the respondent petitioner's father was that the petitioner be vacated from the ground floor and be shifted to the first floor of the 3-story building to enable the father to stay in the ground floor, as he is suffering from age-old illness, my lord. That was considered, the specific prayer sought for in the application was considered by the Assistant Commissioner. Page 30 is the order dated 19/4/2025. My lord, the second para, in this case, the petitioner and his wife are aged above 80 years and suffering from age-related ailments. They were unable to reside in the first floor due to
Yes,
their
we
old age.
have read that. So basically, they have to reside in the ground floor.
Please, I have no objection so far as this order is concerned, my lord. As on this day, this order has been given effect to, my lord. After I approaching this honorable court, my lord. However, this subsequently by the Annexure B, my lord, page 31, the Assistant Commissioner ventured to pass one more order being functus officio. There it is mentioned that the respondent is hereby directed to vacate the entire building and allow the petitioner and his wife to reside in the said house. My lord, the prayer sought in the.
Where is the application which had been filed?
Annexure C, page 32. Typed copy Annexure 34, relevant page number 35, my lord. Page number 35. Hence, I request you kindly help us to stay in the ground floor so as to be closer to R.V. Esther Hospital for both of us. My lord, this honorable court was pleased to grant the interim protection considering the reason of functus officio.
Yes.
And pursuant to the interim order granted by this honorable court, my lord, I was shifted to other place in the very same building The place is vacant for my parents. Let them reside, my lord. So, and let this interim order be set aside, and no hardship will be caused to my parents. And only at the instance of some real estate people, the provisions of the Senior Citizen Act has been abused.
What is the size of the property?
My lord, the property consists of a 3-story building, ground floor, first floor, second floor. In the each floor consists of 2 3 BHK accommodations, and second floor is given to my brother Dr. Devraj, who is a nephrologist in USA, and my sister Indra is staying outside, got married, and now they want to sell this property and making use of these provisions of the act, and with the help of the assistant commissioner, they obtain the annexure B.
Now you are in the second floor.
Now I have shifted to second floor, ground floor, first floor, my lord.
First floor. The ground floor.
In the ground floor also, the 2 BH, 3 BHK accommodations are very much available. My lord, kindly consider the conduct of the respondent also. After the order was passed by the assistant commissioner.
Right now is your father. What is the size of the plot?
My lord, it is more than 40-60, my lord. It is
40-60 2 3 BHK.
3 BHK.
How can there be 2-3 BHKs in the 40-60 plot?
And they have produced the copy. I have produced the copy of the photograph also, my lord.
Cannot be 2-3 BHK flats.
ಇದರಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 13.72 meters, ಉತ್ತರ ದಕ್ಷಿಣ 18.29 meters. 40 into 60, my lord. 40 into 60 site. It was purchased by my father, my lord, in the year 2002, my lord.
It's your father's property.
Yes, your lordship.
Please. He was a retired director in the All India Radio.
I have to let the other side make their submission now.
Your lordship, now the question is, this is self-acquired property of mine. So this is my wish, who are staying or who are not staying. Because of I am staying outside with the help of others, other caretakers. Now the first floor and second floor living for rents. That is my purpose. Because if I am 90 years old, my wife is 83 years old. Now he is suffering from so much of ailments, your lordship. Our submission is, this our self-acquired property. Without our permission, he can't stay there. That is our intention, your lordship. Because of their trouble like anything, mentally and physically. So many police complaints also given to father to against.
Where are the complaints?
Earlier, your lordship.
Who has a copy of the complaints?
No, here I am not attaching. I am attaching the medical certificates, your lordship.
Medical certificate is done. Where are the complaints? Whether they can stay in the first
floor. Complaints is also there. So many messages also there, your lordship.
Show us that.
I will produce, your lordship.
Any possibility of mediation?
No, your lordship. Because of so much of talking on
going on.
No, your lordship. Because of last week itself, they are coming this honorable court from waiting morning to evening, your lordship, to only post this matter because of their urgency. They want to die peacefully with their own house without anybody troubles. That is their intention.
How the ground floor is available for them? The issue that we'll have to consider is whether they can be in the first floor or not.
No, your lordship. Because of first floor and second floor, they need for their needs, your lordship. They give for rent. That amount only.
ಎಷ್ಟು ಬರುತ್ತೆ rent?
I will produce the rent. This one also rental agreements also, your lordship.
ಎಷ್ಟು ಬರ್ಬೋದು?
10,000, your lordship.
10,000. 10,000 ಕೊಡ್ತೀರಾ ನಿತ್ಯಾನಂದ್?
ಆಯ್ತು, ಕೊಡ್ತೀನಿ. I am ready. The rental agreement is pursuant to the order passed by the assistant commissioner, and they have displayed the board on the property that it is for rent.
Because of their troubling like anything.
So place those complaints that you have filed for us to consider. Please. And ask your client whether they want to go for mediation so that solve the matter. Finally, it's your son.
No, your lordship, please. They are not ready. If they want, your lordship, I will bring the respondent number 2 before this honorable court.
If the matter is really pursued by the my parents, my lord, it could have been settled. Some vested interest is playing all those things.
Respondent number 2 ಕರ್ಕೊಂಡು ಬರ್ತೀರಾ?
ಹೌದು ಸರ್.
ಯಾವಾಗ ಕರ್ಕೊಂಡು ಬರ್ತೀರಾ?
Next week, Your Lordship, any date.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಟ್ಯೂಸ್ಡೇ ಕರ್ಕೊಂಡು ಬರ್ತೀರಾ?
ಕರ್ಕೊಂಡು ಬನ್ನಿ.
ರಿಲಿಸ್ಟ್ ಆನ್ ಅದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೇನಿದೆಯೋ ಅದನ್ನು ಕೊಡಿ.
Yes, Your Lordship.
Released on Tuesday 18th at 2:30 p.m.
Interim order may kindly be extended.
Interim order earlier granted is extended till next date.
Much advice.
Passed over matters. List number 1.
ಇಲ್ಲಿ ಬಂದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಅಂತ ಫಸ್ಟ್ ಸರ್ವಿಸ್ ಆಗಿ ಕ್ಲಾಸಿಫೈ ಆಗಿದೆ, ಆಮೇಲೆ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಂತ, ಅಲ್ಲಿಂದ ಮತ್ತೆ KSR ಮತ್ತೆ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ. ಇದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಅಂಡ್ ಸೊಸೈಟಿ ಸ್ವಲ್ಪ ಹುಷಾರಾಗಿ ನೋಡ್ಕೊಳಕ್ಕೆ ಹೇಳಿ, ಬರೀ ಸೊಸೈಟಿ ಇದ್ರೆ ಆಗಲ್ಲ. ಅದೇ ಅದು ನೋಡಕ್ ಬೆಳಿಗ್ಗೆ ಹೆಂಗ್ ಬಂದ್ರೆ
Passed over matters. List number 1, serial number 8. Sri Vishwas.
Seeking mandamus, writ of mandamus, appearing for the petitioner seeking writ of mandamus, Your Lordship. The petitioner has earlier approached before this honorable court in WP number 21064 of 2025, seeking relaxation of condition number 3 in the bail order and permit the petitioner to travel abroad by imposing certain conditions, Your Lordship. Accordingly, the petition has been allowed with certain conditions, Your Lordship. Subsequently, the petitioner has made representation before respondent number 2 and 3 to renew his passport, Your Lordship. The respondent number 2 and 3 has refused to renew the passport for a period of 5 years as per the representation made by the petitioner.
You can make your representation. The short validity passport is what they will give you.
It is already given, my lords.
Because there are criminal proceedings pending against you. Short validity has been given.
I have been offered a job in the abroad, Your Lordship. I have to travel abroad, wherein the
You
passport.
travel, you'll come back and you go back again. You get to
Lordship,
travel.
it has been renewed for only 1 year, Your Lordship. I want minimum 5
You
years.
can go to the embassy there and get a renewal there also. The short validity, what they have the power is for only 1 year.
Your Lordship, that 1 year period has been not mentioned in the order, Your Lordship. It is just mentioned in the order that kindly page number 17.
Then you challenge that notification and come. Because as per that notification, they can do only 1 year.
Your Lordship, that has been not mentioned by the Honorable Court, Your Lordship. It has been
The
mentioned that.
notification under which the passport authority acts, they can only do it for 1 year.
I'll give her a copy, my lord.
Give her a copy. You're trying to give you 1 year passport, then
1
you
year is
don't want,
already
you're
given, my
given.
lords.
That's the maximum that they can do. Counsel for the petition has been provided a copy of the notification by the counsel for respondent. She seeks for and is granted 10 days time to go through the same and make a submission. Released on 2nd December.
Grateful, Your Lordship.
Serial number 29. Karnataka.
And the proxy counsel, not advocate on record, family member is passed away today morning.
He submitted that there is bereavement in the family of the arguing counsel. He seeks for and on his behalf, 2 weeks adjournment is sought for. Released on 9th December.
Serial number 30. Vijay Kumar T.
Released on 2nd December.
Serial number 40. Balramara.
Lordship for the petitioner, your lordships.
Yes, madam. Shanti Bhushan bartara neevena. 40. DSGA.
Serial number 40.
40. I think I'll seek instruction from us. I don't know which matter this is.
The morning passover was requested on his behalf. Okay, passover.
Let's kindly pass.
Passover.
Oblige, your lordships.
Serial number 60. Chetan Jadhav.
The Rowdy sheeter.
Rowdy sheet.
There are no case pending.
No case pending.
Past 15, 16 years.
And even they have also referred to close the Rowdy sheeter station as well.
We record your submission that you are closing it, or we direct you
Orally ಹೇಳಿದ್ದಾರೆ.
direct you to close. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that despite no case pending as on date, a rowdy sheet continues to exist insofar as the petitioner is concerned. The submission of Sri Jadhav Learned Senior Counsel appearing for the petitioner is that the last case had been closed 16 years ago.
Yes.
And from that time, there is no case which has been filed against the petitioner, and the petitioner is a law-abiding citizen. And I said the continuation of the rowdy sheet is causing untold harm and grievance to the petitioner. The AGA, on inquiry and instructions, submits that there is no case which is pending against the petitioner and all the cases have been closed. If that be so, as submitted by Learned Senior Counsel, when the last case was closed 16 years ago, it was not required for the respondents to have continued the rowdy sheet against the petitioner. In that view of the matter, I pass the following order. In system ilva idukunu, when is the last case closed so that they can close the rowdy sheet?
No, my lord, they will be observing them, my lord, after a few years. If they are not involved in any activities, my lord, they will refer it to the ACP. They'll write a letter to the ACP to close it all.
Ella physical. There is no electronic system for that.
I will verify that, my lord.
ಏನಿಲ್ಲ
Mostly
ಇಲ್ಲಾಂದ್ರೆ 16 ವರ್ಷದಿಂದ ಏನಕ್ಕೆ ಇರಬೇಕಾಗಿತ್ತು? Not have been there.
ಸ್ಟೇಷನ್ ಇಂದ ಬರ್ದಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
We'll issue some directions in that. Certiorari is issued. Writ petition allowed. A certiorari is issued. Respondents are directed to delete the name of the petitioner from the rowdy sheet maintained by the respondent within 2 weeks from the date of receipt of a copy of the sort.
Please.
Though the petition is disposed, relist on 17 December for reporting complies with general directions.
The order copy might be made available.
We'll do that. We'll ask them to do an electronic system for keeping track.
Yes,
Relist, my lord.
ನಿಮ್ಗೇನಿಲ್ಲ.
Please, please.
Serial number 62. G1K.
Why are they not here still? You served a copy?
Served the copy.
Acknowledgement ಇದೆಯಾ?
File ಬಿಡಿ.
Learned counsels for respondent number 1 and 2 had been directed to accept notice for the respondents. Counsel for the petitioner had been directed to furnish 2 sets of the petition along with annexures on the said counsels. The same has also been served on them, despite which there is no appearance made on their behalf today. To give one more opportunity for the respondents to be represented, relist on 26th November. In the event of there being no representation for the respondents on that date, matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner.
Yes.
Serial number 65. Venkatesh Doderi.
Again for the petitioners in this case, my lord. Petitioners are houseless, sizeless people in the KGF, my lord.
Okay.
Covered by the judgment.
Or whether you are part of the list of beneficiaries.
No, that list is already enclosed in the page number. Lordship may kindly see.
But the coordinate bench has directed that.
The list number, Lordship may kindly see page number 70, annexure H, my lord. List of 405 beneficiaries are listed and signed by all the required offices.
Yes, you have pointed that out to the coordinate bench. But coordinate bench has directed them to verify and make this. 26(9), everything like that. And AGA seeks for and is granted 10 days time finally to comply with the order dated 26/9/2025.
Land ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ sir. Land has been reserved.
Land is reserved.
Reserved.
So there is no problem for
Not by the judgment of another, same.
ಇದೆಯಾ?
The same man.
ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರಿಗೂ ಕೊಡಿ.
ಅವ್ರಿಗೂ ಇದೆ. ಕೊಡ್ತೀನಿ sir.
Same judges passed the order.
ಸೇಮ್ ಅದು 405 ಜನದಲ್ಲಿ ಒಂದು 50 ಜನ ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ, ಈಗ 210 ಜನ ಬಂದಿದ್ದಾರೆ, ಇನ್ನೊಂದು ರಿಪಿಟೇಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ. Lordship may kindly see the affidavit filed by the Deputy Commissioner, my lord.
Where in 19 September ಅದಾದ್ಮೇಲೆ 26 September ಇದು ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 97 ನೋಡಿ ಸರ್. ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 96 para number 10. I state that committee was constituted under the chairmanship of the
No,
deputy.
that was after the deputy commissioner had filed an affidavit.
ಹೌದು ಸ್ವಾಮಿ, my date.
ಅದೇ ಇದು ಬೇಕು ಅದಕ್ಕೆ.
ಹೌದು ಸ್ವಾಮಿ. 405 ಜನ
Released on 27th November. It clear that no further adjournment would be granted.
Great. Deeply obliged.
66, Murli BM.
Lord, I appeal for the petitions.
Yes.
But this and serial number 73. Lord, fair price depose license. Lord, on the basis of death of my mother.
Password.
In that may not have sought for review in the other matter.
Password.
Please.
67, Satish K.
ಯಾರು contesting Satish?
By the government. There is a dispute between the trustees, my lord. KPMG Act na invoke ಮಾಡಿ cancel.
Lordships, last occasion, there was a direction to produce the lectures. The order, impugned order, my lord, the ಉಲ್ಲೇಖ ಅಂತ ಇದೆ. Those reference. Order date.
Only to ascertain
6-9.
whether, my lord, proceedings are initiated under the provisions of Private Medical Establishment Act when there is a dispute with regard to lease between the trustees of the, it is a short point.
Secure letters which are referred to in the impugned order.
Yes.
To verify whether under KPME or under the clauses contained in the lease agreement between.
Yes.
Annexure H, my lord.
Annexure H is the order, page 49, is, my lord, passed under the provisions of, my lord, KPME Act itself. But I did not bring it to my lord's notice that it is.
What are the facts?
Facts are, my lord, facts are the Mahabodhi Society, my lord, was granted, was entered into a lease deed as per Annexure A, page 27, for a period of, my lord, 99 years. Annexure B, page 29. Thereafter, my lord, Annexure C is the petitioner's organization, which is registered under the, my lord, provisions of KPMA Act, which is the service provider. Now, my lord, a dispute arose at Annexure E, page 38, that, my lord, there is a breach of lease produced at, my lord, Annexure B. The proceedings are initiated under the provisions of Private Medical Establishment Act 2007, which is per se, my lord, redressal of grievance of patients. Therefore, my lord, invoking the provisions of Private Medical Establishment Act may not arise. Lord, the proceedings may have to be initiated. These are the facts.
The lease with Mahabodhi Society is held to be illegal.
Illegal.
And their possession is supposed to be illegal.
Yes.
So you are claiming under Mahabodhi Society.
Please.
You can't have better right than Mahabodhi Society. So your possession is also illegal.
No, the proceedings are initiated under the provisions of my lord, Private Medical Establishment Act. That per se, my lord, is not maintainable.
They are cancelling your this one because you are running on a encroached property. How can you have a license to run a hospital in encroached property?
The lease violate ಮಾಡಿದ್ದಾರೆ.
Lease violate ಅಲ್ಲ.
Condition of lease.
Your run now your possession is illegal.
ಇಲ್ಲ original lease is not my lord held to be bad.
Where is the order? Let's see the order.
Annexure H, my lord, page 48.
Odi.
These was given by BBMP, my lord.
BBMP ನವರು ಕೊಟ್ಟಿರೋದು ನನಗೆ.
For 99 years.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಓದಿ.
Yes, para 2 ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಕುಮಾರ್ ಸಿಎನ್ ಇವರು ಬ್ರೈನ್ಸ್ ಸೋನ್ಸೋ ಈ ಆಸ್ಪತ್ರೆ ಅಂದಾಜು 100 ಕೋಟಿ ಬೆಲೆ ಬಾಳುವ ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಆಸ್ಪತ್ರೆಯನ್ನು ನಿರ್ಮಿಸಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ನಡೆಸಿ ಈ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಇಮೇಲ್ ಮೂಲಕ ದೂರು ಸಲ್ಲಿಸಿದ್ದು. Not he is the complainant.
Yes.
ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಆರೋಗ್ಯ ವೈದ್ಯಾಧಿಕಾರಿ ಸೋನ್ಸೋ ಬ್ರೈನ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಉದ್ಯಮಿಯನ್ನ ನಡೆಸಲು ಪಾಲಿಕೆಯಿಂದ ಉದ್ದಿಮೆ ಪರವಾಗಿ ಪರವಾನಗಿ ನೀಡಲು ಕೋರಿ ಸೋನ್ಸೋ ಆನ್ಲೈನ್ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು. ಈ ಸಂಬಂಧ ಉದ್ದಿಮೆಯ ಸ್ಥಳವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಉದ್ದಿಮೆಯ ಸ್ಥಳವು ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸ್ವತ್ತಾಗಿದ್ದು ಮಹಾಬೋಧಿ ಸಂಸ್ಥೆಯವರ ಪಾಲಿಕೆಯೊಂದಿಗೆ ಒಡಂಬಡಿಕೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ ಸದರಿ ಸಂಸ್ಥೆಯವರು 3ನೇ ವ್ಯಕ್ತಿಯೊಂದಿಗೆ ಮತ್ತೊಂದು ಕರಾರು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು ಸಾರ್ವಜನಿಕ ದೂರುಗಳು ಇರುವುದರಿಂದ ಸದರಿಯವರ ಉದ್ದಿಮೆ ಪರವಾನಗಿ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿರುತ್ತದೆ ಎಂದು ಹೆಂಬರವನ್ನ ಜಾರಿ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿ ಸದರಿ ಉದ್ದಿಮೆದಾರರಿಗೆ ಆರೋಗ್ಯ ಇಲಾಖೆಯಿಂದ ಯಾವುದೇ ಉದ್ದಿಮೆ ಪರವಾನಗಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲವೆಂದು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ ಮತ್ತು ಮಹಾಬೋಧಿ ಸಂಸ್ಥೆಯವರು ತಾವುಗಳೇ ಆಸ್ಪತ್ರೆಯನ್ನು ನಡೆಸುವುದಾಗಿ ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯೊಂದಿಗೆ ಒಡಂಬಡಿಕೆಯನ್ನು ಮಾಡಿಕೊಂಡು ಸದರಿ ಸಂಸ್ಥೆಯವರು ಬ್ರೈನ್ ಸಂಸ್ಥೆಯೊಂದಿಗೆ ಮತ್ತೊಂದು ಒಡಂಬಡಿಕೆ ಮಾಡಿಕೊಂಡಿದ್ದು ಪ್ರಸ್ತುತ ಬ್ರೈನ್ ಆಸ್ಪತ್ರೆಯವರು ನಡೆಸಿರುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. Based on that, my lord, no, the order is passed. Original lease, my lord, is with the Mahabodhi Society is valid. There is no dispute. Now is, my lord, invoking the provisions of private medical establishment with the allegation which is narrated in Annexure E, I'm sorry, Annexure H, may not be, my lord, maintainable. It is only patient's complaint kottu if there is any substandard, my lord, treatment, provisions can be invoked, not otherwise.
PME Act.
But I have produced page 51. Page 59. It is only, my lord, mechanism is provided for patients to air their grievance. Subsection 8 of section 7 and 9 is pertaining to, my lord, standards which are to be maintained by the hospital. (11A) is with regard to, my lord, patients who can register a grievance before the cell. Therefore, my lord, this provision may not be
The documents.
Yes, madam, under what provision can you cancel for violation of lease? Only provision is 15.
ಇದೆ provision ಇದೆ ಸ್ವಾಮಿ. Your lordship may kindly come to page 64, my lord, section 15. There provision is there, but violation
Cancellation of
15 ಬಿಟ್ರೆ ಬೇರೆ ಏನಿಲ್ಲ. There's no other provision except 15. And 15 only is on a complaint by a patient.
Patient.
And any direction issued in relation thereto. There's nothing which provides for lease violation.
Under the act, nothing is provided, my lord. Under the act, they are not supposed
can't
to
be
issue this.
excised.
Yes, but my lord, they have, this was leased by BBMP to one society, my lord. They have again subleased to the present petitioner. And the
BBMP can
purpose,
take action
your
for
lordships,
recovery of the possession.
purpose for which it was leased, it is not, they have violated that.
You can take action,
Yes, ma'am.
but not under this act.
Yes.
You can't take for 302 of IPC Andanja. There's nothing which is there. So you take action for violation of lease, recover the petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that while the impugned order dated 2/9/2025, bearing number so and so passed by respondent number 4, the Deputy Commissioner, Bangalore Urban District and Chairman of KPME, the license granted to the petitioner under Section 7 of the Karnataka Private Medical Establishment Act 2007 has been cancelled. The submission of Sri Satish K. and counsel for the petitioner is that any cancellation of license granted under KPME Act can be made only in terms of Section 15, and violation of any lease condition cannot be a ground for such cancellation in terms of Section 15. Thus, he submits that the action taken by the respondents is contrary to is not in accordance with the applicable law, and powers which have been excised by respondent number 4 do not exist in terms of Section 15 of the KPME Act 2007. Learned AGA would however submit that there is a gross violation of the lease condition inasmuch as the lease having been granted in favor of Mrs. Mahabodhi Society. The said society has entered into an agreement with the petitioner, and the petitioner has put up construction using the public land for private purpose. And as such, there being a violation of the lease condition, actions have been taken by respondent number 4. Heard Shri K. Satish and counsel for the petitioner, Ms. Sarita Kulkarni and AGA for the respondents, various papers. Whether there is a violation of the lease or not, what would be required to be considered is whether a violation could be a ground for cancellation of license under the KPME Act 2007. Section 15 of the KPME Act 2007 is reproduced hereunder for easy reference. A parallel of Section 15 would indicate that an action for cancellation of license can be taken, the penalty or suspension or cancellation of registration could be imposed on any private medical establishment on its failure to comply with any directions given by the Registration Grievance Redressal Authority under subsection 8 of section 7. A complaint filed by a patient regarding overcharging, violation of the patient's charter or private establishment charter, etc., as contained therein. The KPME Act, the license issued under the KPME Act is for the purpose of running a medical establishment, and the said license only governs the manner in which a medical establishment can be run under the said Act. The powers under the said Act therefore cannot be excised for a violation or any complaint as regards violation of a lease agreement as regards the land on which the private medical establishment has been constructed. If at all there is a violation of lease conditions between in the lease, as per the lease between BBMP and Mahabodhi Society, it is for the BBMP to take necessary action in terms of the applicable law as may be provided.
Serial number 74 argument.
The fourth respondent, Deputy Commissioner, cannot on the basis of violation of the alleged lease cancel the license without the requirement of section 15 being satisfied. In that view of the matter, I pass the following order. Writ petition is allowed. The certiorari is issued. The order dated 2/9/25 bearing number so and so at annexure H is quashed. Liberty is ever reserved to the BBMP to initiate such proceedings as may be permissible under law. Liberty is also reserved to respondent number 4 to initiate proceedings under section 15 if there is any violation of section 15. Certiorari quashed. Inನೇನ್ ಬೇಕು?
All other contentions may be kept open.
ಯಾವುದು?
My contention is that there is no violation of lease.
That you take if they initiate action. BBMP initiates action, you take action there, take your defense there.
The Lordship may say that all other contentions.
We are not saying yes or no here, because we are not considering that. It would be wrong on our part to say something on that. Next.
Please.
Serial number 68, Article 69.
Yes, Mr. Arvi.
Sought for writ of mandamus, my lord, annexure E and G, my lord, made up by the petitioners before the third and fifth respondent, my lord. Till date, the actions not taken by the respondent 3 and 5, my lord, they made on 6 September 2025.
You submitted the complaint to third respondent.
Field minutes. Third and fifth also, my lord. The station house officer.
SHO and superintendent of police.
Please, madam.
Yes, madam.
This is the endorsement that is given to him.
ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
ಕೊಟ್ಟಿದೀವಿ ಅವ್ರಿಗೆ, ಅಲ್ಲೇ ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ ಅವರನ್ನು. That is not stated before this court.
That endorsement, I don't know.
If it was received by the petitioner himself, my lord, his signature is also there.
Signature ಇದೆ.
ಅಲ್ಲ, I think so. What individual?
ಅವರು ತೋರಿಸಿ ಅವ್ರಿಗೆ. Petitioner is before this court seeking for the following leaves. And AGA on instructions submit that on the complaint being filed, endorsement has been issued to the petitioner detailing out in terms of the decision of the Honorable Apex Court, detailing out as to why the complaint cannot be registered in compliance with the judgment of the Honorable Apex Court in 2014 bracket 2 ACC bracket 1 Lalita Kumari versus Government of Uttar Pradesh, reserving liberty to the petitioner to challenge the endorsement if so advised.
Great. The liberty to challenge this. Please.
Petition stands disposed.
Great.
70, Satisha DJ.
Respondent number 3, Your Honor.
Satisha,
I have filed ವಕಾಲತ್ ಮೇಲೆ.
you have filed ವಕಾಲತ್. Objections file ಮಾಡಬೇಕಾ ಏನು?
Next date ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
Next date. Senior citizen, na?
Yes, file.
None appears for the petition. Learned counsel for respondent number 3 seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 4th, relist on 11th December.
71.
My lord, for the petitioner, my lord, notice under 126 of BNSS, my lord.
Yesterday's matter, same matter.
Notice, my lord, along with the notice, they should provide all the
Yesterday,
details.
Mr. Manmohan had a long argument on this.
I may also be permitted to produce some.
ಇನ್ನೇನಾದ್ರು additional decisions ಕೊಟ್ರೆ ಹೇಳಿ. ಅದರಲ್ಲೂ ಮಾಡೋಣ.
ಇದರಲ್ಲಿ ಅಷ್ಟೇ. In the notice, it does not, it is not
accompanied by order under 130.
Yes, madam. And does not say what is the allegation against me, what I should reply, and what is the amount for which I have to write upon all those things. To the point, judgments I may be permitted to produce. 3 judgments, 1 reported judgment, which says that, my lord, if there is no order under 111, it is liable to be quashed.
ಕೇರವಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ಆಲ್ರೆಡಿ. ಇವೆರಡು ಕೊಟ್ಟಿಲ್ಲ ಅವರು. ಕೇರವಲ್ಲ ಅಲ್ಲಿ ಪ್ಯಾರ?
My lord, ಯಾವ್ದ್ರ reported judgment, in that one, para number, my lord, para number 7, my lord, page number 9, my lord.
Yes.
On the basis of the complaint lodged.
Hanumantalli para?
My lord.
Hanumant versus state.
Hanumant, my lord.
Para number 8.
Hanumant. My lord, para number 5, my lord. Tahsildar has issued show cause notice.
ಆಯ್ತು ನಾವು ನೋಡ್ತೀವಿ.
Yes, my
Then
lord. And then
Rahim Ali,
Rahim's case, my lord. It is in para number 4, my lord. Page number 4. Page number 4 ali, my lord. A perusal of the said provision would indicate that the order is to be made in writing. The details.
page number ಅಲ್ಲಪ್ಪ, para number ಹೇಳಿ.
Page number 4 ali, internal para number 4 ಇದೆ.
ಅದು extract.
Yes, my lord, extract.
Extract in 7505.
Yes, ma'am. Adli para number 4. Writing
So
the
that
details
is
as
basically
regards the
para
substance of information.
5 ಬೇಕು ಅದರಲ್ಲಿ. ಇದರಲ್ಲಿ ಹನುಮಂತ್ ಅಲ್ಲಿ 5 ಅಂತ ಹೇಳಿದಿರಾ.
ಈ ರಹೀಮ್ ಕೇಸ್ ಅಲ್ಲಿ
Yes, 5 and 6. Kereval para 7 ಅಲ್ಲ.
Yes, ma'am. In Rahim case, my lord.
Kerevala was referred to by Manmohan yesterday, alva?
Pardon me.
Rustom Kerevala, this judgment.
Reported judgment.
In copy koಟ್ಟಿರು.
ತಗೊಳ್ಳಿ.
Heard, reserved.
Please, ma'am. One more aspect, my lord, he is a resident of Bangalore. He is not a resident. Only 10 years ago, there was one case in Bangalore, my lord.
We are only concerned whether
please.
The procedural requirement has been, this one will remand it back, they will pass an order. At that time, they'll have to consider that.
Please. My lord, till then, my lord, not to precipitate.
Respondents are restrained from taking any coercive steps against the petitioner till next date.
Please, ma'am.
72 urgent, serial number 73, only BS.
73 not.
It's a pass over.
66 ಜೊತೆ.
Pass over.
74.
73.
74.
73 pass over, 74.
My lord, it's yesterday's matter, my lord. I couldn't get the copy of the permission, my lord. Orally, they said they have received the permission, my lord. I'll get the copy if it is urgent.
ಕೊಡಬೇಕಲ್ಲಮ್ಮ.
I will get it, my lord, today. It could not.
Let them not precipitate, my lord.
ಏನ್ precipitate?
Further tender notification.
They have received their permission, which is
They have
submission
received,
is
my lord, that
being
is
made on instructions.
oral
Can we
instructions,
pass
my
an
lord.
order? Monday they'll produce it ಅಷ್ಟೇ.
I'll produce it.
If they produce it, your petition will go.
Andre, if they, my lord, one more submission.
If they don't produce it, the entire auction tender will go.
But one more submission is, they have called for tender for a total period of, my lord, covering 2 years. 9 months is already over for the year 25-26 and 26-27. The earnest money is, my lord, 41 lakhs. Even
If you keep on delaying like this, you'll be left with only 1 year. The AGA submits, on instruction submit that the permission has been obtained for issuing a short tender. Given 2 days time, she'll place the same on record. Released on Monday at 2:30 p.m. Monday 17th.
230 more matters. Ramesh Chandra.
Petitioner Archaka, hereditary Archaka. Last vacancy annexure B. He has to perform puja from October 1 to December 31. It is by rotation. 3 families are performing pujas.
Yes.
And I was given, annexure C. According to that, I have been given up to 31st of December.
You are, yes, Rajgopal.
Yes, my lord.
Ellide.
Annexure C may kindly be seen, 30th September, 31. I have given up to 31st January, 31st of December. Now, all of a sudden, it was reduced to up to November, my lord. Without any notice, nothing is there. Annexure A, my lord, 3rd November. And it was issued to me on, given to me on 7th of November. I have to perform my puja from 1st of October to, it was a practice and hereditary Archaka within 3 families.
So it's been reduced to 1511.
1511, annexure A. ಕಣ್ತಪ್ಪಿನಿಂದ ಆಗಿದ್ದು ಅಂತ
ಕಾಪಿ
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಲ್ಲಿ
ಅಲ್ಲೇ ಕೊಡಿ ನೀವು.
ಇಲ್ಲದ್ ಕೊಡ್ತೀವಿ, ಈಗ ಕೊಡ್ತೀವಿ.
ಇವಾಗ ಕೊಡಿ, ಅವ್ರು ಮಂಡೇ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ ಮಂಡೇ ಅಲ್ಲ, ಇದು 14 ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
ನಿಮ್ ಬೆಳಿಗ್ಗೆ ಹೇಳಿದೀವಿ ಯಾವ್ದು ಮೂವ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಕೊಡಿ ಅಂತ, ನೀವು ಕೊಡಲ್ಲ. How will he get instructions if you don't give him the copy?
ನಾವು ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ವಲ್ಲ ಅಂತ.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರೆ ಇವರು ನಾಳೆ ಇಲ್ಲಿಂದ ಹೋಗ್ಬಿಡಿ ಚೇಂಬರ್ಗೆ, ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಇಲ್ಲಿ ಬೇರೆ ಯಾವ್ದು ಕೇಳಿದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೇಡ. ರಮೇಶ್ ಹೇಳ್ತಾ ಇದೀವಿ ಕೊಡಿ ಅಂದ್ರೆ ನೀವು ಕೊಡಲ್ಲ. Anyway, 15th ತಾನೆ. The AG accepts notice for respond number 1 to 4. He seeks for and is granted 2 days time to obtain instruction, make a submission as to on what basis the term of the petitioner has been reduced from 31/12/2025.
Every year from
15/11/2025. Released on Monday.
Monday 17th.
Monday ಇನ್ನ ಇದೆಯಲ್ಲ, ಮಂಡೇ ಏನು
ಇಲ್ಲ 15th ಅಂದ್ರೆ
Monday
Saturday.
17th. Sorry. December. Pass over.
Serial number 2, Ganpati Bhatt.
ಮಂಡೇ ಅಂತ ಅವ್ರೇನ್ ಮಂಡೇ ಅಂತ ಬಂದಿಲ್ಲ ಅಂತ.
ಏನ್ ಮಂಡೇ?
ಅದೇ ಮೂವ್ ಮಾಡಿದ್ದೆ ಅವರು ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದೆ.
ನೀವು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ದು. Released on 15th at 2:30 p.m. 17th at 2:30 p.m.
Serial number 3, Harish S.
Connect to serial number 36 and released on
3rd December.
3rd December. ಯಾವುದು ಏನಾಯ್ತಪ್ಪ? ಫೈಲ್ ಎಲ್ಲಿ? ಮಂಡೇ ತರಿಸಿ. ಮಿಸ್ಟರ್ ಸುಭಾಷ್, ನಿಮ್ಮ ಫೈಲ್ ಏನೋ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ಅಂತೆ. ವಿಲ್ ಟ್ರೈ ಅಂಡ್ ಗೆಟ್ ಇಟ್ ಆನ್ ಮಂಡೇ. ಮಂಡೇ 2:30 ಲಿಸ್ಟ್ ಮಾಡಿ ಮಂಡೇ.
ನಾಳೆ
ಯು ಆರ್ ದೇರ್ ಇನ್ ದಟ್ ಮ್ಯಾಟರ್ ಪ್ರಮೋದ್? ಯು ಆರ್ ಇನ್ ಮಿಸ್ಟರ್
ನಾಳೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಳಗಿದೆ ಮ್ಯಾಟ್ರು. ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರಿಲ್ಲ, ಪ್ರತಿ ಸಲನು ಬಯಸ್ಕೊಳ್ತೀನಿ, ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಹಾಕ್ತಾರೆ.
34 we had filed appeal, my lord, within 3 months from the date of receipt of the award.
The file is misplaced here. So you also support Mr. Subhash tomorrow and make the submission so that.
I am not pressing the matter over there. There is another counsel, I think. I will inform you.
Who is the other counsel?
ಬೇರೆಯವರು ಇದ್ದಾರೆ, ಅವ್ರು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ.
Nim counsel ತಾನೆ? Nim counsel ನೀವು ಹೇಳಿ so that they don't press the matter. We'll take it up on Monday when the file comes. Mr. Subhash has been moving the matter on last 4 or 5 times he has moved. But the file did not come, and that's why we specifically asked the caseworker to come. ಬರ್ಲೇಬೇಕು, ಅದು ಬಂದಿಲ್ಲ because the file is misplaced. Monday it will come. Monday ಬರಬೇಕು. 2:30 on Monday.
List number 1, hearing on IAS serial number 75.
Please, your lordships, I'm for the petitioners. Your lordships, this is a matter where without cancelling.
You switch off your.
I'm sorry, my lords. Without cancelling the first tender, my lords, a subsequent tender was issued. And this honorable court had granted interim orders staying the second tender, my lords. During the pendency of the proceedings, another invitation for price list was floated without uploading the same on KPP portal, my lords. And a work order also was issued to some private party who was not a participant of both the tenders, my lords. Hence, we were constrained to file a contempt petition stating that they had violated the orders of this honorable court. And subsequent to the contempt petition being admitted, my lords, the respondents come before this honorable court and they file the statement of objections, my lords. Your lordships, they take up 2 contentions in this matter, my lords. The first is they say that I have not availed my alternate efficacious remedy under section 16 of the KTTP Act, my lords.
Yes.
Appeal. For that, my lords, the very commencement of the section 16 states that any tenderer aggrieved by an order passed by the tender accepting authority. Now, this is a case where there is no order that has been passed, neither cancellation order nor has my bid been rejected. I qualified the tender and subsequently another tender was issued for the same quantity and bearing the same number, my lords. It bears the same layer.
The same number?
Yes, my lords. The first tender was issued on 27th of September 2023. That is in Annexure F, my lords, of the petition. Annexure F, page 42, my lords. This is on top, my lords, page 42, case NSC 258-23-24, my lords. Your lordships, the second tender, sorry, this happens to be the second tender, my lords. Annexure F is the second tender. First tender is Annexure C, page 21, my lords. Same number, my lords. KSNSC bar 258 bar 2023-24, my lords. For the same quantity, same products, my lords. The first tender, Annexure C, was issued on 27 September 2023, my lords. Second tender comes to be issued on 14th of December 2023, my lords. I am before this honorable court on Jan of 2024 when a stay order comes into the picture, my lords. When this honorable court was pleased to grant a stay order, my lords, on the second tender, Annexure F, my lords.
Quantity is changed. From 1 lakh, it become 1,25,000.
No, it is 1,25,000 itself for both, my lords.
First one is 1 lakh. Annexure C, Annexure F is 1,25,000.
My lords, I draw the attention of this honorable court to page 33, that is in the first tender, Annexure C. First tender, my lords, it's 1,25,000, 1,25,000 and 1,28,000, my lords.
So facing sheet is different.
I apologize, my lords. And the second tender also the same quantity, my lords, and same products, my lords.
Yes.
Your lordships, during the subsistence of this interim order, they go on to issue another private invitation for price list, my lords, which was not uploaded on KPP portal at all, my lords. And that was also for the same products, though the quantity was drastically different, my lords. It was 25,000. They remove 1 lakh, they make it 25, 25 and 28,000.
Immediate requirement.
Immediate requirement, but for which we filed, because they could have come before this honorable court and sought the permission of this honorable court on whatever grounds, and they could have argued this matter on merits, my lords. After I filed a contempt, they filed a statement of objections, and subsequently, in the statement of objections, they take up two contentions. One, I have not availed section 16. The second is the scope of judicial review when it comes to cancellation of tenders, my lords. As far as judicial review is concerned, my lords, on the last date of hearing,
Section
I had
14.
submitted a
14.
Yes, my lords. I had submitted a memo of citations.
Memo of citation?
Yes, my lords. I had the second
citation again. Yes.
Yes, my lords. The second citation, that is from running page 11, my lords, was the Apex Court passed an order, judgment dated 9th July 2024, my lords, running page 11, where both the concepts are answered, my lords. Whether in analysis G, scope of judicial review of actions of the state in matters relating to contract and tender under writ jurisdiction. Second being whether action of cancelling the tender is arbitrary or unfair and in consequence of violation of Article 14. Your lordships, this was a case where there was a valid cancellation, my lords, and the tender was cancelled for two reasons, which is answered in running page 40, my lords. In running page 40, para 73, they say before we proceed to determine whether cancellation of tender could be termed as arbitrary, it is necessary to understand the stance of the respondent in the present litigation as discernible from their pleadings, which has left us quite perplexed. The argument of the respondent is twofold. First, tender had to be cancelled as there was a technical fault. The tender was found to be non-specific and not well defined. As a result, it created ambiguity, resulting in financial losses to the respondent. Secondly, the cancellation was also on account of a change in policy, whereby operation and maintenance of concerned underpasses had been handed over to another authority. The primary
There's no change.
Yes, my lords. This cancellation was held to be invalid, my lords. The primary thrust of the respondent's contention is that the decision to cancel the tender was taken in view of technical faults in the same. More particularly, the ambiguity as to whether the advertisement boards could be put up beyond the area of the concerned underpasses. Then subsequently, various citations are relied upon, and the necessary, the relevant portion, my lords, would be in paragraph number 107, my lords. Sorry, after public interest is also considered, my lords. Paragraph number 110 is relevant, my lords. What they state is, thus the respondent's reasoning in notice in the notice of cancellation that it was incurring financial losses from the aforesaid tender does not hold well either. It has been contended by the respondent that due to the ambiguity in the tender as regards placement of advertisements, many interested bidders might not have been able to submit their bids. Thus, the respondent formed the view that if the ambiguity is corrected, a higher license fee could be fetched. Even financial considerations, my lords, was not a ground for cancellation. Then subsequently, my lords.
Because it was found not to be so. If there was a reason, if there were facts which established, it would have been a reason.
Yes, my lords. But even if there was financial losses, can they even proceed with the? Can they
Obviously,
cancel?
employer cannot be with financial losses.
Yes, oh, fine. My
Unless you
lords,
are do one thing, give it free, then there's no problem. Financial losses is always a ground. That's what the court has said. They are not able to demonstrate it.
Yes, my lords. Now, paragraph 122, that is the last paragraph, my lords. From the above discussion, we are of considered opinion that the present list is nothing but a classic textbook case of an arbitrary and capricious exercise of powers by the respondent to cancel the tender that was issued to the appellant on the basis of extraneous considerations and at the behest of none other but the concerned minister in charge. Your lordships, this is a matter where the minister in charge himself had intervened to cancel the tender. Now, in the present case, my lords, there is no cancellation in the first place, my lords. Hence, I appeared before this honorable court seeking relief, my lords.
Now you have bid for this tender.
The first tender we bid, my lords, we qualified for the technical round. We were L2 bidders, my lords, and L1 was subsequently found to be not having certain eligibility. So we were on the verge of winning the first tender, my lords.
So both the technical evaluation, financial evaluation has happened.
Yes, my lords.
After that, the second tender was issued.
After that, second tender was issued on 14th December, my lords.
Yes, madam.
Section 21 of the General Clauses Act, my lord. I did not.
General clause.
What, my lord? Power to issue, comma, to include, power to add to, comma, amend, comma, vary, or resign notifications, comma, orders, comma, rules or bylaws, where any central act or regulations a power to issue notifications, orders, rules or bylaws is conferred, then that power include a power exercisable in the like manner and subject to the like sanction and conditions, if any, to add, amend, vary or rescind any notifications, orders, rules or bylaws so issued. My lord, we called tender notification.
So you can cancel it.
No, my lord, we called tender notification. L1 is qualified. We went through all the procedure and we checked. There is a lacuna, U-check report is not available. Hence we cancelled.
What check report is not available?
U-check report, my lord.
What is
For
U-check report?
printers, that paper, my lord, A for quality papers, U-check report, because we are registration certificate we are issuing, that must be maintain the quality. So we required for that particular papers what they are submitting, it should be contained with a U-check report certificate. They don't have. Then what we did, we modified the guidelines of the tender. Then issued on 7/10/2023. 7/10/2023, we have issued certain guidelines, corrigendum is issued.
Page?
No, not. Annexure D, page number 38, my lord. We check, my lord. I'm sorry, my lord. We check report. Serial number 5, my lord. In main serial number 3, in second column, my lord, specification in that 5, my lord, we check.
We check.
mentioned.
We check was there earlier also.
No, L1 is not qualified, my lord. We specifically mentioned and modified the guidelines and issued a corrigendum called the second tender. He is very much represented before the, he participated second tender also and filed an objection pre-bid meeting. Then we called for him to give a certain, according to your objection, give a evidence and documents.
When was the second tender issued?
14th December 2023, my lords.
You participated.
Yes, my lords. In the pre-bid meeting that was conducted on 16th December, where we took up a contention saying what happened to the first tender.
Did you participate
Yes,
in
my
the
lords.
second?
Yes, my lords.
After that, you filed this.
Kindly be seen, my lord.
my lords.
Original records I will show, my lord.
After that, you filed the petition.
Just one submission, my lords. Annexure H has the representation where our only objection is how are you issuing a second tender without completing the first tender?
But you did participate.
Yes, my lords, but bids
You
were
did not come before us on the cancellation of the
We
first
didn't submit the
tender.
bids, my lords. We did submit the bids in the second tender.
Hmm.
We were before this honorable court and stay was granted by them. 18th Jan is when the second tender opens, my lords. 22nd Jan, we were before this honorable court and we had sought for interim orders.
My lord, in pre-bid meeting, he filed an objection, my lord.
Yes, ma'am.
Yes, fine.
The
Now,
third contender.
what is the change that you have made in the first tender and the second tender?
My lord, we have made a specific changes with regard to.
What are those changes? Show us the changes.
My lord, what happened? L1 was qualified, but he
We are
doesn't.
not concerned with L1, L2, L3, madam.
Yes.
We are concerned with first and second tender. What are the changes that you have made? And does it come within the purview of section 14 of the KTTP Act? Section 21 of General Clauses Act will not apply. And there is a specific act
My
which
lord,
applies.
section 14 comes once the participant is eligible only, section 14
No, no,
comes.
no. Please read it properly. Now, what are the changes that you have made between these two tenders?
Changes are records.
ರೆಡಿ ಇದೀರಾ ಇಲ್ವಾ?
Meanwhile, my lord.
Get ready.
Meanwhile, my lord, one submission. Meanwhile, my lord, he participated second tender.
He has
when
not
called-
participated.
No, my
He's
lord,
not-
he filed a pre-bid meeting objection. He filed against the third contenders. He filed an objection.
Did he submit a bid, madam?
My lord.
Did he submit a bid?
No, my lord.
Then what
He
is the
filed an
participant?
objection. To consider his objection, we given RPD acknowledgement.
Don't try to
give
be
the-
finding fault with them. First, justify your actions. Do you come under section 14 or not? If you don't come under section 14, you cannot cancel a tender once issued.
My lord, we have not cancelled at all. We have modified the guidelines and we issued. He is not qualified.
Madam, you are walking on very thin line.
My lord,
You are walking on very thin ice if that is the content.
no, my lord, I have a powers. I am an authority
You
called
don't
for
have,
tender.
you don't have the powers. That is the problem. You think you have all the powers, you are regulated by the KTTP Act. If your officers think that they are unlimited power,
14, section
unbridled
14,
power,
My lord, your lordship is correct. Section 14 deals with specifically with regard to qualified bidders. Once the bidder is qualified, in government in such a situation want to cancel, then they have to give a reasons and cancel. Otherwise, it is, he can come to the court. But once there is no qualification at all for the pre-bidder, then how can he will come to the court? I have a right to add the modification rules, regulation, being at,
okay, we'll deal with your submission. Don't worry.
I will submit, my lord.
So according to you, section 14 doesn't apply at all.
No, my lord, it will applicable.
Huh.
Once the bidder is, if he bids,
In this case, does it apply or not?
my lord.
In this case, does section 14 apply?
No, my lord, in this case, not applicable.
So in
Why
the
means
justification ilvalla.
L2, he is a L2, we modified the guidelines of the tender notifications. Hence we called again. He is participated and filed an objections. For that also we considered his objections and we requested to give the proof and evidence. He didn't respond at all. And acknowledgement I submitted, my lord. Acknowledgement the postal Shara came. The such address is not there. Postal original RPD Shara is there.
My lord,
Such
just one
address is not at all found. Now before the meeting only he is not available means what service he will give us?
My lords, let them state to whom they have addressed that letter to, my lords.
Place it on record. You're keeping everything in your file and making your submission. Place it on record, whatever you want to say. File an affidavit of your competent person. You want to file it or you don't want to file it? Yeah, nobody wants to sign it. Huh?
My lord, our submission is this much.
All your arguments sound good just like that. Without justification, there are no
21
use.
very much applicable. my lord.
21 will not apply when 14 is there.
No, my
A
lord,
specific
14 is very
provision.
much applicable. Your lordship is correct. Once the it is happened and in unavoidable circumstances, government can cancel with the reasons. But if it is not itself is.
Only reason is render the procurement unnecessary or impossible. Those are the two reasons. The other reasons could be reject failure of anticipated financial resource, accident, calamities, or any other ground as may be prescribed, which would render the procurement unnecessary or impossible. They are conditional. If both of them don't tag with each other, you can't do it. And what do you want to do? That's your argument?
Modified of the guidelines is there, my lord. According to that, let him participate in second bid also. He is there already.
You cannot be doing like that. Can't be. There's no purpose in that. Ashtena, 14 not applicable, Ashtena.
My lord, tomorrow, my lord, I will come with. Just one small cross verification.
At
That's
the
all.
request of Learned Counsel for respondent released on 17th at 2:30 PM, it's made clear that no further adjournment for further hearing.
Interim orders may be extended.
Interim order earlier granted is extended till next day.
Much obliged.
4 o'clock, ma'am.
4 o'clock, madam.
List number 2, serial number 6. Chetan AC.
Eli, Professor Kumar Eli.
Is in Portal 3, Prajwal Revanna. That unfortunately same day it is.
ಮತ್ತೆ ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲಪ್ಪ 4 o'clock ಬರ್ತೀನಿ ಅಂತ.
Sudden ಆಗಿ ಇವತ್ತು he has come from Delhi, Mr. Luthra has come from Delhi.
So that will go on.
Go on. ನಾಳೆಗೆ ಹೋಗ್ಕೊಳ್ಳಿ.
ನಾಳೆ ಇಲ್ಲ, ನಾಳೆ CMPD.
Can we see, my lord, how many days they have taken? They always take adjournment. I don't want to complain, but they
What do you-
have an interim order and
Order sheet
it's at
for-
their instance, it's getting adjourned.
What to do if you're stuck in some matter? We understand that. Monday, we won't give you any agenda. It is submitted to the senior counsel appearing for the petitioner. He is on his feet in another matter. Hence released on 17th at 4 PM. It is made clear that no further adjournment would be granted. If the learned senior counsel is not available, learned advocate on record is directed to get ready and address his arguments or make such other arrangements.
Interim order may be.
ಏನಂತ entry model?
Tender at stay.
Stay ಆಗಿದೆ.
We can't proceed.
Then they're right there. 10 days stayed ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಟೈಮ್ ಆಗತ್ತಲ್ಲ. You are the existing workers.
Existing.
This is at outsource.
Correct. No, but the problem is these, all these tenders stand stalled. I also reflect on what your lordship said. There is, of course, a larger issue to be addressed, but while we will look into it, but these tenders also let them proceed, because now there are bidders who have whose bids, I mean, they have qualified as L1. On the other hand, simultaneously, of course, we can look into that issue, but let them at least let the work start.
Today we are seeing the petition, and all the things that we pointed out, they have raised the points there.
That what your lordship said, of course they've raised it. In fact, my learned friend pointed out also that there is a condition in the in the tender.
We have one that passed some 3-4 judgments. You can actually look at those judgments. We don't need to rehash that.
It's also for the state to take a call on the.
Have you filed your objections? And you file your objection by Monday. That your objections are also there. Because ಆಮೇಲೆ regularization ಬಂದಾಗ you oppose. So now if you take a stand, if tomorrow they hire the same people and they file an application, you can't oppose. You have to take one stand and stick to it. You can't be dilly-dallying on both sides. Let them do whatever they want. Then objections of the state to be also filed before 17th. 17th at 4 p.m. Interim order earlier granted, it extended till later. They continue. Fast over. 4:30 alla next matter. Fast over.
Passed over matters. List number 1, serial number 40, Balram R. Rao.
But in this case, I was on my legs, my lord. I told my friend I'll be taking.
That is why next Andre we always suggest,
3 day or 19th, my lord. I told him, my lord, I'll be taking time.
You'll be taking time. When will you
Please,
get it?
19th, my lord, 19th or 17th or any date.
19th is fine. 19th or 20th.
Please, 20th.
At the request of the learned DSG, I released on 20th.
I apologize.
We understand. Any interim order in there? Extend madbeka? Nodi.
Interim order is there.
Interim order earlier granted is extended till next day.
Serial number 66, Murli BS.
ಎಲ್ಲಪ್ಪ ಶಿವರಾಮ್ ಅವರು ಫೋನ್ ಮಾಡಿದ್ರ ಅವ್ರಿಗೆ? ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಆಗ್ತೀವಿ ಅಂತ ಹೇಳಿ
ನಾರ್ಮಲ್ ಇರ್ತಾರೆ.
ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದು.
2 ಮ್ಯಾಟರ್ನಲ್ಲೂ ಬರಲಿಲ್ಲ. ರೈಟ್ಸ್
ಮಸ್ಟ್ ಬಿ ಆನ್ ಹಿಸ್ ಫೀಟ್ ಸಮ್ವೇರ್. ಬರ್ಬೋದಲ್ಲ ನೋಡೋಣ.
ಅದಿನ್ನೇನಿಲ್ಲ, ಅದು ಕ್ವಾಶ್ ಆಗಿರೋದು ಸರಿಯಾಗಿದೆ. ಇಟ್ಸ್ impugned order quashed. Direction not to issue license only to that person. That's the
ಇಲ್ಲದೆ ಇರೋ
only thing.
ಇಲ್ಲದೆ ಇರೋ
Then that is to be considered by the authorities and fresh orders are to be passed.
66 and 73 connect to each other and relist on 18th at 2:30 p.m.
Then pursuant to the directions in the earlier matter, which I sought for review, now they are proceeding to issue the license not to the 5th respondent here.
Respondents are restrained from issuing license to the 5th respondent WP 29552 of 2025 till next date of hearing.
Obliged.
List number 3, Ramesh Chandra.
Ramesh, bani. ಏನಪ್ಪ ಆಯ್ತು?
3 months was allocated to their family blood, 1.5 months for him and another 1.5 months to his brother. ಇದಕ್ಕೆ ಇದು ಮಾಡಿದ್ದೀವಿ. Documents they have first annexure C ಮಾಡಿದಾಗ they have not produced any document. Thereafter they have produced a document based on that 1.5 months. It was restricted for 1.5 months.
ಈ ವಾಶ್ಮನ್ ಕಳಿಸಿ ಅನೆಕ್ಸರ್ ಬಿ ನಮ್ಮ ಬ್ರದರ್ ಇದ್ರಲ್ಲೇ ಇಲ್ಲ.
ನಿಮ್ ಬ್ರದರ್ ಎಲ್ಲೋ ಹೋದ್ರು ಮತ್ತೆ?
ಅಲ್ಲ ಬ್ರದರ್ ಪೂಜೆ ಮಾಡುವಂತ ಇಲ್ವೇ ಇಲ್ಲ. ಲಕ್ಷ್ಮಣ ಅನೆಕ್ಸರ್ ಬಿ ಮೇಲೆ ಕಳಿಸಿ.
ಬ್ರದರ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ.
ಅದೇ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು.
ಇಲ್ಲ ಸ್ವಾಮಿ you lost my
ಮತ್ತೆ
kindly
ಇನ್ಯಾರು
sir.
ಕೊಟ್ರು?
ಅದ್ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು. Annexure B may kindly be seen, it is specifically given to me. ಇವತ್ತು ಯಾರೋ ಬಂದು ಮಾಡಕ್ಕಾಗಲ್ಲ. Annexure B ನಲ್ಲಿ it is in the year 1988 ಇಂದ 37 years ನಾನೇ ಮಾಡ್ತಾ ಇರೋದು. 3 ಫ್ಯಾಮಿಲಿಗಳು, ಅದರಲ್ಲಿ ಸಂಪತ್ ಕುಮಾರ್ಗೆ 6 ತಿಂಗಳು, ಕೃಷ್ಣಸ್ವಾಮಿಗೆ 3 ತಿಂಗಳು, ನನಗ್ 3 ತಿಂಗಳು, ರಾಜಗೋಪಾಲ್ ಅಂದ್ರೆ ನಾನೇ. Brother, he has not claimed anywhere, not even put his.
He'll have it tomorrow, please. As a request to learned AJ, release tomorrow at 2:30 PM.
That's all.
List number 1, serial number 76. M. Narayan Swamy.
I filed a impleading application.
Impleading up.
Please, my lord. This is the writ of mandamus, my lord, wherein, my lord, the petitioner has sought for deletion of the temple from the gazette notification.
ನೀವ್ಯಾರು?
I am the Archaka, my lord, wherein we are staying in the waters of the premises, my lord, and we are performing the puja to the temple, my lord. There is a civil dispute between the trust and the petitioner trust and the proposed applicants, my lord.
You make a, when they consider it, you give your objections to them.
Please, my lord, I may be permitted to
Give their objection.
participate in the proceedings.
Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that the representation dated 11/6/2024 at Annexure A submitted by the petitioner to respond number 2 seeking for deletion of the temple managed by the petitioner from the list of Muzrai temples has not been considered. An impleading application has been filed by the Archaka of the temple contending that the same cannot be deleted.
Yes.
Even if such objections were to exist on part of the impleading applicant, the representation having been submitted, it is for respond number 2 to have considered and passed necessary orders either accepting or rejecting the request made by the petitioner. Needless to say, if an order of rejection is passed, same would have to be accompanied by reasons. Hence, I pass the following. A writ petition is allowed. Respond number 2 is directed to consider the representation dated 11/6/24 of at Annexure A made by the petitioner within a period of 30 days from the date of receipt of a copy of this order. While before passing the said order, respond number 2 shall also provide a hearing to the impleading applicant.
77, Ajit PB.
I appear for the petitioner, my lord.
Yes.
My lord, one impleading application is filed by the impleading applicants
Hmm.
saying that they are the original complainants, my lord. The complaint is at page 84 of my petition. In 84, my lord, it is addressed as members of Indranagar Club, Bangalore to DR. So their names are not forthcoming. Nevertheless, they have signed below that, my lord. So on this score, they have filed an impleading application, my lord. My lord, what has happened? This complaint was filed before DR, saying that there are some irregularities in election conducted dated 36/2024.
You are challenging only a notice which has been issued.
A notice,
Show
my
cause
lord.
notice. Show cause
Show
notice.
cause notice. For that, my lord, they are not the necessary and proper party.
They are not necessary party, but your writ petition is not maintainable.
That's because,
You go and give your reply to them, they will consider it.
well, it's because the subject matter of election does not come within the purview of section 25, my lord. They are saying they have also filed the civil suit before the civil court.
Where does it say election?
My lords. My lords.
Where does the notice say election?
Let's not.
Duru arji vicharanegagi.
Please, my
Where is
lords.
the Duru arji?
That Duru Arji is at page 84, my lord.
Misappropriation of sale of liquor. Misappropriation by club staff. Enquire decision of general body. ಅದೆಲ್ಲ ಬರುತ್ತೆ ತಾನೆ?
ಅದೆಲ್ಲ ಬಂದಿದೆ, my lords. My only submission is this is afterthought of their
Petitioner
application.
is before this court
My lords,
seeking for the
my lords,
following
one
relief.
submission, my lord.
What essentially what the petitioner is challenging is a notice issued by respond number
2.
2 dated 29/8/2024 at Annexure A for calling upon the petitioner to show cause in respect of inquiry to be conducted by respondent number 2 in pursuance of complaint received at Annexure F dated 37/2024. If at all, the copy of the complaint being made available to the petitioner, it is for the petitioner to have replied to the said show cause notice and not approach this court seeking for the opposite relief. A writ petition challenging a show cause notice not being maintainable. In the interest of justice, the time granted in the notice dated 29/8/24 is extended by a period of 1 week from today to enable the petitioner to reply to the said show cause notice. The reply to be made on or before 21st November 2025, failing which respondent number 2 would be free to proceed with passing orders.
Great.
I 1/24 stands dismissed.
78.
My lords, I appeal petitioners, my lords. I filed a withdrawal, my lords.
Memo for withdrawal dismissed as withdrawn.
Great.
79.
I appear for petitioner in this case, my lords. This is with respect of the tender matter, my lords.
There is an arbitration clause, my lord. The termination is already upheld. And
My lords.
What is this? As regards, what have you
Regard,
checked?
my lords, the tender was issued in favor of the respondent number 3, my lord, division. Since I am the L1 bidder, I have started my work in the division of respondent number 3, my lords.
Your contract has been cancelled.
No, yes, my contract has been cancelled.
Contract has been cancelled, and you have to invoke the arbitration clause.
With saying that I have not produced EPBG document. That explicitly says in annexure C, my lord, that bid document is not required for the.
During the tender stage, we can exercise jurisdiction. After a contract or a work order, it's a contractual remedy.
Work has been already begun, my lord. I have worked for
They have
3 months.
terminated it. Not arbitration.
There is no service level agreement, my lord. Service level agreement ಇರ್ಲಿಲ್ಲ ಅದರಲ್ಲಿ.
Agreement ilva.
ಹೌದು.
But ಇದ್ರಲ್ಲಿ ಇದೆ ಅಲ್ಲ.
This contract has no such clause to go before the
Then you'll have to
arbitration.
go to civil. Ilva arbitration clause ಇಲ್ಲ.
yes, my lord, there is an arbitration
Page?
clause. Clause 8, my lord.
Page.
Page number 102, my lord. (8.2) demand for arbitration.
Accepted matter termination ಇದೆಯಾ?
My lord, it is arbitrable, my lord. It is arbitrable.
Termination is arbitrable.
The termination has been challenged before this honorable court on various things, my lord. Page number 184, my lord. That action was also upheld by this honorable court.
184.
Yes, my lord, 184.
184.
Yes, my lord.
ಇಲ್ಲಪ್ಪ 184 is some
It was,
bills.
the writ petition was partly allowed.
184 is some bills.
Yes, my lord. He was not allowed to participate in other bid.
The only thing I have not produced the EPBG, electronic bank guarantee.
His contention is that, my lord, he is not required to produce any bank guarantee. In this particular tender document, my lord, he was supposed to produce the electronic bank guarantee. And then after the commencement of the work, we called upon him to provide the electronic bank guarantee. He says that I am not at all required to provide any bank guarantee. On that pretext, my lord, his work was terminated. And now the issue is that, my lord, we had provided him one particular storeroom, my lord. In that particular storeroom, he had kept his housekeeping materials, and he has filed an application to remove those housekeeping material. And now he has locked that key particular premises and keys with him.
Not
only.
true, madam. It is not
And
true.
at least let him remove his material and provide that particular premises to us, my lord.
So accept your termination.
Our division ಅಲ್ಲಿ ನಮ್ಮ ಲಾಕ್ ಹೇಗೆ ಮಾಡೋದು? That is their division. Our division ಅಲ್ಲಿ ನಮ್ಮನ್ನ ಹೋಗ್ಲಿಕ್ಕೆ ಬಿಡ್ತಿರ್ಲಿಲ್ಲ ಅವರು.
ಕೀ ಕೊಟ್ಬಿಡಿ ಇಲ್ಲೇ. ಹೋಗೋದ್ ಬೇಡ.
We have made oral request.
If you have the key, just give it to him. They will open it and go. They'll have to file a
You made
section
several
9.
Let him-
oral
my-
requests.
He wants his material, my lord. It is must be few lakh rupees material. Let him take those material, my lord. Let him come and collect it. We will facilitate for that. And let him challenge all these actions, my lord, our action before the arbitral tribunal, my lord. At least he will get his material, my lord. This is, the application is also pending.
If you want it.
Yeah. Yes, my lord.
Petitioner is before this court seeking for the following reliefs. Essentially, what has been challenged is the termination of the contract entered into between the petitioner and respondent number 2. The said contract being governed by an arbitration clause in terms of clause 8.1 in chapter 8 thereof, learned counsel for respondent number 1 to 4 submits that the petitioner can always agitate all his claims in the arbitral proceedings, including a challenge to the termination. His submission answers the grievance of the petitioner inasmuch as a certiorari cannot be issued to quash a termination of a contract after the contract has come into being. One other issue which is arising during the course of arguments is as regards certain material of the petitioner which has been stored in the storeroom of respondent number 3.
Yes, correct.
Where the counsel for respondent 1 to 4 submits that the petitioner can call upon respondent number 3.
Yes.
At a mutually agreeable time.
Yes.
And remove any of the materials that are of the petitioner. Yes. Which are available in the said storeroom.
Yes,
Do you want us to fix the time or?
Yes, my lord. Fix a time.
Both the counsels submit that date and time could be fixed by this court for the said purpose. In that view of the matter, I pass the following order. Writ petition is partly allowed. The petitioner is reserved liberty to agitate all his claims in arbitral proceedings as and when initiated. The petitioner shall call upon the office of the third respondent at 10:30 a.m. on 24th November 2025 for receipt of all the, for removal of the material belonging to the petitioner, which shall be so removed by drawing up an inventory signed by the petitioner and representative of respondent number 3.
Lord, instead of 24th, my lord, I need to communicate them, my lord. One ಸ್ವಲ್ಪ ದಿವಸದ ಇದನ್ನಾದ್ರೂ.
1st December.
Yes. And he's supposed to hand over the premises to us, my lord. That is
Once he removes what is.
Serial number 80.
This case, I am for the respondent KDB, my lord. The connected matter is on 24th, my lord.
Who is R3?
Yes, Karnataka Udyoga Mitra, my lords.
And AGA accepts notice for respondent number 3. Connect with?
Connected with, it is already connected, my lord. Posted on 24th 11.
Number 8.
Connected matter.
36154.
36154.
Of so and so and relist on?
2024.
24/1.
24/11. 11.
24/11.
Another date was given, my lord, on 36321. 1/12 date was given. That matter also connected.
ಅದ್ಯಾವುದು ಇನ್ನೊಂದು ಮೂರು ಮ್ಯಾಟ್ರ್ ಇದೆಯಾ?
Yes, my lord. Same.
ಎಲ್ಲ ನಂಬರ್ ಕೊಟ್ಬಿಡಿ. Connect with so and so and relist on 24/11. Interim order earlier granted is extended.
This is interim order is not granted to this one.
ಇದ್ರಲ್ಲಿ ಮಾತ್ರ extend
Yes,
ಆಗುತ್ತೆ.
81. Virendra Sharma.
Petition, early hearing application has been filed.
Hello,
Hello.
ಅಷ್ಟೇನಾ?
Date may be fixed very
Readings
short.
complete Readings complete ಆಗೋ ಮುಂಚೆ early hearing ಆಗ್ತದೆ.
Short date may be.
ಹಿಂಗೆ early hearing ಎಲ್ಲೋ ಮಾಡೋದು. Yes, you want to file objections? IA 1/25 cannot be considered since the pleadings are not complete. Learned AGA seeks for and is granted 10 days time to file a statement of objection. Objections, if any, to be filed on or before 5th November, relist on 11th December.
82.
I appear for the applicant, my lord.
Impleading applicant, Mr. Chidananda?
I may have no objection, my lordship may allow the.
No objection.
No.
Who are you?
It's a petition for
Please tell us
mandamus.
that.
It's a petition for
Right,
mandamus.
I'll just like.
My petition.
The
my lord.
petition, my lord,
pleading.
this writ petition, one second, this writ petition will have to be dismissed for the suppression of earlier, the criminal case filed by the petitioner, my lord.
My lord, the petitioner before applicant to your lordship, my lord, an agreement to sell without possession was entered with Satya Chandan. Annexure R1 is the agreement of sale. My lord. So he did not perform, my lord. The petitioner came to purchase this property, my lord. It was sale deed was executed by in favor of him on 31/3/2023. He is in possession of the property.
He has no objection for allowing your application.
Please.
Though he says no objection, we have to give some reason.
Yes.
Who are you?
Now the relief is, your lordship, kindly see the relief.
If my
What is the
senior
relief
colleague is
sought?
gracious enough, I'll just state my case. Only my lord, state my case as to who is the impleading applicant.
Who are you and here but allow ಮಾಡಿ ಬಾಕಿ ಎಲ್ಲ
I
ಮಾಡ್ತಾರೆ.
have sold the one of the unit to the petitioner by registered deed, and he files a police complaint stating that, my
You are
lord,
the
I have
developer.
suppressed the earlier agreement
You are
of
the
sale.
developer.
Yes.
IA 1/25 has been filed by a developer to implead himself as a party respondent in the proceedings. Considering that the petitioner has no objection to the said application and the developer having sold the concerned unit to the petitioner, the presence of the impleading applicant being necessary to decide the list between the parties, IA 1/25 is allowed. The person named in IA 1/25 is brought on record as respond number 4.
Please, my lords.
Counsel for the petitioner to carry out necessary amendment and file amended cost title. Objections ಹಾಕ್ಬೇಕಾ?
Objections ಹಾಕ್ತೇನೆ. Just 1 week.
3 weeks time is granted to the respective respondents to file their respective objections, which shall be filed on or before 5th December, released on 11th December.
Would it be at 2:30, my lords? Because short point, only my lords on the question of mandamus. Now, my lords,
Everybody wants 2:30, everybody wants the matter to be taken.
the dispute is, my lord, your lordship, I'll just make
We'll
two
take
sentences.
it in sequence when it comes. Lord, don't try to jump these.
At least in fresh matter, the preliminary hearing.
Preliminary hearing.
Please.
I'm great.
4:30 matter.
4:30.
List number 2, serial number 7.
ಬಂದಿದಾರ? ಆಯ್ತಿಲ್ಲ, ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಬಂದಾಗ ಹೇಳಿ.
Serial number 83.
Lords, I'm appearing for the petition, my lord.
Yes.
I have challenged the tender notification on 2 grounds, my lord. That the minimum time prescribed under the act is not followed, and the one more ground is
Short tender, long tender.
short tender, and one more ground is they have not followed the circular issued by the Department of Personnel and Administrative Reforms.
Which is a circular?
It is at annexure A, my lords. Annexure C.
What have they not followed in that?
It
What
says
have they
that
not followed?
33% female staff has to be procured from
Which is the condition, Mr. Counsel?
tender is at annexure A, my lords.
ಅಲ್ಲಪ್ಪ ಇವಾಗ annexure C ಅಂತ ಹೇಳಿದ್ರಿ.
Annexure C circular.
Circular.
20th
Which
of
condition? You don't have the file with you.
No, it got misplaced, my lords. I had
You are
kept.
trying to argue a matter without a file.
Annexure C, it states that 33% of female staff has to be procured from belonging to SC and ST and
You
backward
won't
classes.
be able to answer any question that we ask.
Yes, we'll
you when
kindly
you
have
come.
this matter tomorrow, or
IA 1/25 is allowed, released on 26th November.
interim order may kindly be extended.
Interim order earlier granted is extended till next week. And if you don't have the file, please have the courtesy to say, I don't have the file. We'll give you time. Don't try to do this.
I apologize, my lords.
84.
I beg to appear for the petitioner in this matter, my lord.
To the respondent bank.
It's covered by case law of the Honorable Supreme Court, my lord.
What is this?
I'm
No, the vehicle has been
challenging the repossession, the manner in which my vehicle has been repossessed by the bank, my lord. The amount is less than 20 lakhs, therefore we are not before the DRT, my lord.
Repossessed under Surface Act.
No, my lord, hypothecation agreement.
Hypothecation.
There's a default of more than one installment, and so we have.
So
We issued notice. We've issued
This
all.
will not be WP, DRT, WP.
No, my lord, this is not under surface. This is under the contractual hypothecation agreement.
My lord, this is squarely covered by a judgment, my lord, of the Honorable Supreme Court.
Page?
I've produced a separate memo of citations, my lord.
When did you file that?
My lord, 27/5/2025, my lord.
Yes. Page?
My lord, I may straightaway come to page, the judgment at page 12, 2012 SCC on an Allahabad 288, my lord. Similar facts and circumstances, this has already been considered and the repossession was set aside.
Yes. What are the facts? You have not even told us the facts.
Yes, my lord. I obtained a vehicle loan for a purchase of a four-wheeler from the respondent number 1 bank, my lord. There are some defaults, my lord, but in between I had made some payments. It is clear as per the statement of accounts which I have produced as well as the bank. In the month of April 2025, my lord, my vehicle was repossessed. It is my case, the repossession was without any notice. The repossession agency came to my doorstep and seized the vehicle from my possession, my lord. And I had no prior notice or intimation of the same.
Yes.
Subsequently, I have even written to the bank and told them that I am willing to close the entire loan account, except to the extent of the repossession charges for which I am not liable, because the repossession itself has happened without process of law.
Yes.
Now, in response, my lord, the bank has filed the notices that have allegedly been issued to me, my lord, that my lord will find in their statement of
Now,
objections.
what is the state of the vehicle? With whom is the vehicle?
It's with the bank, my lord, but we have not been able to sell it because of the interim order. My lord, the dues are now mounted to 10,23,000. My lord, we have issued notices, we have sent SMSs, WhatsApp messages. They have received everything, my lord. His account has always been under substandard category.
My lord,
Right from 23.
The notices that
I've also produced.
Yes, let him complete.
My lord may see the notices that they have produced in their statement of objections, which starts at page 13, my lord. These notices have, there is no proof of service of any of these notices, my lord. It is just the bare notice itself. When it was sent, where it was sent, whether it was received or not received. In fact, the address that is mentioned in this notice, my lord, Mr. Nishant Bhaskar, Paitanpura, Kolgam, Bhagalpur. My mother resides at that address, my lord, and she has not received any of these notices. There is no proof of service at all. My only grievance is, I admit to the loan, I admit that I have to repay the loan. I am willing to repay the loan subject to reduction of these repossession charges. The manner in which the vehicle has been repossessed from me is completely contrary to law. That is my only grievance.
Counsel, your repossession charges is one small little teeny beeny bit of the amount which is due. In the last 1 year that you have been doing this, your amounts have gone up with the interest.
My lord, this was filed
You
in May.
should pay that money and taken the vehicle.
I have approached them subsequently, asking them what are the dues, my lord. Even that has not been provided. Those emails also have
They have sent it to the address given by you in the loan cum
Yes,
hypothecation
my
agreement.
lord, at page 18, that is his KYC document he submitted to the bank. In fact, my lord,
is
he
there.
only has produced one more notice, which is a sale notice, exactly same address that he has received. Lord, may kindly see the annexure one, my
Let
lord.
him complete, madam.
Yes,
Yes. Anything else?
My lord, this position is covered by case law, which is in my memo of citations at page number 12, my lord. Similar issue has been considered and the repossession was set aside.
Yes, we'll set aside the repossession, but you'll still continue to require to be make payment of the monies.
I will make payment of the money. My statement can be recorded to that effect.
Yes, what do you want to rely on in this judgment?
My lord may see page 13. May I read, my lords?
Yes.
The submission of the learned counsel for the petitioner is that the entire procedure of taking over possession of the vehicle was illegal inasmuch as due process of law has not been adopted by the respondent bank, and it has resorted to taking forcible possession of his vehicle allegedly through its recovery agent, who was neither duly nor properly appointed by the bank in terms of the guidelines issued by the RBI. The person taking possession of the vehicle was not even the agent who was appointed by the bank, so and so, my lord. Lord, may straight away come to
Yes.
Page 16, my lord. Middle of the page, my lord, it is thus clear, my lord, has this.
Yes.
Not only the recovery agent had taken the repossession in violation of the terms and conditions as laid down in the own agreement of the bank with the agency, which has not been produced, my lord. That is an agreement between the agency, J. Maheshwari agency, and the bank. That repossession agency agreement has not been produced. But the agent, Mr. So-and-so, authorized by the bank, had subdelegated its authority to another agent in gross violation of the specific prohibitory condition laid down by the bank. The apex court in the case of so-and-so, which is citation number 1, my lord, has deprecated the practice of the banks of hiring recovery agents and deputing musclemen to seize the vehicle, and has observed that banks should resort to the procedure recognized by law for taking possession of the vehicle of the borrowers, who may have committed default in payment of the installments. In this view of the matter, my lord may kindly see the petition itself. The specific governments made in the petition, none of which have been answered by the respondents, my lord. My lord may come to para 10 of the petition. Shockingly, the vehicle was, my lord has, may I read, my lord?
You have replied to all the WhatsApp messages. You said you can't pay the entire money. Then you made part payments.
Yes, my lord.
So you were aware of all these things.
As on the date the vehicle was repossessed, my lord, there was only one overdue installment.
They've been numbering the reminder messages, that also you have a problem with. You have been put on notice.
Lord, these notices are without any proof of delivery. They
What
were
is
not.
the amount due, madam, now?
Lord,
What is the amount due?
Lord, 10 crores, sorry, 10 lakhs 20, as on today, my lord, is 10 lakhs 23,000. I produced the statement of accounts, and my lord, may kindly see the last page of my statement of
What
accounts.
is the
R10.
amount that the bank is willing to close it for?
My lord, since we are already in possession of the vehicle, regularization is not possible, my lord, because we've already been in, once the vehicle is, they have
We'll
to pay the
direct the
entire
vehicle
dues.
to be released now. Then after that, what will you do?
Lord?
We'll direct the vehicle to be released because you engage that service agency.
My lord, this is, my lord, in terms of,
It is not your bank officials who has repossessed the vehicle. It's a agency through which you have gone.
no, my lord, but this agency
The
is
Supreme
just an
Court has said
outsourced, my
no,
lord, there
and
is
that
no
is not
prohibition
something
in,
which can be encouraged. So the repossession will order now.
Lord,
Hand
there is
over.
no prohibition in engaging third-party services, my lord, for the bank. And that is all. He's been put on notice. My lord, it is not a question
That is
of,
why we are asking you for how much will you settle.
I'll take instructions, my lord, on this. But then, my lord, as of now, we are not ready to regularize, unless, but he's not ready to pay any.
He has also learnt his lessons. You learn your lesson and close the matter.
I'll take instructions, my lord, may kindly have it.
Don't be on ego between both of you.
No, it's not a question of ego, my lord. But my lord, bank engages third-party experts, my lord. In this case, now a manager cannot go
You
and
know
look
the
at.
third-party expertise that they have.
But my lord, copious messages have been sent to his WhatsApp. He's aware. And my lord, may kindly see the
So long as you are
hypothecation.
doing it by yourself, it is fine. If you are going to engage goons and rowdies to do those things,
No, my
fine.
lord. No, even RBI, there is no, my lord, there is no prohibition in engaging registered organizations, my
We'll
lord, and
impose
therefore.
that prohibition for you. You can't be engaging some third party. If you want to do it
And
by,
these are, my lord.
find out by 20th. Relist on 20th.
Yes.
1 of 25 is allowed.
85.
Yes.
Kumaraswamy.
Yes.
Matters regarding tender, my lord.
Early hearing.
I'm challenging annexure E, my lord.
Huh.
I'm the successful tender on 4/1/2025, my lord.
I have not yet
Sir,
given
picture.
the instructions.
ಟೆಂಡರ್ ಅಲಾಟ್ ಆಗೋಗಿದೆಯಾ?
Yes, my lord. I am the successful tender. Next, on 1/4/1/2025, I am the successful tender. Remain subsequent on 4/1/2025, my lord, again, the respondent number 4 has issued another tender. I am challenging this because of the, kindly peruse the page number 17, my lord.
Yes. Yes.
Sorry, my lord, kind number
17
24.
ಅಲ್ಲಿ ಏನಿದೆ?
24, my lord, 24.
24.
Yes, my lord. Here, my lord, ಸಂಬಂಧಪಟ್ಟ ತಾಲೂಕು so and so ಇಲ್ಲಿ ತಾಲೂಕು ಮೀನುಗಾರಿಕಾ ಅಧಿಕಾರಿಯು
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಪ್ಪ?
ಪೇಜ್ ನಂಬರ್ 24, my lord.
24 ಅಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾ ಓದ್ತಾ
ಲಾಸ್ಟ್ ಪ್ಯಾರಾ, my lord, ಸೆಕೆಂಡ್.
ಹಾ.
ಸಂಬಂಧಪಟ್ಟ ತಾಲೂಕು ಅಂತಿದೆ. ಮೀನುಗಾರಿಕಾ ಅಧಿಕಾರಿಯು ಟೆಂಡರ್ ಕಮ್ ಹರಾಜು ಪ್ರಕಟಣೆಯನ್ನು ಪ್ರಕಟಿಸಿದ ದಿನಾಂಕದಿಂದ 15 ದಿನಗಳ ಕಾಲಾವಧಿ ನೀಡಿ ಟೆಂಡರ್ ಕಮ್ ಹರಾಜು ನಡೆಸತಕ್ಕದ್ದು. ನೀರು ತುಂಬಿದ ಒಳನಾಡು ಜಲ ಸಂಪನ್ಮೂಲಗಳ ಸರ್ವೇಕ್ಷಣೆ ನಡೆಸಿ ಅವುಗಳ ಮೀನು ಪಾಶುಹಾರ ಹಕ್ಕಿನ ವಿಲೇವಾರಿಯನ್ನು 3 ಸುತ್ತುಗಳಲ್ಲಿ ನಡೆಸತಕ್ಕದ್ದು. ಪೂರ್ಣವಾಗಿ ಅಥವಾ ಅರ್ಧಕ್ಕಿಂತ ಹೆಚ್ಚು ತುಂಬಿದ ಕೆರೆಗಳನ್ನು ಮೊದಲನೇ ಸುತ್ತಿನಲ್ಲಿ, ಅಂದರೆ ಮೀನುಗಾರಿಕೆ ಫಸಲಿ ವರ್ಷದ ಮೇ ಜೂನ್ ತಿಂಗಳಿನಲ್ಲಿ, ಎರಡನೇ ಸುತ್ತನ್ನು ಜುಲೈ ಆಗಸ್ಟ್ ತಿಂಗಳಿನಲ್ಲಿ, ಮೂರನೇ ಹಾಗೂ ಅಂತಿಮ ಸುತ್ತನ್ನು ಸೆಪ್ಟೆಂಬರ್ ಅಕ್ಟೋಬರ್ ತಿಂಗಳಲ್ಲಿ ನಡೆಸತಕ್ಕದ್ದು. ಮೂರನೇ ಸುತ್ತಿನ ನಂತರ ವಿಲೇವಾರಿಯಾಗದ ಕೆರೆಗಳ ಪಟ್ಟಿಯನ್ನು ತಯಾರು ಮಾಡಿ ವಿಲೇವಾರಿಯಾಗದ ವಿನಾಯಿತಿ ಆದೇಶವನ್ನು ಮೀನುಗಾರಿಕೆ ನಿರ್ದೇಶಕರಿಂದ ಪಡೆಯಲು ಸೂಕ್ತ ಸಮರ್ಥನೆಯೊಂದಿಗೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈ ಆದೇಶದ ಅನುಬಂಧ 7ರ ನಮೂನೆಯಲ್ಲಿ ಸಲ್ಲಿಸತಕ್ಕದ್ದು. ಎಲ್ಲಾ ಜಲಸಂಪನ್ಮೂಲಗಳ ವಿಲೇವಾರಿ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮೀನುಗಾರಿಕೆ ಫಸಲಿ ವರ್ಷ ಪ್ರಾರಂಭವಾದ 4 ತಿಂಗಳ ಒಳಗಾಗಿ, ಅಂದರೆ ಮೀನುಗಾರಿಕೆ ಫಸಲಿ ವರ್ಷದ ಅಕ್ಟೋಬರ್ ಮಾಹೆಯ ಅಂತ್ಯದೊಳಗಾಗಿ ಕಡ್ಡಾಯವಾಗಿ ಪೂರ್ಣಗೊಳಿಸತಕ್ಕದ್ದು. ಬಟ್ here, my lord, they have called tender in the month of October 2024, and I have succeeded in the month of January 4 of 2025. I have succeeded. Again, 4/1/4 April 1st of 2025, I issued notice within 3 months, my lord. You have to pay next year subscription.
You filed your objections, madam?
Yes.
We are not filed.
You want to file? You don't want to file?
I will file, my lord.
The serious.
Yes, ma'am.
And counsel, and AGS seeks for and is granted a week's time to file a statement of objections. Objections, if any, by 21st, relist on 27th. A 1 of 25 cannot be considered now since pleadings are not complete. As I 1 of 25 stands dismissed.
Number 86, Arjan, 87. S.S. Sudhindra.
For the petitioner, my lord, my senior is currently out of station. Kindly have it in the next week, my lord.
Pleadings are complete?
No, my lords. I'll file my objections in this matter as well.
And counsel for?
Respondent, my lords.
Only one respondent?
No, my lords. I'm respondent number 1.
What about the others? Notice has not been issued. What about the other respondent? Notice agilva? Issue notice to respond number 2/11, returnable by 16th December.
Please,
I 1 of 25 is allowed.
My lords,
What is this?
no, lords, I have a serious objection on the IA number 1.
Dispensation of production.
No, my lords. Dispensation. Please, please, please.
88.
The notice is to be ordered, my lords, to the respondent. The petition for mandamus. My refusal, my lords, to sell my land to a local politician. As now,
1
my
of
lords,
25 is allowed. State ella?
State, no state.
And AG
I'll pray for a
access
shorter
notice.
state, my lords. Now, dead bodies are being dumped in my property. My own private property, which, my lords, I got a gift deed from my mother. I refused to sell it, my lords, to a local politician since there was a highway project that was notified near my land. All of a sudden, my property becomes a village graveyard. Tashildar involves there. Tashildar is, my lords, interfering in my property. My lords, I have produced, my lords, the newspaper cutting also, where he is personally visited.
He accepts notice for respondent. He seeks for and is granted 1 week's time to file a statement of objection. Relist on 26th.
ಇವಾಗ ಆಗಲೇ 2 dead bodies ಅಲ್ಲಿ ಹಾಕಿದ್ರು. I have removed both the dead bodies.
A designated graveyard, it can't be used.
I filed an RTI application also.
The officer will be in trouble if it is being done. Yes.
I'm sorry.
89.
Lord,
Date given 4/12, why have you moved the matter?
Lord, state did
date
not
is
reach
given.
that day, and a date was given on 4/12. But however, the urgency is this: the petitioner has been blacklisted without hearing, and thereafter, my lords, now technical bid has also opened. Order dated 18/9/2025 may kindly be seen, my lords. This honorable court admits.
18/9/25.
Please.
There's no interim order.
There's no interim order, my lords. This was the observation
So
of this
did you
honorable court.
participate in the bid on 27/9/25?
Lords, I'm debarred from participating. I'm only seeking as an interim relief subject to the result of this petition. Let me be allowed to participate.
That bid is over now.
No, my lords.
27/9.
The first tender, my lords, that got it got recalled, and a new tender has been floated because of the fact that I quoted 1 paisa less.
Exactly 1 paisa less.
Yes, my lords. That is because of that, a stringent penalty of blacklisting has been issued. That I'm
1 paisa less than what?
At the threshold
To
amount.
tender. Threshold amount.
Threshold amount, that is 90% of the amount put to tender.
My submission. Identical matter. This code maybe is dismiss the writ petition.
With 1 paisa less. If you debar a person like that.
May request kindly. Prior, my lord, writ petition prior. Issue writ of mandamus for quashing and set aside the impugned order dated so and so passed by the annexure G. Issue writ of mandamus directing the respondent to release the forfeited amount sum of rupees so and so. Issue writ of mandamus directing the respondent to allow the petitioner to participate in the future tender. The very same writ petition, my lord, page number 3.
Yeah, but what is the quantum there? 1 paisa na?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಈಗ ಐ ಆಮ್ ರೆಫರಿಂಗ್ ಅದರಲ್ಲೂ ಕೂಡ ಲೆಸ್ಸರ್ 1 ಪೈಸಾ ಬಿಡ್ ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ 4 ಫೀಟ್ ಮಾಡಿ ಆಸ್ ಪರ್ ದಿ ಟೆಂಡರ್ ಡಾಕ್ಯುಮೆಂಟ್ 3.74 ಪ್ರಕಾರ 4 ಫೀಟ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಟೆಂಡರ್ಗೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿಲ್ಲ. ವೆರಿ ಸೇಮ್ proceedings they have challenged before this court. This honorable court is dismissed the writ petition.
So on your submission that it don't amount to be a debarment and he can participate.
He can participate. But even if it is participated, as per the class 3.74, the department can reject their application for
if they don't satisfy those requirements. And it's not a guarantee that they will get. So
and
now-
in pursuant to this, my
your
lord,
submission is that despite the rejection there, now we can participate in the next tender.
he's already participated.
And it will be
Now its
considered-
technical bid is opened. In the other 3 or 4 participants are there. In pursuant to this, my lord, the notification they have produced at
Now-
annexure.
Srinivas, now you will consider that bid on its own merits as per the tender, yours the earlier rejection.
Please, man.
Please, that would satisfy.
Indian bid.
As my lord, may one minute, my lord.
In the
My
teeth of
request
annexure
for
G,
the-
they should, in the teeth
The
of
tender
annexure G,
document in
they should
pursuant
not
to next
reject my-
third tender, my
That is your
lord.
apprehension. The categorical
Apprehension
statement
saying that maybe they are going to
they'll debar.
reject their
But
tender.
with reference to this. Now your submission is clear. Petitioner is before this court seeking for the following reliefs. Void annexure G.
One minute, my lord. The tender document I will show one clause.
Your
3.74.
submission is sufficient.
One. Page number 27, my lord. 28, it's relevant, my lord.
Yes. Retender and will be rejected.
28, the respective bidder are not allowed to participate in the retender and will be rejected. If it is
So
the
either retender or
retender,
It's a
this is a
retender.
retender.
then we'll have to decide the matter. on
No,
that.
but this
This is a
clause,
retender.
this
This is the
clause was
third
subject
time
matter
they were
of
called
challenge.
for the tender, my lord. Initially, we were called for 29 district, my lord. In the Shumagga, he is participated as a single bid. Therefore, we are recalled and fresh tender is called in second bid. Second tender, my lord, they have quoted the less than 1 paisa. Therefore,
Less by 1 paisa.
1 paisa, my lord.
Less than 1 paisa.
Less by 1 paisa, my lord. Therefore, in terms of this class 3.74, their tender document is technically we have rejected on 3.9. That proceedings they have challenged before this court. And second, after rejection, my lord, we called for the third tender. That third tender, my lord, is they have participated. They apprehension that this condition they go maybe the respondent going to be rejected.
However, my lords, that particular clause, my lords, was subject matter of challenge in the earlier round of
You
litigation.
have filed a written
During the
statement objection also, my lord.
During the pendency of this petition, annexure G was passed, hence it was rendered infructuous.
What was passed?
My lord, on the earlier round of litigation, we had challenged this clause 3.7, wherein they had sought that our tender would be rejected if the amount quoted is less than 90% of the bid amount. That clause was challenged. During the pendency of this petition, they passed annexure G. Because of this, that petition got rendered infructuous. Hence, we have filed this fresh petition, my lord.
Have you challenged the clause here?
Yes, my lord.
Lord,
Annexure R2, my lord.
That tender
R2
been recalled.
Statement objection we have filed. R2.
See, unless you challenge that clause, under which basis this
My lord,
order has been passed.
that clause, which is part of that tender, is already recalled. Now a fresh tender has been issued.
But that also has the same clause.
Same clause, my lord. There is no change.
You
Now
can't
what
say
I'm
more.
now what I'm saying is stating is, my lords, in the fresh tender, I may be permitted to participate.
No problem.
Please, my lords.
Or else we may be permitted to reject Antara. We'll allow you to participate, we'll allow them to reject. What is it that you'll get?
My lords, no hearing was afforded.
The
while
respective
rejecting.
bidders are not allowed to participate in retender and will be rejected until then.
However, this clause was subject matter of challenge in the earlier.
It's not been set aside.
No, my lords, because of the annexure G now, which was passed.
We can't say more than this. It's for you to decide what you want to.
But subject to the result of this writ petition, may be permitted to participate, my lords.
It's always
Because there is no
Somebody says he'll participate. He has no objection to allow you to participate.
But they'll
But
reject.
he wants the right to reject. He'll reject it.
Not on this ground, my lords.
Obviously on this ground. Unless you challenge, it can't help you.
Lord, now
There's no purpose
the
in that
precarious
order.
situation is I cannot challenge this clause because of the earlier tender, because now it is recalled. Now I'll make the right bid.
Decide what you want to do. We'll have it on 19th. At the request of counsel for the petition, relist on 19th.
In view of, my lord, make one submission, my lord. In view of this pending writ petition, we are not able to proceed.
Let us decide on
My lord,
19th as to what.
Please.
It will be taken with the preliminary hearing list, my lords, because there is no
Preliminary
entry.
hearing.
Much obliged.
IA2 will be considered along with the main. Yes.
Bill number 19.
I await for respondent number 6 in this matter.
For the petition, counsel will. Respondent number 2. Yes.
For filing objection, 2 weeks time may be granted, please.
Objections, pleadings are not complete? No. Nobody has filed objections?
No, sir, it's a fresh matter.
5, 2, 6, 4. IA 1 of 25 is allowed. The respective counsels for the respondents are granted 10 days time to file their respective statement of objection, which shall be filed on or before 5th December, relist on 11th December.
Voluminous.
It's a very voluminous document, at least 3 weeks of time,
That is what you are getting. 5th December is 3 weeks.
2 weeks, that would be 2 weeks.
Lekatmaka. Mathematics class.
Your Lordship, the reality is that next week.
I'm getting 3 weeks. Yeah. File it.
Would your lordship be having that on 12th?
By 5th you file it, we are having it on 11th.
Much over.
Apply.
But file it on 5th, not on 11th.
This happen. By that date, we will file it. 5th Salpa.
No, you need not worry, it will be the new year, don't worry.
No, I don't want to extend.
Not New Year, this is.
We don't want to extend that.
Looking forward to the new year now already.
91.
I appear for the impleading applicant in the first
The
two
same
cases.
crime, my lord, sir. My lord has passed an order, my lord. Same may be.
May I submit, my lord? I have filed two impleading application in 91 and 91.1.
May be allowed.
Because I was the complainant before the police. I am a private sector bank with more than 100 years of existence. Many customers pledged
IA
the
can be allowed, my lord.
No.
No objection.
IA may be allowed ಅಂತ ಇದ್ದಾರೆ ಇನ್ನೇನು ವಿಶ್ವಾಸ
Facts ಹೇಳಿದೆ ಅಷ್ಟೇ ನಾನು.
Facts
ಏನಕ್ಕೆ why do you want to come on record ಅದೇ ಹೇಳಿ
That's what I'm. Various customers pledged golds with me. And one of our employees stole the gold and pledged
Very
with
de facto compliant has become an
with
accused.
the finance
Now, that's my
company
instruction.
amounting to substantial amount.
But the same
This is a
crime, my lord
stolen
has passed
gold.
an order with another bank.
I am
Same
the
order.
complainant.
107, let them follow and
till
continue.
you take some action on this
Your lordship
we are
position
going
is
to
there.
have serious problems. It is for you to take action.
My lords gave direction to law commission. There is a reported the judgment is there.
Even a bank manager steals from the bank and pledges with them.
The complainant is also become an accused now.
Obviously,
The complainant, the
you
very
will make
complainant.
everybody an accused, you will also be an accused. You are making thieves of everybody. We have no qualms in saying that. You are tempting everybody to becoming a thief.
My lord, the same.
Because you don't ask any question from where the gold came.
That is not small.
Anybody comes
My lord,
with
they are
anything,
also
you will
facing
take
the
it.
same situation, my lord.
They-
Even
they
the
will come
impleading
and pledge-
applicant is also
listen
facing
to
same
us.
situation. Everyone faced. It's
1
there, my
crore
lord.
of rupees, you'll give 20 lakh of rupees without asking question. Then it's anyway free gold for them, stolen. They will not come. You will auction it and keep the entire money with
No,
you.
my lord, we will not auction.
How
it
they
with this
can
matter.
accept 1 kg gold from
Matter will not auction.
Place all the records.
Yes.
How many defaults have happened? Place it. We'll call upon it.
This matter, I will not auction it, my lord. We will hold it.
No, we place all those records before us. So that we can at least awaken the government which is sleeping into some action.
My lord.
Number of matters which are coming up before us on these gold loans, the theft of it, the number of thefts being registered because of these gold loans is tremendous. And it is because of no particular KYC being followed by you, no questions being asked by you, nothing. And all those KYC are blank documents, some fake documents. That address which has been given is of nobody. That's why we'll ask you these questions.
It's
Now you
5
place it.
kg gold, not less than that.
Whether it is 5 kgs or 10 grams, it doesn't matter. But the reason is that there is no particular law regulating them.
My lords
RBI
directed the
everybody
very
is-
same company. My lords directed the very
We have
same.
directed, but the state is still sleeping. State is not woken up still. This is a very serious issue.
My lords, if my lords be,
IA 2 of 25 has been filed by a bank claiming that one of its managers,
Employees.
has stolen gold from the bank and deposited it with the petitioner to avail a loan. And it is for that reason that the bank wants to come on record
I was the complainant before the major.
Since the complaint had been filed by the bank. Accepting the reason stated therein, IA 2 of 25 is allowed. The bank is brought on record as respond number 3, counsel for the petitioner to carry out necessary amendment, file amended cost title. 91.1 same order.
Same. Third, I have already
91.2 same, ella bank.
Illa bank.
Same, my lord, the same crime. My lord has already passed an order.
He made me as a party in the third writ petition. First
There
and
are
second.
a large number of matters which are coming up before this court where gold is stolen from a house.
But the division bench has also had passed some order with
Please
regarding
wait
that.
till we are
Yes,
dictating.
Yes,
Don't try to jump the thing. You will furnish us these details. Large number of matters are coming up before this court where gold is stolen, gold or gold ornaments are stolen from.
Are alleged to be
residences.
stolen, my lords. Are alleged to
You
be
want to
stolen.
dictate?
No, my lords, it's alleged to be stolen only.
We are using the word with responsibility.
But it's not, it's
We are
alleged, it's only an
using the word
allegation,
with
my lords.
responsibility, Mr. Counsel. You don't need to correct our dictation. Gold is stolen from, gold or gold ornaments are stolen from residences and pledged with gold finance companies like the petitioner. And it is on account of the KYC norms not being followed properly. The gold loan is advanced, which is subsequently defaulted, and the gold loan company auctions the gold and retains the amounts auctioned since there is no claimant. In this case is a telling case in that line of matters, inasmuch as even an employee of a bank has been tempted to do so and has stolen gold from the bank to pledge with the gold loan company since no questions are asked and no KYC norms are followed.
It is there, my lords, I'll furnish. It is there, my lords.
We have seen that.
My lords, it's there. My lords has directed to produce, I'm furnishing it, my lords.
The petitioners are called upon to place on record the details of the gold loans advanced by the petitioners for the last 3 years.
But
The
it
amount of,
runs in lakhs of crores, my lords.
we are not concerned. You are given it, no? At that time, you did not think about it.
In that case, my lords, kindly make RBI as also a party. RBI is a statutory body.
We'll make them also a party. The gold loans advanced by the petitioner, for the petitioners for the last 3 years, the number of gold loans where default has occurred, the number of gold loans which have been cleared, the on default, the amount for which the auction has taken place, and the number of gold, number of auctions where the defaulting borrower has turned up to collect the balance amounts. They said statement to be placed on record before 15th of December 2025.
But it requires some time because 3 years, my lord, it runs in voluminous documents, my lords.
By December 15th, the statement from 1st April to 15 December to be submitted. The rest of the accounts to be submitted thereafter.
My lords, may I kindly limit to Karnataka at least. Petitioners means it's a.
Karnataka is also enough. We want to wake up only the state government of Karnataka. That's enough. In the state of Karnataka. We are not waking up any other government. Only the state government is sufficient. The being of the considered opinion that this matter touches upon public interest and regulatory authority like the Reserve Bank of India would also be required to be made a party to these proceedings. Reserve Bank of India is brought on record as respond number 4. Shri Pradeep Savkar is directed to accept notice.
Five.
Shri Pradeep Savkar is directed to accept notice for respond number 4. He is called upon to make his.
But 4 is him, my lords.
Kamal, you are here. This is a very serious issue. Every day we are getting 10 to 12 matters. And every time it is 106 is shown, saying that that has to be followed. The number of thefts which are happening, we'll ask the state also to give that details. The learned AGA He is also directed to secure instructions and place on record before the 15th of December the number of thefts of gold which have been reported, the number of thefts involving the gold loan company where the gold has been pledged with the gold loan company. Anything else you will require?
Including, let them also put it. The R3 also put it, my lord. See, they are also in the same situation.
We are a scheduled bank.
They are also nothing different. They are also facing the same situation. I cannot alone be made crucified.
I have not approached the court.
They are also facing the same situation.
What if there are any other specific guidelines?
Guidelines are there. I will also put in.
Your guidelines are there. There's no, unlike other verification where the banks will visit the house and verify. Some fake Aadhaar card is given. They take that as the KYC and proceed. Bere idralli mobile number, verification, KYC registration, all those things are not mandated by you. Only one identification is mandated. They'll take that identification and finished. And then in all these matters, the owner of the gold doesn't get it. From whom the theft has happened. They say we have a security interest. That we have of course dealt with in another matter. But your regulation is bad. And this is a matter which affects a lot of people. Please look into it seriously.
He may be
You
directed.
give us those details.
Copy of the writ petitions.
I will, sir. I will, sir. Interim order
Released on
continue.
15th. Interim order earlier granted. Released on 15th for further hearing. Interim order earlier granted is extended till next date of hearing at 2:30 p.m.
Great.
92.
Challenge the tender condition, my lord, which restrained me from approaching any legal forum, my lord, any judicial forum. And my lord's
Tender condition restraining you from
approaching any court of law, my lord, for
who is this?
Stay. I have been permitted, my lord. In next week, it is the tender is likely to be opened, my lord. Without insisting this particular clause, I was permitted to participate in the tender, my lord.
Lord, why this was insisted, my lord? Only one reason, that the requirement is for the students, my lord. That may not be stalled in future
of the
because of
Contract
that.
Act applies to you. You can't do that. 92 IA 1 of 25 is allowed. Released on yavat opening?
Next week, it is likely to be.
It's on
Released on 3rd December.
20th.
3rd December.
93.
Only one lordship. The lordship has granted the interim order by permitting me to vote in the upcoming election. The condition is that, my lord, the process fees should be paid on 3/11 itself.
3/11.
We have paid on 4/11, my lord.
4/11 kottidira.
Please.
IA 1 of 25 is allowed. Learned counsel for the petitioner. IA 2 of 25 has been filed for extension of interim order on the ground that the time granted by this court for making payment of process fee, that is 3/11/25, was breached and the process fee was paid on 4/11/25. Condoning the delay in making payment of the process fee, the belated payment is accepted. Registry is directed to issue notice to respond number 5 and 6, returnable by 3/12/2025. Interim order earlier granted is extended till next date of hearing. IA 2 of 25 is allowed.
95.
ಇದು ಮತ್ತೆ ಹೇಳಲಿಲ್ಲ ನೀವು ಅಲ್ಲಿ ಕೂತ್ರೆ ಇಲ್ಲಿ ಬರ್ತೀರಾ ಅದುವರೆಗೂ
I was held up in court hall 2, so I could not appear. And for convenience, my lord, I have just made these notes.
The rest of the matters are unlikely to reach. Yes, Mr. Rana?
Not 6 only. It is a case of first hand. The petitioner is enjoying without paying license fee from last 1 year.
Memo of retirement filed by
I appear for the
106.
petitioner, my lord, I have filed an
Ms.
IA
Sumati
for
Pauline has entered appearance for the
Interim order is
petitioner.
not complied with.
Hence, the memo of retirement filed by Shri Abhijit Arnaldi is accepted, he is discharged from the matter. Process fee
Interim
kottilla.
order says they have to pay the license fee from January. They have not complied with that.
My lord, they have taken excess amount from us and we
There
have
is interim
obtained
order
the
is
charge
passed.
after the order
Very
was
well.
passed, I
You have
obtained
not
the
paid
charge.
the process
And
fee,
we have
madam.
taken-
You have not paid the process fee also.
I'll comply with all those orders. my lord.
Interim order is gone.
The interim order.
You have not complied with the office objection, process fee you don't pay. Acknowledgement for deposit amount you haven't paid. Relist on 18th and preliminary hearing. Yes. You comply with the office objections. Comply with the office objections. You comply, it will come in preliminary hearing. We are not touching the orders matters, please comply. Whoever has complied will come in. 105. Interim order extended.
My lord.
Then what is your submission? IA2 of 25 has been served. You have received. And counsel for respond number 1 and 2 confirms receipt of IA2 of 25. Hence office objection on IA2 stands complied. Date ಕೊಡಿ ಯಾವುದು?
Serial number 120.
ಯಾವುದ್ರಲ್ಲಿ? Who is, oh, that is the issue notice on IA2 of 25, written up by 17 December. ಹೇಳಿಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 4th ಇದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮುಂದೆ ಅದು. ಯಾರು who is the respondent? ಯಾವ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ? Ms. HR Renuka for respond number 1, Shriram General Insurance yaru?
B Pradeep.
B Pradeep for respond number 2, relist on 8th December.
Serial number 120.
There's not something
Serial
that
number
you-
124, my lords. This is a matter, my lords, where we've complied with the office objection. The one on maintainability, my lords, it says that
You are from Raichur, Atti Gold Mines in Dharwad, so you'll have to go to Dharwad.
my lords, the other matters were heard before the principal bench, my lords. Your
All of
lords.
them were from Raichur and Dharwad.
Yes, my lords, the similar respondents were placed.
Give the numbers, connect with so and so.
The matter has been disposed of, my lords, 19146 of 2024. His lordship has already passed in judgment. That matter was heard before the principal bench. My lords. Subsequent to that, another petition was also filed. That is also heard before the principal bench.
They have no jurisdiction. All our orders will be without value.
My lords, the purchase orders have been issued. Otherwise, liberty may be granted, my lords, I'll withdraw and file it.
After hanging for some time, the counsel for the petitioner seeks permission to withdraw the above petition with liberty to file the matter with the appropriate jurisdiction court. Reserving such liberty, petition is dismissed as withdrawn.
Serial number 120. Serial number 120, my lords. I have made a note, my lords, in the office objection with regard to office objection. 2 IAS, my lords, I have challenged, my lords, in one petition. This is, my lords, one is filed by the, my lords, claimant under section 5, and, my lords, another is filed by as, my lords.
Submission of counsel for the petitioner, office objection is overruled.
My lords, here, my lords, there may be, my lords, sir.
We will have to consider the facts. It will come up next.
Lordship, serial
This
number.
is, my lords, with regard to, my lords,
My
motor-
lordship, my lordship, serial number 109, my lordships.
Madam, it is not filed beyond the limitation period.
Limitation
6
period.
months. Yes, ma'am.
Issue notice to the respondents returnable by 8 December, though the proceeding in MVC number so and so shall go on. So and so court is restrained from passing the final award.
Your Lordship, serial number 40, Your Lordship. The issues
My Lordship,
Foreign Contribution Act, Your Lordship.
Huh?
Serial number 40, matter has been passed over, Your Lordship. Can it on 19th, Your Lordship?
40, 19th. No, we adjourned it.
my Lordship, serial number 109, my Lordship.
Yes.
My Lord, may I mention?
One
My Lord,
not.
I am
My
appearing.
Lordships, I am for the respondent number 5, my Lordships.
Yes, what is
My
the
Lordships,
submission?
may kindly direct the petitioners to serve a set of copies on us, my Lordships.
Who is for the petitioner?
Aishwarya
My
Hegde?
Lordships,
Petitioner is not here to direct. It will come up.
my Lordships, and the connected matters are coming up on 17th, my Lordships.
109. Relist on 17th. Yes.
Much
My
obliged.
Lord, may I mention? My Lord, I appear in item number 121 on behalf of the petitioner.
Yes.
My Lord, all the office objections have been complied with. The registry is pressing to file the certified copy of Annexure C. My Lord, it's a tender matter wherein the rejection reason has been cited on GEM portal. My Lord, we are not
Also,
having
for
the
the
certified
petitioner submit that Annexure C is a printout of the rejection order on the GEMS portal. Registry to verify if that be so, the office objection would stand overruled.
My Lord, your kind indulgence very much warranted in the present.
It will come in the regular course, then we'll come.
in the regular course, then we'll consider.
My lord, since serial number 98, interim orders to be extended. 98.
ಯಾರಪ್ಪ VC-ಅಲ್ಲಿ?
ಯಾರಪ್ಪ VC-ಅಲ್ಲಿ?
My lords, I appear for the petitioners in serial number 98.
ಹೇಳಿ.
Interim orders to be extended.
Awaiting service January interim
Awaiting
order.
service January.
Much obliged.
ಏನಾಗ್ತಾ ಇದೆ? ಯಾವ್ದಪ್ಪ? 100.
My lord, serial number 117, my lord, interim order has to be extended, my lord.
Yes, all interim orders will be extended.
Obliged, my lord.
Which one? Why?
17 December.
You comply with the office objection, then only. You're for the respondent. Yes.
List number 2, serial number 7.
All compilation of have been delayed by the petitioners also, and it actually makes part of the.
Yes.
These are
January to date.
orders in returning, copy of the judgment in RSA and in the same case. Then compilation of relevant laws and authorities. As per rule of 141. Then both documents have small compilation for convenience.
Yes.
You do not know the outset not want to rely on the RSA not there.
First RSA, na?
First RSA.
Yes. ILR 92.
34.
34.
Paragraph number 6. Paragraph number 5.
Yes. Yes, please.
Paragraph 5.
Yes.
At paragraph 7 of its judgment, the appellate court did accept the case of the government that the Dhamma Malay had been given to Mandega by the palace of the to gather produce of such Malay and supply to palace. After the advent of British government, the supply of cardamom was given up and assessment was levied. Retaining the proprietary right in the state, permitting the Dhamma Malay to take their own arrangement in cardamom found in their millet. It is also accepted, the finding of Lionel Davidson, that Jamam Labour do not possess proprietary. The Jamam right by virtue of the grant made by both parties. But they possess only right to cultivate the cardamom according to the indigenous law. I will so accept that proceeded to add that subsequent developments show that change of tenure has taken place. It particularly emphasized that he made the purchase the property over and paid the full assessment. For this reason, as briefed in paragraph 38 of it, Commissioner ordered transfer of Jamabandi of this Malay to the name of people and accordingly the tenure is shown as Sagumai. It has concluded that the change of tenure from Jamamalai to Sagumai as per the order of the Commissioner of Food. Reference has been made to Exhibit 1. The mutation register reflects this law. It appears that definite court derived support from what we call the order of the Commissioner changing the tenure dated further. On the face of it, this reasoning is only erroneous and unsustainable. In Exhibit P1, except mentioning Sagumalai in column number 9 relating to tenure, there is nothing to indicate that the Commissioner did make such an order. Reference to the order of Commissioner it makes the position amply clear. The Commissioner never ordered that the tenure was changed. He only stated that because Medappa had paid 170 dues from Aryappa, the sale in favor of Medappa was confirmed and Jamapati was directed to be transferred. The name of Medappa. And clerk could not satisfy me that by such an auction sale, there is an automatic change of tenure. It is also pertinent to note that Exhibit P8 refers to the order of Chief Commissioner dated to transferring the same tenure as in title of Medappa to the plaintiff's father. This is dated to 1941 column number 5. So the tenure is shown as Jamama. What is significant is that order confirming this was made by the Commissioner, whereas the transfer was made by the Chief Commissioner. In this context, section 29(1) of the regulation needs reference and not to the section 29(1). I'll skip my note here a little bit. Here, we come to paragraph number 6. Or paragraph number 5 itself, the last line, though section 110 speaks.
Yes.
How the privileges attached to the tenure being extinguished, it does not follow that the tenure is changed. By accepting such a tenure, the landlord has not accepted any privilege, but he has got only a right to raise cardamom wherever possible in Jamamalai area and nothing more. Perhaps when no longer the palace continued to hold proprietary rights, the land was assessed to land revenue. Nothing more can be inferred with regard to the assessment levied by the government or the use of the numbers. Failure to produce the sales certificate according to the AG to raise an adverse influence against the respondent plaintiff. When asked about the sales certificate, the plaintiff only stated that he does not know whether the then Commissioner of Food issued any sales certificate to Medappa. Medappa had not been examined and it cannot be made out whether he was alive at all at that time. That apart, it is pertinent to note that it cannot be made out if the plaintiff's father came in possession of the sales certificate. However, the fact that the land was sold in auction has been noted in Exhibit P1, but the sales certificate could have thrown light on the rights of Medappa acquired. In the absence of any such evidence, it is only just and proper to infer that Medappa acquired only those rights that the defaulting Aryappa had possessed and nothing more. The learned counsel for the respondent had argued that once an entry is made as Sagu in Exhibit P1, the appellants cannot go behind it and say that the tenure Jama still continued. There is a stray entry in Exhibit P1 alone in the year 1927 that the tenure was Sagumalai. There is absolutely no iota of evidence to show how this tenure was converted into Sagu when it is akin to regulatory tenure. It is patently clear that the nature of tenure of Jammamalai that the holder does not acquire any proprietary right over the soil. The mere fact that the land had been assessed to pay under section 48 does not ipso facto change the nature of the tenure, because under that section all land whatever property apply and whatever situates liable to the payment of land revenue or points of mutation decree by themselves do not confer any right. Rights must flow independently of such entries, and Supreme Court in case of Contractor clearly pointed out that mutation proceedings are not judicial proceedings but are in the nature of fiscal entries in the interest of the state for revenue collection. Mutation proceedings and orders passed by revenue authorities cannot be treated as conclusive evidence for determination of proprietary titles to immovable property. It is not shown that even for subsequent years the same tenure has continued in revenue records. In Exhibit 3.1, no doubt it has been written on the same day that the entry was a mistake. It cannot be made out as to what it refers. There is sufficient force in the argument of the respondent that such a note on the same date does not carry any weight and appears to have been made only to overcome the entry made earlier. But what is necessary to note is that there is no order of the Chief Commissioner that a tenure from Jammamalai was changed to Karnataka. Next one, para number 9 at page 41. Exhibit P3 it could be made out that things continued without any attempt on the part of either the plaintiff's father or the plaintiff to assert rights over the tree standing on the vast extent of more than the 460 acres of land till an application was made to the Deputy Commissioner Pool by the plaintiff on which an order as per Exhibit P3 dated came to be made. The main contention of the plaintiff therein was that the land had become farm and therefore the proprietary rights in the timber had passed on to the purchaser. His father, purchaser, his father. In the course of his order, the Deputy Commissioner observed the proceedings of mutation entries various bearing number 59 dated 2/9/1940 confirms that according to order the Chief Commissioner of Food, the Jammamalai of the Malay bearing 7.2 was transferred from Paisari to the name of Imam Ramapur as Jammamalai. The transfer was made as per the order of the Chief Commissioner of Food as Jammamalai and not based on the sale deed executed by Sri Firecracker Medappa, who had no title over the property. When the Malay in question was transferred to the name of from a Jammamalai, he is subject to defined rights of the Malay guard to Jammamalays. The reasoning of the Deputy Commissioner that since the Malay guards have no proprietary right for non-payment of Malay assessment, the proper course was to resume the Malay. And that is the reason the Malay question was reverted as Paisari without giving effect to the mutation proceedings number 20 dated does not appear to find support in any of the provisions of the regulation because admittedly the Malay was brought to sale for non-payment of land revenue by Karnataka. And at that point of time in the year 1927, the land was not resumed to the government. Even otherwise, there was no order of the Chief Commissioner resuming the land. Therefore, that's what ultimately the Chief Commissioner did was he transferred the Jammamalai in the name of the plaintiff's father only as Jammamalai. As the tenure stood as such through the right from inception, that is grant in favor of the original owner's higher price. The Deputy Commissioner, however, rejected the permission, pointing out that even if it was considered that Malay was sold in auction and the judgment was in favor of the cannot have right over the trees or in the valley. It is the argument of the third party that even according to the respondent, the land was worth 10 lakhs in the year 1929, when he gave evidence to the value of the trees may go to several lakhs of rupees. The respondent was attempting to get away with such valuable trees worth for a song. There appears to be sufficient force in the argument that none made any effort for nearly 50 years after the sale in the year 1927 to cut and remove trees from this land, which was granted only to cultivate cardamom as Jamamale. Perhaps in the year 1926, the plaintiff made an effort to assert certain proprietary rights which were never created in the land at any time. The trial court, having considered all aspects, the nature of the trial tenure, and the various provisions of regulation, was eminently justified in dismissing the suit. The first appellate court, without properly appreciating the scope of such provisions and regulation, and understanding the nature of the tenure and the procedure of the change in tenure reversed the decree of the trial court, which cannot sustain. Appeal, therefore, has to be allowed. Now, on the next page, appellate portion, page number 43, the last paragraph. For the reason supports that the appeal is allowed, the judgment and decree of the first appellate court decreeing the suit for the dismissal of suit are set aside and both of the trial court dismissing the suit are restored. If the respondent has failed parts of this appeal is not permitted. Now that here, the title, as far as the title is concerned, there are no proprietary rights, it's only transfer of thing, and as regards to the sale at that point of time, whatever happened, everything has been in detail discussed. No, my lord, like my lords too, the writ appeal part. The writ appeal, page number 22, not paragraph. Sorry.
So the prayer was for declaration that the revenue auction sale conferred on the auction purchase absolute rights of the scheduled property, and as successor in title, the plaintiff is the absolute owner. Trial court dismissed it, first appellate court decreed the suit. The second appeal court reversed the finding of the first appellate court, confirming the trial court's decision. Was it taken up to the Supreme Court? This is the finality of it. ನಿಮ್ ರಿಪ್ಲೈ ಇಲ್ಲ ಹೇಳಿ ಬಟ್ ಇದು ಎಷ್ಟತಿ ಹಿಂಗ್ ರಿಪ್ಲೈ ಅದು ಇದು ನಡೀತಾ ಇರೋದು ಪಿಂಗ್ ಪಾಂಗ್ ಬಾಲ್ ಯು ಆರ್ ಪ್ಲೇಯಿಂಗ್ ಟೇಬಲ್ ಟೆನ್ನಿಸ್ ಆರ್ ಟೆನ್ನಿಸ್ ಆರ್ ಶಟಲ್ ಕಾಕ್ ವಿ ಡೋಂಟ್ ನೋ it looks like now that paddle ball.
I don't think I have anything more to say.
Yes.
Page number 22, where it's appeal. But before going to this, I would want to ask that not the suit for declaration and possession was initially by the original ways for declaration and possession, which word was dismissed. Only to the extent of their right to procure or cultivate cardamom.
Continue.
There is no proprietary right. That word was set aside by the RA. Then RA was allowed. That was challenged in RSA. RSA was allowed, setting aside the RA. So, not as far as that is concerned, it is only there is no proprietary right, only right to procure cardamom was established to that effect of civil court jurisdiction. appeal. In writ appeal, not paragraph number 15, that is at page number 22.
Hmm. Yes.
21, 14 minutes over. Thus, it is evident that the respondents are no, and never in the problem. 21.
Yes.
Thereafter, the appeal preferred to the state government was allowed, and the judgment and decree passed by the trial court dismissing the suit was restored. The relevant extract reads are rendered. For the reasons aforesaid, the appeal is allowed. The judgment and decree of the first appellate court decreeing the suit of the plaintiff respondents are set aside, and those of the trial court dismissing the suit are dismissed. Thus, it is evident that the respondents have no proprietary rights in respect of the land in question and only have a right to cultivate the cardamom. However, the learned single judge that this is to the judgment in decree passed by a bench of this court in RSA number 456, that the same thing is referring back. And as the orders passed by the DC, that is point out, and the consequential order that is passed by the Tahsildar Litigation, it is pertinent to note that form number 16 is prepared under rules 40, 42, 58, 38 of the Karnataka Land Revenue Rules 1956. In form number 16, column number 9 records the name of the owner or subjector. Column number 11 records other rights and liabilities. Therefore, in the light of the judgment passed by the learned single judge in second appeal, we direct that the competent authority to record the name of the state government as owner in respect of the land clearing number 5 for Chidava village, Kapotulna, in Kodagu district, measuring 468 acres, 72 cents. And in column number 11, the entry made into the nature of the land is Jamba. And in column number 12 of the form, form 16, the rights of the respondent be to the effect that they have the right to cultivate cardamom on the land. So far as sufficient state by the learned senior counsel for the respondent to the writ appeal filed by the state is not maintainable, we find that the aforesaid submission is sans substance, as no question of title is involved in this appeal, and the question of title has already been adjudicated by the learned single judge in second appeal, where judgment and decree dated joint appeal. For yet another reason, the aforesaid contention does not deserve acceptance in view of the submission made by the learned single counsel to the respondent that the respondents are not claiming any higher rights than the one granted to them by judgment and decree passed in RSA number. In view of the proceeding analysis, the judgment passed by the learned single judge dated joint is quack, and the competent authority is directed to record the name of the state government as owner in respect of the land clearing number 0.4. The rights of the respondents be recorded to the effect that they have a right to cultivate cardamom on the land in question in the light of the judgment of this court in RSA number 0.2 dated 1991, in which the rights of the parties in respect of the land in question have been adjudicated and which has attained finality. However, the respondent's right to inherent in the land in question or to claim the right to cultivate the same on the strength of the sale deed executed in favor is kept open and it shall be open to the competent authority to determine the same in accordance with law. No, not title is clear that the land rests with the state. And here not, RSA, they are not challenging it also. They are not preferred the SLP challenging the RSA.
Yes.
And henceforth, it both attains finality. As far as the land belongs to the state. And no one will deem it as a forest. And it is a forest, a sensitive forest. So the forest authority, the department has issued a notice which is under challenge.
And now they are saying that you have to pay rental.
Yes, assessment. Every year assessment fee. That is what it is, what's the fee? It is termed as assessment fee.
For the petition.
Pension made for dignity. But as far as it is a government land, know this, that they are in possession of the land. That the cardamom is being cultivated. And apart from cardamom in the same area, they are cultivating coffee also.
We'll come to one by one.
Yes.
Once
So orders have been passed.
the title is been confirmed and their right to cultivate cardamom is confirmed.
Yes.
So that will have to continue.
Yes.
So the lease and theory,
Even the last page.
where is this lease coming from? The operative portion of your order 375 is deeming it to be a lease. There's no lease. So the forfeiture of the lease is not proper, number one. Number two, again, exercise of 64A, when they have a right to cultivate, again is not proper. Madidar nodi, 375 nodi. All of you have been arguing, but what we are asking you is focus on the order which has been passed under challenge. You are noting in para 29 at 375. First nodi, Pradeep. Under the powers vested in provision of 82 of the Forest Act, read with Rule 69, and the hereby declare lease of this said scheduled Jammu Malay lands. He has regarded it as a lease.
But I think it's a wrong terminology. You might not come to page number 379.
379.
Not the column number 7, paragraph number 7. I read part of it. The Jammu Malay land should pay an annual assessment of lease rent. So it actually, they are supposed to be termed as annual assessment.
Aito. So if it's
I know my lord would say, have you made an agreement with it?
ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅದು. If it is a annual assessment to be paid, it is only that they continue to pay, there is no default in it.
As of now, there is a default.
No, there is no default.
Yes, from the next very next election, very next election. They are asked to pay arrears in.
First you satisfy this, then we'll come to that. ನೀವು ಇದು satisfied ಅಂತಾನೆ ಹೇಳಲ್ಲ ಹೋದ್ರೆ. Section 82 and 69 to so-called terminate the lease which does not exist. It's a right which has been conferred and right which has been directed to be entered by the Commissioner of Court twice. Title is different. Under the power, tenure is different. Under the powers vested under 64A and other provisions, evict.
Yes, 64A is evict.
On what basis?
Because of violation.
What is the violation?
Here, one of the previous page, 374. Conclusion part may not be correct. The Jammu Malay was continued on whatever, the last 4-5 lines.
ಇದೆಲ್ಲ ಆಯ್ತಲ್ಲಪ್ಪ, ಇವಾಗ ನೀವು ಓದಿದ್ದನ್ನು ರಾಯಪುರಂದು ಕನ್ಫರ್ಮ್ ಆಯ್ತು ಎಂಟ್ರಿ, ಜಾನ್ದು ಕನ್ಫರ್ಮ್ ಆಯ್ತು. Coffee will come to. insofar as this one is based on that they had no right to transfer. That right to transfer virtually has been upheld in RSA. Entry has been made in favor of the Raipuram family. Raipuram family has transferred to the John family. That has been upheld in the writ appeal. Entry has been made. Entry has been upheld. Proprietary rights is with the state. That is where even this everybody is this whole thing is conservator of forest is also confused between ownership, lease, tenure, and the right. When's the tenure is fine. ಅದಕ್ಕೆ ಕಾಫಿಗೆ ಆಮೇಲೆ ಲಾಸ್ಟಲ್ಲಿ ಬರೋಣ ಅಂತ ಹೇಳಿದ್ದು because that's a very small thing. Raipuram is confirmed, John family is confirmed. So on the basis of the sale deed, there's a violation ಅಂತ ಹೇಳ್ತಾರೆ. That is the violation for 64A.
Here, violation is not just that, violation is regarding the coffee also. That is only,
Okay, ನೀವು ಕಾಫಿ ಅಂತ time to have coffee ಆಯ್ತು. But the issue would be that if it's a violation of that, there's a rectification, then you should issue a notice saying rectify it, remove it.
if there was what has been issued.
Remove the coffee ಅಂತ ಎಲ್ಲಿದೆ? Remove the coffee ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. The whole litigation has been on the misunderstanding ಬೇಡ ಅಂತ strong word ಬೇಡ. We'll only say it is the interplay or mismatch. Because there's a little difficult, the Kurg laws are a little difficult. Their tenure is different completely. Tenure is completely different. Ownership is completely different. Vesting is in different. The rights are different. ಮಧ್ಯಾಹ್ನ ಯಾವುದೋ ಹೇಳಿದ್ರು ನಾವು ಜಮಾಬಾಣೆ we have passed an order that applies to only ಜಮಾಬಾಣೆ ಅಂತ ನಿಮ್ಮ AGA doesn't apply to ಸಾಗು ಬಾಣೆ ಅಂತ. ಸಾಗು ಬಾಣೆ you don't even ಸಾಗು is proprietary right. You don't need any permission. So this whole thing is also about sagu. It is not sagu malai, it is jama malai. Jama malai is in the jama of the state. So that has continued. But where do you come up with this concept of lease? And then you come up with a concept of violation of the lease, excising 64A, and then you further you come to then you say unauthorized, recoverable as ido, and to top it all at next page 32, 5 lakh per hectare per month. What?
Arrears which is pending from 2012.
What is the basis of doing all these?
This thing is not, this has been done without serving.
No, not notice. It is about no only as to regard the coffee. Rectify in any lease. It has to be rectification followed by termination. You can't terminate a lease without giving that option. Now, coffee is the issue which will come. We'll come to him later. So these are the anything else you have on this?
No, I think the representation of that extent. And as far as this concerned, I think we should issue another notice in proper.
Insofar as violation. ಮತ್ತೆ ಇನ್ನೊಂದು 20 ವರ್ಷ. Yes, Mr. Kamal, what do you want to do about coffee? And apart from any other argument that you have?
The purpose of relying upon the
You can't. Hmm.
The suit was filed originally by a person who was not the family member of the original Malaga.
Hmm.
That original Malaga had defaulted in payment of land. The government had auctioned it.
Karyappa and.
Mr. Medappa purchased it in auction.
Hmm.
Mr. Medappa sold it to the plaintiff's father.
Hmm.
And after that, then when the plaintiff came into possession of that property and he wanted to cut trees.
In
the government
74.
demanded seigniorage and therefore he went to court and claimed. He sought for a declaration that the revenue auction sale conferred on the auction purchaser absolute right over the scheduled property. As successor in title, he is the absolute owner. That is what he claimed from. What the
Senerage ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ all these would not have happened. Pennywise, then you missed the woods for the trees and then that, no pun intended, but that is what it is. Hmm.
I think at that point of time, if the laws take by laws to the regulations include that
Hmm.
actually what the land, removed land regulations provide, that is in 106.
Yes.
Regarding on sale, regarding absolute conditions. After that order, the supervision once is sale,
valid
You
transfer.
can't argue this now with
ಇಲ್ಲ, ಇಲ್ಲ.
the two judgments that are
Please,
there.
sir. So, my lord, so therefore, this
They
ought
could
to
have
have been
argued
carried.
it. They could have taken it up to the
This
apex
ought
court.
to
They
have
did
been
not.
carried. The rule or the principle and the rule of the regulation is that if there is auction, you become absolute owner and all encumbrances are marked clean. But nonetheless, what the trial court does, my lord,
But would that take away the tenure? Gothilla. That has not been decided and does not subject matter of
there
this.
may not be the subject matter also here. What the trial court says is, in the result, the plaintiff is entitled only to a declaration that the suit scheduled properties are Jamma Malay properties. The plaintiff has not proved that the properties were Sago and he gets absolute rights over the same as sought for and therefore relief is dismissed. Plaintiff's rights over the scheduled properties or Jamma Malay properties are saved under section 202 of the Karnataka. So what happens is the plaintiff's rights as a Jamma holder are saved. So therefore today my humble submission is twofold. One is the government is the defendant in this suit. Of course, the RA completely decreed the suit. The RSA said we go back to the trial court. So this is the situation currently after the RSA. So my first submission would be that the government is bound by this as a party to this. Second thing that I would like to submit for my lord's kind consideration is that the very person who is here is not the original Malagar or his successor in interest, and he himself is a transferee, twice removed. And the defense that you being a transferee, which is banned or prohibited under the original Jamma grant,
No longer exists.
that they could not have, they did not take it there, they cannot raise it at this distance in point. The third point that I would like to make for my lord's kind consideration is that the judgment of the Commissioner of Coorg of 1906, he lays down 7 or 8 rights that are given to the Malagars. Kindly come to page 81 of the main
81 of the main or compilation?
additional one.
Compilation.
In the additional compilation.
The printed judgment.
Yes, that printed judgment, my lord.
Historically, how judgments were.
how judgments were printed. They were published, I think, more because of they were published, I think, as volumes and books like any of the reports that we have. Kindly come to page 99.
Flaps. ಅದಲ್ಲ ಕೊಡಿ. $99.
99. Para 70. To sum up my decisions on the general questions in issue in these claims, I find under section 17 of the Indian Forest Act 1878, 1, that Jamma Maleigars possess no proprietary rights in the Jamma Malays. 2, that in virtue of a grant made by the Coorg Rajas, they possess the right to cultivate cardamom therein according to indigenous method, which may be improved but not radically altered. 3, that they have no right to minor forest products therein except so far as it relates to the use of canes, is netipai, coli, leaves, creepers, and fiber for the purpose of ancillary to cardamom cultivation. That they possess no right to shoot within the Malays or the reserved forest. That they have the right to access to the Malays by defined routes as may be necessary for the purpose of connected with cultivation of cardamom. That they possess the right to fell such timber as may be necessary for preparation of cardamom plots and for the construction of buildings within the Malays, for the housing of themselves and their labor, and the storage of cardamom produce collected. That they possess the right to utilize other forest products for construction of buildings mentioned under item number 6 and to cut firewood for their own use within the Malays and for the purpose of drying cardamom on the spot. And that for themselves and their laborers, they possess the right to consume within the Malays a reasonable quantity of toddy drawn from the bane palms growing therein. And the rest are so my humble submission is that, my lords, apart from this, there are no other rights and restrictions that are available or put upon the Malaygar. And therefore, today to say that the Malaygar or their successors in interest could not transfer that interest to anybody else, my lords, is a fallacious argument according to me, my lords. Now, what my learned friend, the AG, has relied upon is a provision of the Karnataka Forest Manual. My submission in that regard is twofold, my lords. One is that is not part of a statute, neither is it a rule. It is not part of the forest rules, my lords. That for number 141, that, my lord.
But even if a transfer happens, that will be only of these 6 rights.
Only on these 6. That is why it is said by section 5 and 6 of the TP Act. They said what unless it is restricted by section 6 of the Transfer of Property Act, any property is transferable. And I have accepted that my right to use these Jamma Malay lands are restricted. That I am to use it for cultivation of naturally grown cardamom. And my submission on instructions is that as submitted by the government, I am not in cultivation of 100 acres of that land in coffee. I have submitted before, my lord, there is one portion within this whole boundary, survey number 154/2, 19 acres, 34 guntas, which is Bane lands. It is Paradina Bane lands. It is not Jamma Malay. It is also not their case that particular survey number is Jamma Malay, because from their own record, which I will show, my lords, it is not included in that. I have only, it is about 19 acres, 34 guntas. It is in that area, there is some coffee that is being grown. It is only that 19-20 acres.
And a survey would have to be done.
That survey will have to be done.
Has it been done?
That can always happen. The chief secretary went, and I don't think there was ever a notice of survey.
It was only just going and looking at. The coffee is grown on only 19 acres. We are thinking of removing those 100 acres. So it's in Bane land.
Aduna, whether
if he is agreeable for a survey,
my second submission is, my lord, this entire extent of 468 plus 19 acres is not within the forest at all. It is neither protected forest
That may
nor
not be a-
reserved forest.
That may not be an issue for this court to go into.
My lords, it is a very important issue, but one of the grounds that I have raised is that the forest department does not have the jurisdiction
You
to,
mean to say revenue department would have, not the forest department?
yes, if at all there is any such, it is not forest at all. In my humble submission, it is a misconception today to say that it is Jamma and therefore it is forest. It may have been forest many years ago as greenery in that entire district. But it is neither part of the protected forest which was stated to have declared or attempt, or first preliminary notification was made in 1899. That my lords may recollect that notification was did not see the follow-up that required to be done.
Final notification did not happen.
It did not happen. The enquiry as to what claims are there within that property did
Pradeep
not.
has not addressed arguments on that. Miss ಆಗಿರ್ಬೇಕು, we also forgot that.
And
In Kerala,
the commissioner's judgment also
this is contention. That
and-
final notification has not been issued.
and statement of objections.
Forest department will not have. ಆಗಿಲ್ಲ, how is the forest department accept? At the most, revenue department can accept. Then 64 ಅದೆಲ್ಲ ಬರದೇ ಇಲ್ಲ. You agree with that? So then no argument
Then
required.
kindly see, my lord. Para 11.
Sure, no argument anta.
My lord, because the only defense that we can put up, since it is in the heart of the forest, so we can claim it as a deemed forest. And this 64 may not come. 64, the Shogas notice which is now issued, it may not survive on the count that only the reason is that they are growing coffee. What is guaranteed under Jamma Malay privileges? They are going out of that context and growing coffee. I extend to this mean adik forest bರ್ತದೆ. Anyway, it's a revenue land ಅನ್ನೋದನ್ನ.
You can issue them a notice to remove.
Yes.
But if they want a survey to be done,
There are two more submissions.
get instructions on those two.
My lords, once it is not protected forest under the 1899 Act, kindly see the statement of objections that the government files in this matter, please.
Yeah, 10 ನಿಮಿಷ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, ಆಗೋಯ್ತು ಇದು ಒಂದೇ ಒಂದು.
If you want to take time, you take not today ಅಂತ.
11ನೇ paragraph
ಆಯ್ತು.
states objections. They categorically say we are not claiming that it is reserved forest also, because in the para 11, and there are documents to support that it is not part of the Padinalaknad Reserve Forest. It is humbly submitted that the respondents do not claim, since it has been settled in the writ petition number 4013 of 2007 by the Honorable High Court, that the lands in question are reserved forest. However, the claim made by the petitioners that the lands in question are not forest lands is refuted, as already detailed in para 3 and 4. It is proved with documentary evidence and reasoning that the lands in question are part of a legally notified protected forest. It is a fact that the third respondent in this case is not respondent. So they say that it is not reserved forest. There is the notification of 1899 which did not get followed through. The 1906 judgment of the Coorg's Commissioner of Coorg also says that protected forest action was dropped and it has no value. And then kindly see annexure G to the petition. G and H. Kindly see annexure G. It is at page 123. This is a document issued by the Deputy Conservator of Forests, and this is a statement of Jamma Malay details in Padinalaknad Reserve Forest of Virajpet Forest Division, please, my lords. This entire statement does not have these lands as being part of Jamma Malay within the reserved forest. There is a separate statement at page 131. Page 123 to 128 is the total statement of Jamma Malay within the reserve forest which do not contain these subject lands. Kindly come to page 131. This is information pertaining to Jamma Malay lands of Kodagu district.
You have taken this.
I have seen, my lord, then idralli now last second page nalli our entries are there, and in this kindly see 154/2 is not a property that is referred at all as being the Jamma Malay land.
Your second page, which are you referring to?
Of the page, page 128, I'm sorry, 130. The second statement of Jamma Malay in Kodagu district.
129/3 to so and so.
These are the 468 of Jamma Malay, which I say, yes, it is Jamma Malay. But the statement, it is outside the forest. It is within the district, yes. And in this list of survey numbers, this 154/2, this Paradinamane is not there. So therefore, my humble submission is that there is no forest land, there is neither lease, there is no grant of any lease. This is a tenure that has been subsisting since long. There is no restriction to say that you cannot transfer these limited rights of holding. And even in the Coorg regulations, my lord, holder is defined.
You showed us in that document only.
Holder is also defined, please, my lords. Holder is defined in the regulations. Signifies a person who is in possession of.
Tenure change could also be made. Sanction for sale also could be.
Yes.
At the page 123 you have shown.
Yes, please. Yes, please.
Because in the register, tenure change also is permissible.
Tenure change, they have also done that.
There is no prohibition.
Ali tenure change ಮಾಡಿದ್ದಾರೆ.
I have to consider it as on the date on which the transfer took place, not in 1969 when that 141 came in. Prior to 1969, what has happened? Prior to 1969, if you look at Annexure G, tenure change as per government order, Sagu Malaynu
ಮಾಡಿದ್ದೀರಾ. There are so many.
Not sure, you are not there at that time, whether you seen that. Accorded for sale by payment of Nazrana Malay value.
Page 123.
123.
Onwards.
Serial number 10.
Permission to grant.
So 141 cannot be applied retrospectively.
And my lord,
in fact, those issues RSA only consider Agila. They are not argued. You read somebody else was there. Those issues, if it had been considered, the judgment might have been different. It could have been taken on appeal, but now it is too late after 50 years, 40 years. Agala. So it was permitted during that time. 69, when 141 came in.
68. Not when really see the date. It is 29/5/1968.
Oh.
So 1969 onwards, 141 came.
What we are trying to say, once a Jamma Malay, always a Jamma Malay, once a mortgage, always a mortgage. That is not there.
This is an entry which has been caused prior to the act coming to force.
Yes. That is there.
No, but then they can't change it because of 202.
So by that time, Karyappa to Medappa, Medappa to Emmanuel had happened. So your conservator could not have said that all that is wrong. Applying this order, that's why we asked Mantesh to get a AG so that this is.
I think it's better, my lord, we will reconsider all these things and issue a notice. Let them come forward.
Yeah, now that you have argued, we'll deal with all
that is not
too late. I would request my lord to
in on litigation.
My last submission, my lord, would be in the decision of the Coorg commissioner. There is he holds that For physical reasons and other reasons, if cardamom cannot be grown and it is diverted for other use, that cannot be a ground to revoke that grant. But there is a possibility that out of 468 acres, there is some areas where it cannot grow. But I would just, that is just because that is a
Would have been a
consideration that has
situation
happened.
When you have to supply it to the Raja, after that, that situation is gone.
That's
All those conditions are
Please, I'm grateful.
gone. If you grow cardamom, you'll get money. If you don't, you don't
I
get
will
money.
not get.
That's all.
Correct.
There's nothing more after that. But the issue of coffee is one thing, whether it is 100 acres. That
My submission is that it is not in the part of the larger extent of 468. It is limited to this 19, 20 acres of 154/2. No. That land itself is not Jama land.
See, now that is not part of reserve.
We have produced photographs, aerial survey, all those things.
ಇಲ್ಲ ಯಾವುದು ನಮ್ಗೆ ತೋರಿಸಿಲ್ಲ.
ಏನು ಇಲ್ಲ.
Not seen it till now.
We have it.
ಇಲ್ಲ ಸರ್.
Produce ಮಾಡಿದ
ಅದು ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ ಸರ್. ಅದು ನಾವು ಇದ್ರೆ there is also, my lord.
I have gone through. I have it. I don't know why.
We haven't seen anything.
I have also produced separately the Virajpet forest manual ಕೊಟ್ಟಿದ್ವಿ. ಅದರಲ್ಲೂ ನಮ್ಮ ಈ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಏನು ಇಲ್ಲ.
It is clear that it is not forest land, not reserved forest land. Protected forest land. That notification has not attained finality. Even the protected, it's not part of the reserve. Protected forest land, the notification which had been issued has not attained finality. So if that finality it remained at only a proposal, on a proposal, can you still continue to say it is protected forest land? Can't do. If that is not the case, then the conservator of forest did not have the power to do all these. We are giving you
Virajpet
the flow of it.
Swami, Virajpet forest working plan ಇದೆ
ಇರ್ಲಿಲ್ಲ. Conservator says it's a lease when it is not a lease, contrary to the judgment that you read out today. It's not a lease. There is no lease renters to be paid, so there is no question of default. Assessment ಕೊಡ್ತಾರೆ. ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳೇ ಇಲ್ಲ. It's not my case at all. It is not their case.
What I have issued notice.
That is lease. 5 lakhs per hectare per month.
That is the notice you have issued. 5 lakhs. 5 lakhs is the amount that you arrive at in this. It's a very funny order. Very well written, but
since it was under the impression that the PIL was filed, so
that is the only pressure answer.
Sir, that
yes.
Yes, because something is filed, you have to discharge it legally. ನಾವು ಏನು ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ ಅಂತ ಸುಮ್ಮನೆ ಏನೋ ಮಾಡ್ಬಿಡ್ತೀರಾ ಹಿಂಗೆ.
The detailed report has been filed. He has personally visited the place and report has been filed. And only after that report came, it is revealed that in the forest area, in this particular area.
That is what we are shocked by. That's why we wanted you. That's exactly the reason that report of so many senior officers has been filed, which when Mr. Kamal pointed out these glaring defects, we could not expect that those senior people would be making that mistake. And Adike, we wanted you to see if there is a reserved forest, there is a protect. They'll get jurisdiction only then. They don't get a jurisdiction. The Revenue Department could have.
Even that was
forest
not
matter, the Revenue Department to forest matter, we are trying to solve that issue.
When that was not available, they get jurisdiction, the revenue get jurisdiction only in respect of the writ appeal, because where it has been declared that it's a government land. Earlier, the writ petition where they have upheld the rights of transfer also. So only the writ appeal is allowed where it is declared as a government land. Now the revenue will get. Earlier it was not so also.
It was not so also.
It was not so, because the second prayer, what in the prayer, my lord,
nobody looked into those.
Yes, the second prayer is to implement the order passed in the writ petitions or findings. So since it is set,
We have read on 400 acres of forest land. India. It is not forest land, then no worries.
I filed, my lords.
File your written
List- I
submissions.
filed the written list of dates, synopsis, and also a brief reply submission. Ella no happy with judgments I filed.
Nimdo, you want to file written submissions?
We will file, my lord. We'll file.
Havaga. Now we'll give a date until you file, we won't preserve.
My lord, within 1
The
week,
matters are.
we'll file it, all enclosing this regulations and all.
Reserve ಮಾಡ್ತೀವಿ ಆಮೇಲೆ ಹಾಕಿ
Reserve ಮಾಡ್ಬಿಡಿ ಮತ್ತೆ again.
Third, reply arguments of learned additional advocate general and rejoinder arguments of learned counsel for the petitioner. Learned counsel for the petitioner submits that he has filed his brief synopsis of arguments. Learned AGA seeks for 2 weeks' time to file his synopsis of arguments. Released on 2nd December.
Third, my lord.
Third, ಯಾರು ಡ್ರಾಫ್ಟ್ ಮಾಡೋದು ಅವರ
ನಾನೇ
ನೀವು ಅಪ್ರೂವ್ ಮಾಡ್ಬೇಕು ಫಸ್ಟ್ ಅವ್ರು ಡ್ರಾಫ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ.
It's only for filing. I'll file only for filing.
ನೀವು ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಅವ್ರು ಕೊಡ್ಬೇಕಲ್ಲ.
I'll do it.
ಆಮೇಲೆ ಅವ್ರು ಅಪ್ರೂವ್.
I'll do it.
3rd December.
Obliged.
Great.
Number
125.
Huh.
It is a parole matter.
125 parole.
5 lakhs.
Maybe is it tomorrow?
ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ ಮತ್ತೆ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ ನೀವು?
Office objection.
125 post tomorrow at top of the list.
Your lordship, 102.
Yes, 102.
2.
Ah,
It was listed for today but did not reach.
yes.
Tomorrow, top of the list, if it may be listed, your lordship.
The service is not complete. You have to make payment of process fee. Service is complete.
I had paid the process fee, your lordship.
It appears that it has not been paid. Paid whenever you can. 102, if process fee is paid, issue notice to unserved respondents, returnable by 16th December.
Okay.
ನೀವು ಟೈಪ್ ಮಾಡಿ ಹಾ ನಾಳೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಹಾ ಇಲ್ಲ ಅದು ಆಗಲ್ಲಪ್ಪ ಹಂಗೆ ಹ್ಯಾಂಡಲ್ ಬರಿ ಇಲ್ಲ ಹ್ಯಾಂಡಲ್ ಬರಿ ಅಯ್ಯೋ ಇಲ್ಲಪ್ಪ ಹಂಗೆಲ್ಲ ಇಲ್ಲ. ಈಗ ಅದನ್ನ ಮತ್ತೆ ತಂದು ಮಾಡೋದು ಯಾರಿದ್ದಾರೆ ಹೇಳಿ? ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಡೇಟ್ ಇಲ್ಲ ಇಲ್ಲ ನೋ ಈಗ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ನಾಳೆ ಹೊಸದು ಬರ್ಕೊಂಬನ್ನಿ. ಅದ್ ಬಿಟ್ಬಿಡಿ, ಅದು ನಾಳೆ ಹೊಸದು ಬರ್ಕೊಂಡು ಬೇಡ ಅದ ಹಂಗೆ ಇಟ್ಕೊಳ್ಳಿ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಲಿಸ್ಟ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ ನಿಮ್ಗೆ ಅಲ್ವಾ? ಆ ಮೆಮೋಗ ಕೊಟ್ಟಿರೋಕ್ ಮುಂಚೆ ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ಆಗ